Yeah, unfortunately, the mirror seven wins, 16 losses. But that's part of being a Mets fan. Are you a fan of the Japanese? Oh, of course you're from like sheep. Yeah, sheep protection. He was a lawyer. He's also one of the biggest. Bring me to it here. When I was here, I still know Tigers. It's such a cool experience coming to the country not being that big. So different. So good. What's your career? Where are they from? Are you from?
Good morning, Christina. Hello. I'm good. Thank you. How are you?
Moderation.
Thank you.
Yeah, I like the way it was set up. Like it's nicely switched up that way.
Great.
Yeah, not too many people.
Yes, that's
I
true.
mean, it's not
It keeps
super
it
intense,
active.
yeah, and also diversity.
Yes.
Yeah,
Yes. Thank you. Good morning, everyone. Hello. Welcome back to ADBI. I hope you are well rested for this second day of the Alternative Dispute Resolution Policy Dialogue. So yesterday, during the sessions, we focused on how to institutionalize alternative dispute resolution in the context of investment state dispute settlement. Today, we will dive into investment dispute resolution, a second macro topic of this event. Before starting, please allow me to go through some housekeeping rules again. So as we mentioned yesterday, please be sure to attend the sessions online and to remain until they end. Turn your mobiles to silent mode, and in case you need to take any calls, please take those outside. We also ask you to keep engaging actively and respectfully as yesterday, and feel free to ask any questions. You're also welcome to use the information from the discussions, but please do not disseminate them publicly or reveal who made any particular comments. Just a reminder that eating and drinking is prohibited in this room except for water. Restrooms are in the corridor, and in case you need a prayer room, please approach an ADBI staff. For those attending online, again, the information from the discussions can be used. However, please do not disseminate it publicly or reveal who made any comments. And if you have any questions, please type it in the Q&A box. The disclaimer also from yesterday applies to today. So today's agenda starts with a keynote speech by Ms. Martina Polasek. After that, we will move to session 5, titled Mediation and Investment Disputes. After that, we will move to a coffee break, and later to session 6, titled Incorporating Investment Dispute Settlement in the Regional Comprehensive Economic Partnership. After that, we'll break for lunch, and later we'll start the afternoon with a keynote speech. Session 7 after, titled Management of Arbitration and Building Sustainable ISDS Management Systems. After coffee break, we'll move to a fireside chat, Regional Economic Cooperation and Integration through ADR. And later we'll have session 8, how should ADR advance in the digital era to resolve cross-border commercial disputes? And we'll end with the closing session, from dialogue to action, advancing ADR through cooperation. And lastly, closing remarks. So we can now begin with the first keynote speech for today. Please allow me to introduce Ms. Martina Polasek, Secretary General at the International Center for Settlement of Investment Disputes. Ms. Polasek leads a team of over 70 legal, finance, and information technology specialists at the world's leading institution for resolving international investment disputes. As Vice President of the World Bank Group, she works closely with all 5 institutions of the bank. It is an honor today to have her join us online for delivering her keynote speech. Martina Polasek, if you're ready, the floor is yours.
Thank you very much for this nice introduction, and thank you very much to the ADBI for this invitation. I'm really sorry that I could not be there with you in person, but I'm delighted to get this opportunity to address you virtually, because these are themes that I deeply care about. Today's session focus on investment mediation and on strengthening of dispute management systems. And these are not abstract topics. They really go to the heart of how states investors build the trust that makes cross-border investment possible. And I wanted to share some reflections on why that matters and what ICSID is doing about it. ICSID was established within the World Bank Group and with a clear mandate, and that is to foster favorable investment climates. And that achieving that requires a dispute resolution framework that is stable, that is effective, and that is predictable, and one that gives both investors and states confidence that disputes will be resolved fairly and conclusively. And that assurance is what shapes where capital flows go. The Asia-Pacific region illustrates this point very compellingly. It remains the world's top destination for foreign direct investment, drawing over 462 billion in FDI flows in 2024 alone. 4 regional members, all ICSID member states, ranked among the top 10 FDI destinations globally, and 5 ranked among the top 10 sources of outward investment. This is a region deeply woven into global capital flows, and that integration brings both opportunity and complexity. Greater investment flows inevitably produce more disputes. And by the end of 2025, ICSID had registered nearly 1,100 arbitration and conciliation cases. 15% involved Asia-Pacific member states as respondents, and 11% involved investors from the region. The question is not whether disputes will arise, they will, but whether the frameworks to manage them are fit for purpose. And the Asia-Pacific region has really been part of shaping those frameworks. Governments across the regions have modernized in domestic legal regimes, concluded new investment agreements, and negotiated landmark instruments such as the CPTPP and the RCEP. And there is also a visible shift in how some states approach ISDS, investor-state dispute settlement. Several have terminated agreements containing arbitration provisions. Others have renegotiated them to incorporate carve-outs for public health, environmental regulation, and other sovereign interests. And of course, some have moved further toward state-to-state mechanisms and replaced ISDS. The RCEP warrants particular attention, and that's as the largest regional economic partnership in the Asia-Pacific and covering economies representing nearly 1/3 of global GDP. Its approach to ISDS carries weight that goes well beyond the region. ISDS was deferred during negotiations to avoid delaying entry into force, And states will decide by 2027 whether to include this mechanism. And that decision will be consequential beyond the region. A credible and impartial dispute resolution framework that whatever form it ultimately takes sends a signal to global capital markets, and that carries real economic value. And so how Asia Pacific resolves that question may well shape the trajectory of ISDS reform. And this brings me to the heart of my remarks, mediation, and why it deserves far more prominent place in how we think about investment dispute resolution. Asia Pacific countries have actually been at the forefront of promoting mediation in investment treaties. A 2022 study by Professor Jansen Kalamita of National University of Singapore, who I believe is there with you today, concluded that 66% of investment agreements concluded by ASEAN states include provisions for ADR, compared to just 24% globally. So, for example, there's the Australia-Indonesia CEPA that requires investors to attempt mediation before initiating arbitration. And you had the CPTPP that calls on parties to seek resolution of the dispute through consultation and negotiations, and that could involve also mediation before proceeding to arbitration. And the EU-Singapore FTA specifically allows mediation at a stage of a dispute, at any stage, not merely as a precursor to arbitration, but really to complement arbitration. So these are not marginal provisions. They reflect a genuine recognition that mediation offers something arbitration cannot: the space for parties to shape their own outcomes. There is great potential to leverage on mediation, and the ICSID caseload statistics really confirms that. More than 1/3 of cases involving ADB regional members were settled or discontinued before an award was rendered. Now, that is exactly why we decided to create a mediation framework at ICSID. And in 2022, ICSID member states adopted that in the form of formal mediation rules. And that was really a landmark development in international investment law. And these rules provide a flexible, a voluntary framework that can be initiated even without prior agreement and without requiring the state to be an ICSID member state. So mediation can be initiated based on a prior agreement, obviously, but also by a simple request for mediation that ICSID transmits to the other party under Rule 6. And even when this type of request is declined, we have frequently observed that the act of the transmission alone opens a door, and it facilitates negotiations that lead to settlement without any formal process ever beginning. Now, what makes mediation distinctive, and I would argue particularly powerful, is that it allows parties to look beyond strict legal claims. A mediator's role is not to adjudicate, but to help parties understand each other's underlying interests. Whether a party wants to preserve or exit a relationship with a state, what the political and financial constraints are on each side, what a workable solution actually looks like. The outcome is not imposed, it's negotiated. And critically, mediation is not a commitment to settle, it is a commitment to negotiate. So either party may withdraw at any time. And also, it is considerably more cost-effective than arbitration. Typical costs range between $25,000 to $100,000 per party, with an average duration of 8 months from mediator appointment to the conclusion of the mediation. So for states managing tight budget and limited legal capacity, that difference is not trivial. Now, I've heard some skepticism. It's sometimes suggested that investor-state mediation is futile, that states will not authorize settlements, and especially not in high-stakes disputes. But the evidence tells a different story, and I wanted to give you an example that is in the public domain. The case involved a commercial company incorporated in Ecuador and operated in the energy sector. For several years, it had been engaged in judicial proceedings against the Ecuadorian state. 4 cases pending before different instances of domestic judiciary, alongside a case governed by the UNCITRAL arbitration rules and alleging breaches of fair and equitable treatment and denial of justice. The investor's primary interest was straightforward: to secure payment of obligations outstanding for several years, to bring the judicial proceedings to an end, and to withdraw the notice of arbitration. So they chose to pursue mediation, not instead of the existing proceedings, but in parallel. And this allowed the parties to bundle the various disputes and address them jointly in a single coherent process. The dispute was successfully settled in the end. So this case illustrates something important. Mediation need not precede arbitration. It can be pursued alongside it at any stage of the dispute's life cycle. And it is most powerful as a tool that parties consider early and return to throughout a dispute, wherever they are in the process. So what is ICSID doing to promote mediation? Well, we're not waiting for the culture of mediation to develop on its own. We're really actively working on shifting the default. So first of all, when we register an arbitration, we now explicitly inform parties about the availability of mediation alongside arbitration proceedings. And that's key to signal that we're ready to receive mediations. The second is that we're incorporating a specific reference to mediation in procedure order number 1. That's the first substantive step in every ICSID arbitration, so that the option is raised at the outset of every case. Third, we have published a background paper and an overview of investment treaty clauses on mediation that we're currently updating, and that's on our website. We've also launched the second installment of our investment mediation webinar series last October, and we'll be continuing those series. And we're expanding our roster of investment mediators and building capacity through partnerships with local institutions and regional partners, including the ADB and ADBI. And Frauke Nitschke, who's there and our expert on mediation, can tell you more about other initiatives that we are taking. And I'm finally pleased to note that ICSID is opening an office in Singapore, and our presence there will make ICSID more visible and accessible to ADB members and better position us to support regional priorities, including on mediation. I'd like to close by emphasizing that ISDS is a young and evolving discipline, and it's adapting to shifts in global investment patterns, to legal frameworks, and to user expectations. Mediation is one of the most promising directions of that evolution, not because it replaces arbitration, but because it expands the options available. It preserves relationships, it reduces costs, and allows outcomes to be shaped by the parties themselves. We are aware of 40 investment mediations involving states across different regions and sectors. and that number will grow. The question is not whether mediation has a role in ISDS. It clearly does. But the question is how we as practitioners, policymakers, and institutions can make mediation the first instinct. ICSID is therefore very pleased to learn that ADB and ADBI are launching the ADR joint network to promote ADR across the Asia Pacific. And we would be delighted to support this initiative in the context of investor-state disputes. So thank you, and I wish you a fruitful and productive discussion today.
Thank you very much, Ms. Polasek, for this insightful keynote speech on investment mediation and highlighting the importance of solid mediation frameworks to address investment disputes. We can now move on to the first session of the day, titled Mediation in Investment Disputes. Please allow me to introduce Ms. Annette Magnusson, Principal Climate Change Counsel and ADB Investment Law and Policy Expert, who will be the moderator for this session. Ms. Magnusson's practice focuses on international climate law, international investment law, and dispute resolution, and the role of lawyers in the climate transition. Ms. Magnusson, the role is yours.
Good morning, everyone. And if I may invite my speakers and discussants to also join the floor with me so we can start our session. So as we populate the stage with the speakers and with the discussants, a few words of introduction for what we will be discussing here in this session in mediation and investment disputes. So you've heard Martina Polasek outline sort of the framework for mediation from the ICSID perspective and the value of mediation in investor-state disputes and the many benefits that can be gained from that. So we will delve a little bit more into the details of that and the experiences of investor-state mediation from the background of our experts here on stage. And what distinguishes investment mediation and perhaps when to use investment or when to use mediation in investor disputes, but also perhaps when to not use mediation in investment disputes, because as we will hear, it may not be that it is suitable in every dispute. So that is an important thing to keep in mind. So how do we integrate the use of mediations into the life cycle of the dispute in the investor-state dispute scenario? And you've heard Martina Polasek also comment on that, sort of the mediation windows and have parallel developments on that. Of course, we could have both treaty-based and contract-based investor-state disputes, and that can also lead to mediation in different contexts. All the speakers, like I said, they will address these issues from their respective experiences and their respective position and viewpoint of the world of investment-state disputes. And I have a fantastic panel that we will first hear two presentations from Mr. Jae-Sung Lee, who is the Principal Legal Officer with the UNCITRAL Secretariat in Vienna. And he will talk about the UNCITRAL view and work in this space. Next, Frauke Nitschke, who is a team leader and senior legal counsel from ICSID, and she will share specifics on the ICSID experience, building on what Martina Polasek shared, but also some of the research that she has been conducting in this space. After this, we will move into a discussion with our speakers and our discussants. And for that purpose, we have Amanda Yosani, who is a legal drafter for the Legal Bureau of the Ministry of Investment and Downstream Industry in Indonesia. Jin Shi will be joining us online. Is she online? Yes, Fantastic. So she is Deputy Secretary General of the South China Subcommission of CTAC. Shuang Weiming is CEO of Singapore International Mediation Center. Joel Lee is also joining us online. He's a professor with the National University of Singapore. And Roberto Echandi, who is a global trade specialist with the World Bank. So, as you can see, we have a very, very strong lineup and different perspectives of expertise to analyze the issue of mediation in investment disputes. So if I may first now invite Jay to give your presentation, please.
Thank you and good morning. I think you've seen me yesterday, so you probably know who I am. So I will be talking about the UNCITRAL perspective of mediations, and you've heard about the UNCITRAL mediation framework. As I mentioned yesterday, UNCITRAL has created an entire framework whereby international legal standards are available for the use of mediations. But as Martina has mentioned, even though the framework is there, you have to know that the framework is there in order to start using that framework. And this is why what we have tried to do was to build in this framework to use and possibly utilize mediations for resolving investment disputes. I have to give you a little bit of background history because if you recall, the Singapore Convention was adopted in 2018. But in 2017, another working group got a mandate to work on the field of ISDS reform. So this was not only about mediations, it was more broadly about investor-state dispute settlement reform. And one of the reform elements that was identified by the working group was to actually have a focus on investment mediation. This is why, because while the mediation was there to exist, it was underutilized, and there was a need for the working group to develop reforms in order for states to be aware and to use these mediation frameworks. Was considered that it was quite easy to undertake work on this, and that is why the two texts were adopted in 2023, which was the model provisions on mediation and also the guidelines on mediations for IIDs. Okay. So the model provisions is quite straightforward. It allows, it actually draws the attention of the disputing parties, the availability of mediations, and when that mediation would commence through invitations and a recourse and by responding to that invitations. It also provides provisions on the information to be required in an invitations, what happens with the other dispute resolution proceedings, the use of the information that's shared in the mediations in other proceedings, and the result, which is the settlement agreement. Now, this provision is supposed to be incorporated in a treaty. It could be incorporated in a contract or investment contract, or it could actually be incorporated into domestic legislation as well. It introduces the core principles of mediations. It then refers to the existing rules for mediations, which includes the UNCITRAL mediation rules, but also the ICSID mediation rules. And it also touches upon the commencement of mediations, which is a very critical time, for example, for limitation periods. The guidelines is actually a pointer whereby it can actually be used not only for investment disputes, but it can actually be used for any kind of a dispute using mediations. But it is kind of a pointer for potential users of investment in mediations. It outlines the main issues that participants should consider during and before and after mediations, but it was not intended to promote any best practices. This is because UNCITRAL is an intergovernmental body where these legal standards are negotiated, but the states wanted to be careful because if it is treated as a best practice, it then leads to expectations from investors that this is what the governments are supposed to do to engage in mediations. And this is why they wanted to make sure that it does not create any expectations on the part of the investors for mediations. And this is why we have to say that it is not intended to promote best practices here. Now, going back to the panel that we had yesterday about dispute prevention and mitigations, mediation has to be considered in the broader context of dispute mitigations and preventions. And that is why the Commission also adopted last year a toolkit on the prevention and mitigation of international disputes. This builds on the work that Roberto mentioned, or that the World Bank has conducted, not only about dispute prevention, but also about retention of investments. And in a nutshell, it is to be kind of the general guidelines on how states can make sure that grievances do not end up as disputes. You'll see that there is a long exhaustive list of practices by states to prevent and mitigate disputes, but the practices that were mentioned on yesterday were not captured, and we're hoping to update these documents as we go. Now, I'm going back to this slide because this is not the end of the story for mediations. This year, the Commission will be adopting a statute of the Advisory Center, which will also be engaged in use of mediations for parties or clients themselves. On the bottom, you'll see that we're developing procedural rules and provisions on cross-cutting issues. This year, we'll be adopting the supplementary provisions on the procedure, IID proceedings, but next year, what's going to come is there will be another set of provisions that will be considered by the working group and then eventually by the Commission on amicable settlement, which includes a provision on cooling off periods and the effect of mediations on limitations period. I'm sharing this because it's still being discussed, but this is where it all comes into the picture. There will be another provisions on the exhaustion of, or the possibility to use local remedies, whereas some of the states wanted to have an exhaustion of local remedies, and this will probably need to be considered in the broader context of dispute prevention and the use of mediation as well. Another linkage, as mentioned, we have 3,000 existing treaties, and many of them do not really refer to mediations. So what we're foreseeing is that we are negotiating a multilateral instrument on ISDS reform, which would make it possible to integrate or incorporate the model provisions that I mentioned on mediation into existing treaties through an amendment procedure. We had done that through the transparency rules and the Mauritius conventions. But as I mentioned, there were a number of different reform elements that UNCITRAL is negotiating. And for states that want to incorporate these reforms into their existing treaties, there has to be a mechanism to do so. So one of the provisions there, as you see on Protocol B, of course, this is still being negotiated, is the UNCITRAL model provisions on mediations. And by a state becoming a party to the multilateral instrument and then opting into this model provisions, they will be incorporating this availability of mediations into their existing treaties, as long as there's a match with the other state party to that treaty. So this is what's being currently discussed at UNCITRAL. I know that we'll be having a discussions about mandatory mediations, but I'll actually touch upon that later, because in the UNCITRAL working group, there was the discussions about whether mediation should be mandatory, but in the end, it was decided that it should be voluntary, mainly because of the we discussed the pros and cons of mandatory mediations, but it was considered that at this point, it is more important to highlight the availability of mediations rather than imposing a hard restriction or imposing mediations for the parties. I think that's it for my presentation. Thank you.
Thank you so much. It's an impressive list of initiatives that and the work streams at the UNCITRAL currently. A lot of experience being poured into that work from different states having experience of mediation. And from that, we move into the research, Frauke, and the ICSID experience of investor-state mediation. The floor is yours.
I'll wait for the slide. So thank you for ADB and ADBI for having us here at ICSID, and for the second time to have that opportunity to build really on what we discussed last year. And I can see that it seemingly moves into a network because many familiar faces are here today. So let me start looking a little bit building on what Jay shared with us on the working group 3. And I just want to take 30 seconds for us to find our grounding and a foundation in what is it that we think of mediation. and that it's a flexible process. It's a dialogue, facilitated dialogue, where the parties remain in control of the outcome with the support of a third-party neutral one or two mediators. This is important, and I will get back to this, as we were discussing of mediation as a faster and cheaper way to resolve dispute. That cuts it short. It's a fundamentally different process. It is different. It's not a mini arbitration, and in the ICSID context, there's differences to conciliation that we are happy to discuss in the break. Conciliation is a little bit more formal, sets up a three-member not a tribunal, but a commission. So in that sense, under the ICSID rules, there are really differences between mediation and conciliation. Mandatory mediation, Jay touched upon it. I thought the discussions at Working Group 3 were really instructive. Should there be mandatory mediation? And I just want to make clear, mandatory mediation means the entry into the process is mandated. It is not a mandate to settle. And that is a fundamental difference. That even if mediation is mandated, unless you are under the IBA rules that require you to be in there until the first meeting, you can leave the mediation at any time. And so there are pros and cons that you see on the slide, and we could probably touch upon in a later discussion. We talked about mediation windows. Roberto picked up on it yesterday already. Martina talked about it, and you see a little version, a slightly different layout, but the content is similar to what Roberto showed yesterday, the life cycle of an investment dispute. And if we see mediation as a facilitated negotiation form, it's available even at the outset of the discussion of an investment, along operations, before arbitrations, alongside arbitration, and even after an award is rendered. I think this is really important for a policy perspective, how mediation can be included. It's not necessarily just a pre-arbitration step as it was originally often perceived. Now, jumping to the empirical data, Annette mentioned the research. There are now over 45 investment mediations that we know of, real investment mediations with a state party. It involves juridical and natural persons. So it's not just a company and a state issue, but also natural persons involved. And it's not only a regional phenomenon, what sometimes has been stated in literature. It's not something that's only in Asia or only in Africa, but it is across the globe. The industry sector, sometimes you will hear, oh, there are certain industry sectors that are primarily suited for mediation, and the data shows us otherwise. It does not depend on the industry sector. You have a range of sectors on the slide where mediation has happened in practice. The consent, mediation needs consent. The parties need to agree to mediate. And this has often been found in practice in ad hoc agreements and in contractual provisions. Sometimes there are mediations alongside a bilateral investment treaty claim, but the mediation as such is still was still on the basis of an ad hoc agreement. And the empirical data confirms the slide we just looked at, which is that mediation can happen at any stage of the life of an investment dispute. Duration and cost, something that we talked about yesterday, in mediation looks different from arbitration. The majority of mediations is around 8 months, and it costs between $25,000 and $100,000 per party, which is different from the cost for a full arbitration and in the investment context. What does the empirical data show us? How do settlements actually look in the investment context? And you have examples on the slide. It is not only payment of sums of money. That is what the law allows under the treaties, payment of compensation, payment of damages, but the empirical data on settlement looks different. And that is because the parties remain in control of the outcome. How do they want to shape the post-dispute future? And you see it on the slide that also the instruments, how settlements in investor-state disputes are recorded, are not necessarily a settlement agreement, but they may be incorporated in an award if you have it alongside an arbitration. But you may also need implementation by law, my home state of Germany had an investment dispute. In order to implement the settlement agreement, a law needed to be passed by parliament. There are different aspects that relate to that. Enforcement, confidentiality, aspects we could perhaps explore later or in a different panel. Martina gave you a bit of an overview of examples, and here is 2 episodes that we had in our investment mediation webinar series that actually feature a debrief of 2 investment mediations that happened on different continents. One that Martina talked about with Ecuador. The webinar features the Deputy Attorney General of Ecuador talking about the benefits for the state of mediating a dispute, being clear that not every dispute is prone for mediation, but it has significant benefits for the states in those cases where it does. The other one was an example in Lithuania, the biggest construction project in Lithuania with multilateral banks financing it, had an issue about contractual delays. The parties had discussed, tried to negotiate it, couldn't find a resolution. And as you will hear if you listen to the webinar, the investor said, well, we actually started it because we wanted to stop the limitation and prescription period. We were not really convinced that this would work, but we thought we'd try. They ended up with a settlement agreement. And what's interesting in that is that there were 2 components to the project. Both had the same problem. Both had the issues of delays, contractual issues with the state. One was settled by mediation and the project continued. And the other one, you saw the impact of arbitration on the ground, on the project. And that was very different benefits for the parties involved. What does this mean? In the context of the work for UNCITRAL Working Group 3, we provided UNCITRAL with our treaty analysis of mediation provisions. And you see on the slide different categories of treaty provisions that I will not go into, but we are updating it currently. And we see that there are more and more treaty provisions providing for mediation what we call open use, not only pre-arbitration, but alongside arbitration as well. And in certain treaties like the Canada-Ukraine FTA, there is specific mentioning of mediation for SMEs. So we see more sophistication in the development of clauses. And Annette mentioned it at the outset of the panel. How do you assess the suitability? I told you before, it's not just one particular sector or one region. How do I know whether this actually could work in this instance? And the background paper, as well as the guidelines on mediation for UNCITRAL, provide a certain list of aspects that you could consider when determining whether mediation is the right process. And I think that's where we need to get to. We need to have a conscious choice of finding the right process for the problem. And on the slide, you have certain aspects. Is there a willingness to negotiate, or do you actually want a ruling by a tribunal, as perhaps in the WTO context we discussed yesterday? And is there a desire to have the control over the outcome? Or is it that you would rather have it that somebody else decides the issue for political reasons? And then we discussed yesterday already, how can I structure the mediation process to spread the political responsibility? And that's where we need to think about investment mediation fundamentally different from commercial mediation. And what's important, and we will touch upon in a different session, assessment of whether you want to settle, assessment of whether you want to use mediation needs to be done at different points in time. So not only before an arbitration, but also alongside arbitration. And Martina identified the various initiatives to support states and investors to use mediation and implement it in practice. Thank you very much. That's it.
Thank you very much, Frauke. So now we have set the scene. And as you can see from Frauke's list here, there are, and also from what you heard before, there are lots of resources for parties involved in investor-state disputes to help assess whether mediation should be an option in this particular instance and what would be a good time for it. But still, a very common description, and we heard it also today, when it comes to mediation, is that it's underutilized. So one wonder why that is. And of course, one of the good argument or one driver to use something is if you hear the success stories. So now we will see what are the success stories, building on what we have heard so far. And I will invite Wei Ming to share some of his success stories. Before he does, I will say that my very brief introductions of our panel here today, of course, does not do justice to their long experience in this space. So please use the QR code in the program to learn more about the expertise of all of my speakers up here. Wei Ming.
Yes, thank you. It's wonderful to be back here in Tokyo. Thanks to ADBI and ADB for the invitation. And I think I can see this is growing from strength to strength. So Byungsik, well done. With regard to the success stories of these mediations, let me just first of all say that SIMC does not just focus on investor-state mediations. Of course, we are a commercial, not-for-profit organization, and we do mostly commercial mediations. So we have about 500 filings to date. And out of that, there is actually a very large percentage of state-owned enterprises that come to SIMC for mediation. And the reason we believe is because SIMC, being an institution, is probably better placed than some of the ad hoc mediations and other arrangements for governments to put their trust, state-owned enterprises to put their trust in SIMC to host these mediations. Out of the 500 over, we have several mediations that involve the governments themselves, right? So when we talk about success stories, I have in mind a few, and I think the first that I want to mention, which is probably the most unusual that I've come across, is a dispute relating to military assets. And if you think about military assets, it's probably one of the most confidential type of transaction because it involves the Ministry of Defense, it involves suppliers, it involves a whole, supply chain, technology, et cetera. The country's national secrets are all considered. So in this particular mediation, we're very glad that we were able to host that. And what is important in this is, when you talk about some of the learnings from that, is that the center must have enough experienced mediators that is able to mediate such sensitive matters. So when it comes to the long experience of the mediator, the nationality is very important. The parties did not choose a mediator that's from any of the countries that are involved. So some of the countries where they are not involved in these type of sort of military sales are probably best suited for these type of mediations. On top of that, this particular mediation, I saw from Franca's report there that some of the mediations took 2 years. This particular mediation, unlike our commercial mediation, which is probably why Franca says it's fundamentally different, is that our commercial mediations probably take 1 to 3 days. The very complex ones will take 2 to 3 months. This mediation took more than a year. And you do need a mediator who is able to do the long haul, that really to sustain that effort to talk to both sides regularly and persistently, doggedly, to ensure that they are kept up to date on the next, to move the mediation along. So we kept in touch with this mediator throughout that process. And it was only after 1 year that we sat down and we said, oh, it was finally settled. And it took many iterations on both sides. And of course, on the government side, it's even more complex because of the nature of the dispute. So one of the important thing is about how you structure the mediation is going to be so important. and who you bring onto the day of the mediation and throughout that process is important. There's another one, and many of the state, those mediations that involve the state actually involve infrastructure projects, whether it's mining, whether it's energy. We had one where the Attorney General of the country actually flew in. And this is another learning point that I want to just highlight. There is nothing like experiencing a workshop of mediation for 2 days. It doesn't have to be the 5-day accreditation, but a 2-day mediation. And we were fortunate enough to train, to have a workshop with this Attorney General before the actual dispute itself. So when the dispute arose, having had the 2-day training with SIMC, he was actually very comfortable to come to SIMC physically to have the mediation. So one of the learning that we have, and I guess it's a message for all of us, we talk about training of mediators, we talk about training of lawyers, we talk about training of judges. It's so important to also train the decision makers of these ISDS disputes so that they know exactly what is happening. So that's the second learning on who is supposed to be there. The third one I would say is really on a part of, and I know there are many countries here that are represented. I want to encourage you that Singapore is a tiny little country, if you've ever been there. And many of us here are from relatively small countries, where I can say for mediation, small is beautiful. Small is beautiful because you are a center in a country where you're not probably involved in a lot of this ISDS type of dispute. That makes you unique within that region to host the mediation because you're neutral, because you're not invested yourselves. So you should have strong centers that have the ability, have the mediators, have the processors, and processors, again, speaking as SIMC, I cannot underestimate the importance of cybersecurity, right? To make sure that your system is intact, to make sure you have the relevant insurance protection, et cetera, et cetera. We can talk about that a lot more, but the preparation is really critical. Thank you.
Thank you so much. And I think this really highlights the importance of people in the process. You talked about sort of the right mediator, but also the importance of the buy-in in the organization and understanding the process at the right level in the organization, including in the parties involved. And I think this is really an important key. Professor Lee, may I invite you to build upon what we have just heard? I know you have been giving some thought to additional issues when it comes to sort of the use of investor-state mediation and particular challenges and how they can be overcome. Professor Lee?
Thank you. Good morning, everyone. Greetings from Singapore. I'm sorry that I cannot be there with you in person. My thanks to ADB for inviting me to be part of this very august conversation. I want to speak to two things in the time that I have. Very briefly on sort of when might it be suitable for mediation to be used in investment disputes, and then the second on the matter of what changes or what thoughts, what issues we might want to think about when designing a process for international mediation, specifically in investment disputes. On the first, in relation to mediation windows or when is something suitable for mediation, I loved what Ms. Frake-Nitsche's list is. That is a very good list because it helps us make an assessment of suitability. To that, I would only add potentially looking at one other factor, which is whether there is a manageable power asymmetry. And what that basically means is sometimes when you have an investor-state dispute, there is a perceived or an actual power asymmetry, and some folks may feel very uncomfortable in going into a mediation if they perceive that their counterpart is overwhelmingly powerful, for example, right? The other thing I would add to sort of those factors or the idea of those factors is actually, rather than just looking at whether the factors exist or not, to also have a diagnostic framework. And what that means is for each of those factors to ask these questions: what is present? What is missing? And if it is missing, what can we do to introduce or develop that condition such that the ground becomes riper for mediation? Now, it's not always possible. Sometimes we can actually physically do something about it, but sometimes it really needs to be supplied by time and context, right? So that it's not something that's always within our control, but something to think about. So rather than saying, oh no, these factors don't exist, and therefore we can't do anything about it, we can't go to mediation, some things may be within our influence to actually get it to happen. So that's the first thing I want to say, and I'll say no more about that. Frauke's list is very impressive and very, very helpful. The second thing I would like to say is to address the question, what needs to change in ISDS mediation design? And I think the pitfall is a lot of people seem to think that we can actually take mediation as is practice in the commercial world, whatever that means, and somehow transplant it over to the ISDS context. And it's just not suitable. The climate is different, the context is different, the soil is different, the conditions are different. So I like to maybe raise 5 very quick ideas to think about when designing ISDS processes. First, I think is we have to pay a lot more attention to pre-mediation. What my friend Wee Ming just said a little bit earlier is that you might have to spend up to a year talking with stakeholders, trying to get them to think about, bring them to the table, and so on and so forth. There needs probably be a lot more mediation advocacy in this context, developing trust even before mediation is actually formally agreed to. The second, of course, is mediator role and selection. This I will say very little about, except for the fact that obviously ISDS mediators will need to have the credibility and the trust and the faith of international parties, including states. The third is process structure. I don't think we can import really simply, the usual joint sessions, private sessions, that kind of things that we might use in a commercial context. But in international context, there's probably going to need to be more multilateral, multi-track, multi-level conversations going on, and to explicitly integrate public interests and policy rationale into the conversation and the agenda, okay? Because the audience is quite a slightly different one, in fact, vastly different one. The fourth thing would be transparency protocols. And this is one of the things that actually seem to have create a tension between confidentiality, which is sort of a big thing in mediation, and the need for transparency, because this is the actions of a state as well as essentially investment monies. People will think confidentiality is actually a cover up, trying to cover something up. There's some deceit going on, or there's something wrong going on. But of course, not everything can be transparent, because otherwise, certain confidential information will never come out. We may never resolve. So some kind of balance between those two need to be thought through, and with sort of perhaps a graduated disclosure framework and public accountability measures where it's appropriate. The final thing will be settlement and follow-up. The notion that you may, of course, have to have ratification, domestic regulatory compliance, potentially even third-party monitoring to ensure that things are running smoothly. Okay, maybe monitoring, not the best word, but essentially making sure that what's been agreed to is running along smoothly. We check in by ICSID from time to time, or something like that. Okay, so I don't want to go beyond my time, but I hope those thoughts have been helpful. Thank you very much.
Thank you very much. This is very interesting. I think what we have heard so far from all of our speakers is that you have a very strong message on, again, the importance of recognizing that disputes involving states and governments are fundamentally different from commercial disputes. However, there could be things that you can learn, but you need to be aware of this. And for example, when it comes to issues like transparency and confidentiality, but also the appointment of the mediators and other things. So we have mentioned mediation windows from time to time throughout our talk here today. And I would like to invite Ms. Yin Shi from CTAC to share the CTAC experience of working with MedArb, which is a unique CTAC feature. And also, what is the experience of CTAC when it comes to identifying the mediation windows and working with mediation? Ms. Yin Shi?
Thanks very much for ADB and ADBI's invitation. I'm stepping in for Ms. Lu Fei, and also best regards from her. China International Economic and Trade Arbitration Commission, known as CTAC, has the investment arbitration rules. While we don't have a real case applying the rules, but we do have a lot of inbound investment from which disputes arise between the parties, investor, and the different levels of provincial governments. And also from commercial arbitration perspective, we've had much experience on MedUp. About 20% of all of the commercial arbitration cases in CTAC have been settled through mediation. Well, the mediation in CTAC is a bit different from widely known, like we call Western style. But I will start from the history of mediation in China so that you can understand why so many windows open throughout the arbitration procedure. Mediation is an ancient creation of Chinese civilization as early as the Zhou dynasty, more than 3,000 years ago. The state created an official position called Tiaoren, literally the mediator. The mediator's duty was to resolve disputes through persuasion and reconciliation. By the Tang and Song dynasties, more than 1,000 years ago, mediation had become the preferred method for settling civil disputes. Officials were expected to educate the parties, awaken their moral conscience, and restore relationships. Why this emphasis on mediation? Because ancient Chinese legal thought cherished the idea of no litigation. It means almost all civil disputes were encouraged to end through mediation, not litigation. The goal was not merely to decide who was wrong or right or wrong, but repair broken relationships and restore social harmony. The ancient tradition gave rise to what scholars now call the Oriental experience, a distinctive model where the mediator acts not as a judge, but as a facilitator or a helper to resolve disputes. And remarkably, this classic wisdom has survived and evolved into the modern mediation system as we see in China today. So CTAC is a big, has a lot of practice in mediation. Back in the 1980s, CTAC pioneered what is now pioneered in his arbitration rules in 1988, saying that the Arbitration Commission, that's CTAC, and the Arbitration Tribunal may conduct mediation of the cases under their cognizance. If a settlement agreement was reached, the tribunal would issue an award based on that agreement. And fast forward to today, CTAC's current arbitration rules contain very detailed provisions on mediation based on voluntariness, mutual consent of both parties, and leading to enforceable outcomes. It really combines the flexibility of mediation and the enforceability of arbitration. And the arbitrator can be the mediator. It might be different from what most people think about mediation, but from the history, we know that actually arbitrator in the process of mediation is seen as more of a helper to help the parties to solve problems instead of a judge to judge right and wrong. So that's why we naturally the arbitrator naturally changes hat to a mediator. In Article 47 under CTAC rules, the arbitral tribunal may conciliate the dispute during the proceedings, but only with the consent of both parties. We do that in the condition that both parties agree. We would ask parties whether they agree or not before the hearing or during the oral hearing. So the mediation windows actually open before, during, and after the oral hearings during the whole arbitration process. Even after the oral hearing, the arbitrator would encourage the parties to meet, to conciliate, to talk to each other, to change phone numbers, and to settle. So that's about the windows of mediation, and I will talk about the mediation regulation and also CTAC's mediation center later. Thanks.
Thank you very much. I think this is a very interesting illustration of how the culture of mediation actually will, in a certain jurisdiction, and the experience of China here has influenced also the size of the window. And when you put in the window, you know, it can appear in many different parts of the procedure. So very enlightening. So thank you very much for sharing that experience. Before we move into our next main topic for our conversation, do we have any immediate observations or reflections from what we have heard? Robert?
Yes, I would like to emphasize this window logic and the two reflections that were both the presenters made in the morning. Let me ask you the question to the audience. All of you have, I mean, if we say that FDI is a relationship between the state and the investor, right? And if we say that we want to preserve relationships, why? Because FDI is good, because we want to implement agreements, et cetera, et cetera, et cetera. And if we see that most of the time, you ask the question, why mediation is not mainstreamed, okay? So let's make the parallel that I made on the analogy yesterday, that basically in human relationships, let me ask you, any of you, if you have a problem with your husband or with your wife, would you go to a divorce lawyer immediately? No, you don't. There's a time. You try to solve the problem yourself. Then if it doesn't work, you go hopefully to a therapist, and then you go to a divorce. Well, why are we wondering why no one goes to therapist in the divorce stage? Because that's what ISDS is. When you escalated a dispute already, you're with a divorce lawyer. Divorce lawyers are trained to solve the problem of the divorce. They have to distribute gains and alimony and fix the damage. So we cannot be surprised. Maybe we're asking divorce lawyers to be therapists. I think that the key point that Martina and Frauke said, mediation is about preserving relationships. It's about how do we make it happen. So the window on when that happened has to be well before.
Thank you. I think it's fascinating how marriages can be used to illustrate all sorts of things in the legal life. Very good. Frauke, go ahead.
Yeah, I think that is a good metaphor for Roberto. And I think this is also part of why certain communities, the arbitration community, has less data, because the mediations may not happen at that stage, but earlier, and you need to talk to the mediators who actually have the data. I thought the discussion was really interesting. I have a couple of points on our experience with the arbitrator-mediator model that we just heard from CTAC. In 1985, ICSID thought that we would be really innovative by introducing a rule, the pre-hearing conference at the time AR 21-2, that allowed the president of the tribunal to meet the parties after the submissions were filed with a view for settlement and to have a conversation about settlement. The idea sounds good. It was only invoked once in practice, and it miserably failed in the investment context. Part of this was because the role is different. The parties have pled the case on the basis of the law, on evidence, on fact, but not on priorities and interests. And so that asymmetry didn't lend itself. And the arbitrator was in the position to decide at the end. So the parties were not really willing to come forward with their interest, because in the end, there would be a different outcome. So that provision has been entirely removed in the investment context. I also think in terms of like challenges of arbitrators, we have a clear rule in the mediation and arbitration provision that you cannot have the roles overlap between mediator and arbitrator unless the parties and the mediator agree. Like if you really want it, you can.
This is where maybe the issue of culture comes in, right? And expectation in that particular context. And in the ISDS ICSID context, it was completely different than the Chinese context. Yeah.
Exactly right. It can come in different scenarios. It plays out. The power imbalance, I thought Professor Lee brought up a really good point, and I would love to hear more and be in touch about diagnostic tools. I think that can only help us. And the power imbalance, I believe Anna Howard, who we heard from yesterday, did something in her research on that negotiation and mediation, if you have the power imbalance, let's go back to our ISDS point first. You know, we need to be really careful about what is the power imbalance. I have seen states who really, really, really want to keep this investor there. So the power imbalance was not the state in power, but the investor in power. So we need to watch out that we don't have an underlying assumption that the power is with the state. And when you compare it, and that's, I think, where Anna's research came in, the power imbalance, if you assume there is one, might be much better addressed with the mediator in the room, who can help facilitate this perception. The one side coming with 25 people, the other one is a natural person coming in with one support agent or something. So I think there we may want to think a little bit more. And what we said with the duration of mediations, you know, the aspect that we also know from empirical data, it's a setup at the beginning, who all needs to be involved. We talked yesterday about the mediation within government agencies that may need to happen to identify how the process is set up. And then the sign off of the agreement at the end. That takes time to get the different entities involved. And from data, last point, the settlement aspect, we have looked at 195 settlements. And it seems like when you have the settlement with the state, it's usually complied with. We had only 3 where there was a dispute arising out of the settlement agreement. So the monitoring, I find an interesting idea. From the data, we have not seen the need for it.
So as you hear, so many threads, and we can disappear in many different directions here. So I hope you will grab Frauke after we finish the session to discuss some of the points that she is raising. Thank you for that. I want to move on to talk about capacity building. We have in different forms talked about sort of the value of maybe using mediation more and changing awareness on how mediation can be used in different ways. And one of them, of course, is to working with governments and large stakeholders for institutional capacity building. So I would like to invite Amanda and see how the government of Indonesia is working with capacity building, or what is the view of your government of capacity building in this space, and what measures can be done.
Thank you, Annette. It's such an honor to be seated here between amazing speakers and a wonderful moderator. Thank you so much. With regard to the capacity building, as government officials, I feel the urge to and feel the need to have one, because I believe that mediation to work in investment dispute, it is not enough to have the rules itself. We also need people who know how to use them. Indonesia already has access to international frameworks such as ICSID or UNCITRAL, which are very useful because they provide structures, procedures, neutrality, and international credibility. But I believe the main gap is not the framework, it is the capacity at the national level. I hope that international organizations can support training for government officials, also simulation exercises and guidance on how to use mediation strategically. as Wei Ming said before, but not only government officials in central government, but we also need it in the regional governments, not only judges, but also the Attorney General, because the Attorney General will be or usually become the representative of the states in the event of ISDS or SSDS. Capacity buildings that needed should not only focus on disputes that have already escalated, but it also strengthen early dialogue mechanisms, grievance handling systems, as we talked about yesterday, and also about the coordination across governments. I think it's very important because many investment disputes do not start as legal claims per se, but they start as administrative problems. So I think we need a same level of understanding and also same level of capacity in the national and also in the regional level. As someone said yesterday, maybe effective mediation is not just about resolving disputes. It's about preventing them from happening at all. Thank you so much.
Thank you. I think that is a very wise reflection, that it's about preventing them from happening in the first place, right? So it's all about people, as we have heard, the marriage analogy. So it's sort of how to get along, also in a commercial context. And the capacity building, you mentioned national, regional level, but also coherence across ministries. So it's a complex exercise, one could say. Roberto, you have experience from this, from the World Bank perspective. Can you share some of your experience?
Yes, in the World Bank, as I told you yesterday, I presented research, but also we did several pilots. And we helped countries, I think, to generate what is the minimum infrastructure of coordination that you need among yourselves in order to be able to react to an investment problem before it escalates. And I emphasize this because remember that the states are multiple agencies. And the key point that we found is that every time we did capacity building, we would find people like you who understand all these things very well. I don't have to convince anybody in this room about the importance of investment, about the importance of IIAs. The question is that you are not alone in your country, in governments. You have to work with other agencies, and those other agencies are usually the ones that generate trouble. So the key is how we set up this infrastructure, and we set up these investment grievance mechanisms, right? And I think we had been, we had around 10 pilots and some successful. I mean, we are measuring the investment retained and the jobs retained. Why? Because that's the idea, to generate, to get political support from the presidents. We have to make this politically attractive. We have to change from divorces to having good relationships. And let me tell you, there's a lot of you spend a lot of money in investment promotion. There's no better promotion than having investors talking about problems rightly solved in your countries. And it's even cheaper too. So on the CMMs, we have done it, around 10. We can continue. We are already going. Mind you, going back to mediation, we have found some lessons in our work. And the lessons that we have found is that, yes, sometimes we can generate these mechanisms, and we go, and a lot of the investment promotion agencies will be very involved, and the Attorney General will be involved, and all of these will be involved in different means. There's still a need to have almost kind of a fighter squad from outside to help and facilitate that negotiation, not between the investor and the government, paradoxically, but between the agencies of the government. So that's where the negotiation that we have seen is most important. And that's where mediators are needed. And yet, no one talks about it. And we don't have it in our area. And mediation could be there. And that's probably the most important. So I would think that some institutions, we could think about how to have that squad ready to support and facilitate the negotiation that we'll have within the governments in trying to solve the problems.
Thank you. This is so interesting. I think in any large organization, and governments arguably are very large organizations, you will have these gaps between different, call it departments, call it arms or of the organization, what have you, and they tend not to know what the other one is doing. And also to move in to fill those gaps and to create awareness of the need to at least think that there are things going on in other parts of government that will influence your work. Yeah, I think it's a very, very good step. And that's really reflects some of the work we have been doing in ADB as well when it comes to policy coherence for international investments and investment governance. So I think it has many names, but it's so important. So looking at the time, we have more topics on our list and we will have time to discuss. What I think we will do, I think we will go straight into a conversation, talk about the mandated or mandatory mediation, because I think that's where the experience of our panel will fit in very well. We had some intention of talking about drafting of in future international investment agreements and mediation, but I think that's a topic in and of itself. So we will maybe park that for now and we will move on. But before we do, I will just want to see if we have Meishi, you took the microphone, if you had something to add on this topic, on the capacity building.
Oh, yeah. So when it comes to capacity building, you think about it, whether it's litigation in court or arbitration, in a sense, all of us have a instinctive understanding of what it is. When growing up, one of my favorite movies to go to are court dramas. I love watching court dramas. Maybe that's why I became a lawyer. And in a sense, we know what happens in the court, or we think we know what happens in the court based on what Hollywood tells us. But when it comes to mediation, there's really not much of that education going on as to what's happened. So instinctively, we think we know, oh, it's just negotiation, but it's not. So I think the education, the capacity building has to be done so much more than, say, in the other areas where the public, the government kind of know what going to court, going to arbitration is like. So on my point about capacity building, we really have to cover the whole range of the governments at the most senior level. If it's something that we can do together, I think it'll be something excellent, because obviously ADB has a reach. One other point I want to just emphasize here is that George mentioned yesterday that the success rate of mediation, and it's the same for SIMC, when it comes to commercial mediation, it's about 70%, right? That's data that's shared freely around the world. When I look at state-related cases, I naturally think that the success rate will be less because it's more complex, involves difficult parties. The power dynamics are very challenging. But our data shows that the success of state-related mediations are at 80%. That was a surprise to me, so I wanted to share with all of you. And I think the reason is because, in a sense, because the stakes are so high and the mediator puts so much effort into it, and the parties that come for the mediation voluntarily really wants to solve the problem, that you actually have a much higher percentage of success. And in a sense, I guess, too big to fail is a phrase that comes to mind. And if I may encourage us in the area of ISDS disputes, I think the success rates would even be higher than commercial rates. So that's an interesting fact.
That's a really interesting number. And listening to the number, I wonder if not what Professor Lee was saying about this dynamic between confidentiality that you will have in these disputes, and I think Frauke alluded to it as well, where you could where government settles a dispute in a mediation, that could be from a public perception perspective, you could have challenges in communicating that because you're talking about taxpayers' money and it's confidential. What happened in that room really? So maybe there is this sort of reflex not to boost too much about it when you actually were successful in mediation. But that's just my personal reflection. So now moving into a few concluding reflections on the use of mandatory or mandated mediation. We have a few minutes left to share some thoughts on that. And I know in Indonesia, there is mandatory mediation. So what can we learn from that? I will invite Amanda first, and then I will invite others in the panel. I have Professor Lee down here that I think he will say a few things about this as well, but please others jump in. Maybe keep it around 2 minutes each if you can. What is the experience of this mandatory/mandate mediation? What are the important experiences from this that we can take into going forward if you want to build the use of mediation for investment disputes? Amanda.
Thank you, Annette. Yes, Indonesia already has practical experience with mandatory mediations through our domestic courts under Supreme Court Regulation number 1 of 2016. Mediation is compulsory in civil proceedings. Before a case can proceed in civil court, the parties must attend mediations, appoint a mediator, and engage in good faith within a set time frame. If the parties refuse, there can be a procedural consequences, including delays or inadmissibility in courts. For these reasons, I believe that mandatory mediation is feasible and it forces early dialogue, reduce escalations, and also helps to build a negotiation culture between parties. The enforceability of the deed of settlement, if settled, also supported by the court order. However, in reality, it can also only become a formality only. Some parties treat the court annexed mediation as a box-ticking exercise before moving on to litigations, and also the lack of genuine commitment. The parties are not ready to negotiate, and also, but it makes the mandatory mediations alone will not create agreements. And the court annexed mediation is also not designed for complex or multi-stakeholders disputes. It's different with mediation in international organizations like UNCITRAL or ICSID because it's voluntary, flexible, and party-driven. However, Indonesia experience shows that mandatory mediations can create the opportunity, but the effectiveness depends on the capacity, incentives, and trust. Like yesterday's speaker said, trust is very important in the mediations. So I believe the question is how Indonesia or we design the mediations so that it is meaningful and not only procedural in court or maybe in other forms. Thank you.
Thank you. So we have heard from the experience here of Indonesia. Professor Lee, do you have anything to chip in when it comes to the mandatory/mandated mediation?
Yes, and I'll be brief. Thank you very much. But I mean, this is something that people have spilled both ink, sweat, and blood on. And I will confess that in my younger days, I would fight to the death, or argue to the death about whether mediation should have been voluntary or not. I think that today the starting point is what Frauke had put up on the screen a little bit earlier, is that what needs to be voluntary is actually the agreement, not the entering into the mediation. And it was interesting to me to hear that at some point they considered somehow making mediation mandatory. Now, I'm not sure how that would work in the investor state context, but assuming it was possible, I think there are two quite distinct advantages. One advantage is that many parties don't want to suggest mediation, at least in the commercial world, because it makes them look weak, right? Some people have this idea that only weak parties mediate or negotiate, which is nonsense, but it is what it is, right? So having mediation mandatory allows people to save face, allows people to actually say, well, you know what, let's come to the table, it's fine, we have to anyway. But the second thing, and I want to build on what Wei Ming said a little bit earlier, is that the settlement rate, I'm surprised to hear it's 82%, right? And even if we took a conservative number, like 60%, that's a very high return, if you think about it, right? And the only problem is that people aren't availing themselves of that benefit because they are not trying mediation in the first place, for whatever reasons. So at another level, when we mandate mediation, it actually brings more people to the table and it increases the chances of them actually benefiting from their process. In this case, 60% chance, if you think about it. So I've changed the way I've thought since from my younger days. And today I'm quite comfortable with the idea of mandatory mediation But agency is still very, very important when it comes to agreement. So parties should not be forced to enter into agreement. But the fact is, actually, mandatory mediation can be of great assistance bringing parties to the table. Yeah, I'll say no more. Thank you for the time.
Thank you, Professor Lee. Apart from the fact that I really appreciate what you said in substance, I find it very encouraging to have someone say that they actually changed their mind about something in this day and age. So thank you for being very inspirational on that side as well. Roberto, yes.
Distinction on this is whether you have a contractual dispute or a treaty-based dispute. Because in contractual disputes, I think that the rate that you're talking about is on contract. I'm not saying that in treaty-based is may not be important, but my fear in contractual is easier because you already have the parties, you already have the thing, you're basically have the issue at hand. In treaty, I would be in favor if the state has the capacity to do the mediation. If the state doesn't have the capacity because there's no internal coordination, it's a waste of time. And I think that's the point that I have been trying to convey. We have to go to the window before to enable the states to do the mediation that now is very difficult to do.
I think there's a lot to say, but I would keep it short. I think, as I mentioned, I think we need to talk about other amicable settlement methods as well, because if you mandate mediations, what are we going to do with the other amicable settlement? That's another thing. The cooling off period also comes into the picture. I think this has to be considered. In the UNCITRAL context, we negotiated on what mandatory mediation actually means itself. Whether, as Fraka mentions, does that mean that it is automatically you're in mediations and you have to walk out of it? But what does it mean then to be engaged in mediations? What kind of a condition is that? Of course, in a treaty, you could make mediation as a condition for raising a claim, which is then it's a conditions for raising a claim. But when we really talked about mandatory, is it talking about the period of mediations? Is it about actively engaging in mediations? It is about actually sending the invite, or is it automatically sent? These kind of questions arose, and this is why we kept it a little bit vague and left it open. I think this is probably why the current mediation provisions in the UNCITRAL text are more voluntary in nature and able for states to actually invite the others to join, and then they're able to walk out. If this is the last time, I wanted to just pick one point on Roberto's point about the analogy that he made. I think we had a very short debate in the UNCITRAL context about whether this is going to be about investment mediation or mediation for international investment disputes. As a lawyer, you probably know what the difference is. Investment mediation can be understood a little bit more broadly as mediations to resolve the grievances that arise in the context of the entire investment period. Whereas for mediations for international investment disputes, if there is a dispute and you're using mediations to solve it. Because of the legal logic that we have been developing as in prevention and mitigation of disputes and mediations for investment disputes, we took the latter path and used mediation for international investment disputes. But as a whole, I think it makes more sense to talk about investment mediations in the text of retaining investment and more of a general sense. And going back to the analogy that you mentioned, you need to talk about mediations pre-marriage as well.
So it's mediation as part of governance, right? From very early on in the relationship, right? The dating, the first date, long before the marriage, right? So I'm looking at the time, so we are actually out of time, but I wanted to just give the opportunity if we have any one of the panelists here in the room or online that want to add a few wise thoughts before we conclude. Fraka is nodding.
Can I respond a bit?
Please do.
Yes, we've had the challenge on arbitrator, mediator scenario in the past 30 years when we attend international meetings as today's conference. for last year, we considered the different mediation, arbitration, dispute resolution mentalities of people from all over the world. So we do have a set of separate mediation rules in CTAC and a separate panel of mediators that people can choose from if they want to shift to mediation from arbitration, and they can select an independent mediator to help them. And also in China, the mediation, the State Council just promulgated the first mediation law. We call it the commercial mediation regulation. Although we had a long history of mediation, but in modern China, most mediation were conducted in the community level or neighborhood, like solving marriage, husband-wife disputes, or small amount commercial disputes. So we just have this real genuine commercial mediation regulation in place now, and it enters into force on May the 1st, just a few days from now. And it's a new start of commercial mediation in China, a symbol of a new start. And for the window in the scenario, in the investment dispute scenario, I would recommend instead of waiting for the chance to open the window for mediation, I'd rather encourage parties to enter into mediation clauses or multi-layer dispute resolution clauses, but just and to set clear timeline for mediation and clear mediation rules, if any, to apply, so that parties are forced to mediation, to go through mediation before any other dispute resolution method. Like we just established the International Mediation Court in Hong Kong. It's an international organization. It literally can can mediate any problem, any disputes internationally. So I would recommend the clauses to put a multi-layer dispute resolution clauses in any ISDS or any other contracts. Thank you.
Thank you. So build a window into the construction from the very beginning. So that's what the lessons learned. Thank you so much. Now, Frauke, you have 30 seconds.
30 seconds. I just wanted to pick up on a couple of things. I think what's important, I promised 30 seconds, 30 minutes exactly. I think the discussion is not necessarily whether mandatory mediation needs to be there, but you need to anchor in the policy that mediation is a possibility for the state, so that it gets away from the individual responsibility. 60% is the success rate in the investment context. I didn't want to miss that from what we have seen, certainly. And institutional readiness makes it easier to mediate, but I have seen successful mediations if there is no coordinating agency. The mediator will then help you get ready for what you need.
Thank you so much. And now we have to conclude, or our hosts will not be happy with me as a moderator. Thank you so much to all of the speakers. Please join me in giving them a big round of applause.
Thank you very much to all the speakers, presenters, and panelists for this insightful panel discussion. So we will now break for a coffee break, and we will be back at 10:50. Thank you. Thanks, Dr. Thank you. Wonderful presentation. So interesting.
I think.
No, it's okay. I felt really bad.
And you started.
I thought when I got it would be very.
Yeah.
But very interesting. I mean, I wish we actually had.
Yeah, it's a fun. It was a great panel. A great panel.
Thank you.
Thank you. Thank you. Have I told you the whole analogy? Because every part of the gets covered. Yeah, everything starts with a turkey.
No, as long as we could see ADB, ADR, how we pass on the expertise.
Yes, no worries. Yeah, it's good.
And yeah, Fan. So question. But you made it go. When you I can only imagine how frustrating. So you have to again, very. I mean, you will find out from there. late night. And then I thought I don't know. You can talk about some of them. That is a little bit in the wording of the one question where we need to actually I'm sorry. Irina, she works in the section. Yeah, that's she did in the either about like how to manage a little bit on that. Oh yeah. Okay, whatever you. I look at concept because my team is the same but I don't have it. If I catch it when I go to bed, then maybe I can go. Okay, good.
Oh, thank you. Welcome back from the coffee break. I hope you enjoyed this short break. So please, let's now take a seat to restart with our session number 6. So next session is titled Incorporating Investment Dispute Settlement in the Regional Comprehensive Economic Partnership, RCEP. Please allow me to introduce the moderator for this session, Mr. Jung Kang, Director of Regional Cooperation and Integration Division at the ADB, Economic Research and Development Department. As director, Mr. Kang plays a key role as an interface between ADB's internal and external stakeholders on regional cooperation and integration. Mr. Kang, the floor is yours.
Thank you. Good morning, everyone. My name is Jung again, and I'm the director of the Regional Cooperation Integration Division of the Asian Development Banks. I'm so-called the interface between the ADB and the Asia Pacific countries in terms of promoting regional cooperation integration across the Asia and the Pacific region. I think we all know about the RCEP, Regional Economic Cooperation, economic partnership, right? And which should be the mega trade agreement, which can foster the trade flows across the region, but not only on the trade front, but how much it can be a conduit through which the investment, the flows across the region can be fostered further. And I think in that context, it's very timely and quite important to discuss the potential role of the investment state dispute settlement mechanism in how that mechanism can help induce more FDI inflows into the region in particular. And then I think that we are joined by the 4 eminent speakers today. First one is the Dr. Jansen Kalamita, professor of NUS. He's based in Singapore. And then he will be making short presentation alongside me. And then we will be also joined by 3 esteemed panelists. The first, Mr. Taufik Wargadalam. I'm struggling to correctly pronouncing their name. So please join us on the stage, Mr. Taufik. And also our second panelist will be Ms. Amanda Yoseani, who's the Associate Legal Drafter, Legal Bureau of Ministry of Investment Downstream Industry of Indonesia. And please to join us at the stage. And last but not least, the Mr. Tirawat Ong Kao, who is the counselor, Department of International Economic Affairs, Minister of Foreign Affairs, Thailand. With this, I think I'm asked to, actually I volunteered to not only moderate the session, but also to make a short presentation to set the stage of this interesting session. So let me first make a short presentation first, to be followed by the Mr. Kalamitas around the presentation. Okay, so during my presentation, so far we have listened to a lot of the legal opinions and the views, and based on the expertise of various participants of this event, and then a lot of the legal document and the legal phrases. But during this presentation by myself, you may see a lot of the numbers, although you may like it or not, but I hope you could enjoy some of them. First slide is about the ISDM provisions in BIT bilateral investment treaties and investment chapters of the free trade agreements. Actually, in ADB, we are running and operating our own IIL toolkits, which comprises both BITs and investment chapters, FTAs, and there we have the codified the different provisions of the BITs and the FTAs of the investment FTA investment chapters. As you can see, by comparing those provisions before the 2020 and after 2020, we can see in the case of BIT, there could be quite significant progress that has been made on the fronts of transparency in ISA, investment state arbitration, and the access to arbitration. In the case of FTAs on the right-hand side, there has been a lot of the progress that has been made in terms of transparency in ISA in particular, although, in particular, as well as the access to the arbitration. Access to arbitration means that whether those provisions allow to access to international arbitration like those in the ICSID. And by transparency, we mean whether the provisions stipulates the clauses on the public arbitration hearings, procedures for the appointing arbitrators, and the obligations of connected parties, and the enforcement awards, among others. Based on that, we have codified different provisions between 1 and 2. 1 means then the low level of quality of those provisions. 2 means the high level of quality of the provisions. And then when it comes to the potential effect of the ISDS or ISDM on the FTA flows, some anecdotal evidence indicate that some conflicting result and outcomes in a sense. First and foremost, those ISDS provisions should signal credibility in terms of high-risking settings. The government can signal their commitment to attracting more FTA inflows by embracing ISDM or ISDM clause provisions in their BITs and FTAs. But at the same time, whether those provisions have actually investment promoting, fostering effect or not, that remains as an empirical question, because some of the anecdotal evidence, for example, in the case of Colombia case, when it comes in particular, when the outcome of the award was not in favor of the investor, that can even work against the investment motivation and incentives in late afterwards. So overall, like in the case of SPS and TBT and the trade flows, SPS and TBT can be a very important commitment tool to attract more trade flows, but at the same time, it can work against the promoting trade flows when it comes to the quite stringent provisions in place by some of the importing countries. Like in the case of those trade provisions, ISDS, whether those can be investment promoting tools or not still remains an empirical question. And usually, most of the investors often view ISDS as a form of risk insurance, particularly in the weak institution environments, instead of taking those as a decisive factor, triggering new investment flows on its own. So in that sense, ISDA tend to be promoting the investment decisions for the many of the FDI investors, but it may not be the sole and the decisive factor in governing the decision-making of the investors across the world. Building on the III toolkit we have rolled out and having implemented for the past decades, we had conducted quick simulation exercise. This is empirical exercise using the regression methodology to test whether the BIT and then the FDA provisions can have a significant positive impact of FDI inflows into the region. The dependent variable here is a number of project or deals. Then we have used the different models. The first one is to test the impact of BIT and then the BIT-related family provisions based on our codification exercise. And the second model is to test the chapters of FDAs, whether those provisions can have really significant and the positive impact of the FDI inflows into the region. And we have also controlled other potential factors such as the geographical vicinity, GDP levels, between both host and the destination countries, and then the colonial relationship and the geographical contiguity, among many others, to see whether actually the ISDS and the other FDI-ADB provisions can have a significant impact on the FDI flows. So here we are showing the different variables included into the empirical exercise, as I explained before. So based on the III toolkits under our the platform. So let me just briefly go over the result of this empirical exercise. One caveat I'd like to add, though, is that this exercise is not using the panel data, so-called. By panel data, we mean the tracing the time horizon changes of the different factors and the different FDI deals over time. But here we are collapsing all the country flows between a specific period from 2003 to 2024. So in that sense, this is to provide snap analysis of how different provisions of BIT and FTA or FTA the investment chapters can affect FTA flows based on the cross-country comparison. So this is not to compare the countries' FTA inflows before II and after, but it's to compare the different impact of the provisions onto the FTA inflows between those having those provisions and those without. This is cross-country comparison, so-called. Then, as you can see from this comparison table, overall the BITs and then the different provisions of BITs seems to have a positive and significant impact on the FTA inflows into Asia. Yeah. So, for example, the presence of BIT and the definition of investment, national treatment, MFN, and the expropriation and the free transfer, those provisions seem to have a positive impact of both on greenfield investment in particular, but not so much about the M&As. On the second column, you see some different numbers, but it doesn't have asset rate. This means that the impact is not significant at all. But at least in the case of the greenfield project, on the first column numbers, you can see the asset rate. 3 asset rates indicate significance at the 1% level, and the 2 asterisks indicate the significance at the 5% level. So this overall means that the BIT and the different provisions under BIT seems to have a positive significant impact of the greenfield investment into Asia and the Pacific region, but not so much about M&A. But when it comes to the investment chapters of FDA, as you can see from the third and the fourth column of this table, for both greenfield investment and M&A deals, different investment chapters of FTA seem to have a positive impact on the FTA flows. This also includes the impact of the access to arbitration and the transparency in ISA, as you can see from the bottom 2 rows of this table. So this clearly indicates not only general provisions investment chapters of FTAs, but in particular, access to arbitration and the transparency in the ISA seem to have positive significant impact to the FTA inflows into the Asian Pacific region. So another table here we have tested the different family provisions under BIT as well as the investment chapter of FTA. So here, for example, entry, the family indicates admission versus establishment, and the treatment, the family provision covers the national treatment, MFN, as well as public interest obligation. Scope, as you may imagine, covers the definition of investment, umbrella clause, and temporal scope of application, among many others. And the expropriation covers fair and equitable treatment, and the direct and indirect expropriation clauses concerned. ISDM, again, covers two pillars of our codified toolkits. First is the access to arbitration. The other is the transparency investor state arbitration. As you can see from the table again, overall, the BIT, existence of BIT as well, the different family provisions of BIT seem to have a positive impact on both the greenfield investment and M&A deals. This includes the impact of ISDM, but not so much of, here the ISDM alongside other BIT provisions shows the positive significant impact on the FTA flows, but the ISDM and other provisions do not seem to have a positive impact on the M&A deals, as you can see from the second row of this table. First row indicates a lot of numbers with asterisk, which means the significance of those variables and factors. But on the second row, at least on the M&A, those BIT provisions, including the ISDM, doesn't seem to have a positive impact on the FTA inflows on M&A deals. Below, the third and the fourth row indicates, as I showed before in the prior slide, investment chapters, various provisions of the investment chapter in FTA, including those for ISDM, shows the positive significant impact of FTA inflows, not only for the greenfield investment, but for M&A at the same time. This means that the FTA has a great potential to embrace the fostering, the enabling environment for the FDI inflows for the Asia Pacific region, including through the ISDM. On the right-hand side, we have tested another variation of the model by combining both BIT and FTA at the same time in one model. Then, as you can see, again, the BIT, FTA on the first to the fourth row shows the significant impact, which means that both BIT, FTA provisions, including ISDM, seem to show the positive impact on the greenfield investment. But on the below part of the table, when it comes to the impact on the M&A deals, as you can see, existence of the FTA provisions seem to have a positive impact, but not the BIT itself per se. When it comes to the impact of the ISDM, when we control for the potential impact FTA provision, on the rightmost part of the table, as you can see, BIT ISDM provision exert positive impact, significant impact, not so much of the ISDM provision of the FTA. This means investor ISDM provision of the investment chapter of the FTA can have a significantly positive impact on the FTA inflow into the region when there is no BIT between contracting parties at the bilateral level. So in that sense, if there in the absence of the BIT between two contracting parties, FTA, investment chapter, when it comes to the embracing ISDM, can have positive impact on the FTA inflows. So in that sense, FTA can be playing a role as a complement to the BIT. So this has a quite important implication. So when it comes to the thinking about the roles of the FTA in promoting the FTA inflow, in particular through the ISDM provisions, policymakers need to think about whether they already have a BIT among themselves or not. If they don't have BIT, there is a strong case to be made to have FTA through which investment flows can be further fostered, in particular through the ISDM measures. So the key message about this, the SNAP analysis, is that over time, the many Asian countries have progressed evolution of the treatment of the ISDM, ISDS, in particular in expanding the access to the ISA and also improving the transparency of those ISDA, ISDS, ISDM related measures through the BIT and the FTA arrangement. But whether the ISDM in particular can have a positive impact on the FDI inflows into the region still remains as an empirical question. And our SNAP analysis has indicated at least there is a quite strong case to be made to embrace ISDM measures, either through BIT or investment chapter of FTA, by which the regional economies can intend to and try to mobilize more FDI inflows into their respective economies in the future. So let me stop there. Thank you very much. So we can entertain some of the questions from the audience later, but now let me move on to our next presenter, Mr. Jensen, for his presentation.
There's nothing like following a proper social scientist when you're a lawyer to make you feel inadequate in what you're about to say. I'd also just qualify, perhaps based upon what was just discussed, that ISDS is not monolithic. ISDS comes in all shapes and sizes. And actually, what I want to talk about in my time are 4 options for ISDS in RCEP and an elephant. I'm going to talk about an elephant, but I'm going to talk about that at the end. And these are not the only options, but these are principal options that I'm going to discuss for the way in which RCEP might incorporate an investor-state dispute settlement mechanism. And here I should point out that ASEAN is not alone in terms of closing an investment chapter without agreeing on a dispute settlement mechanism. ASEAN is actually in the very same position as the African Union finds itself right now with the African Continental Free Trade Agreement Investment Protocol, which the African Union closed, but they remain to come to a decision on how to or whether to incorporate ISDS. And that has to do with a lot of the same kind of disagreements among African Union states with respect to ISDS as we see among ASEAN states with respect to ISDS. So let me start with what might be considered the first option, which is classical or traditional investor-state arbitration. We don't need to go into the details. We're familiar with this process. And quite clearly, there's no political appetite in ASEAN to simply have classical investor-state arbitration. At least that's my understanding, given the fact that if there had been an appetite simply to use investor-state arbitration, probably ASEAN wouldn't have needed to close the chapter without reaching an agreement, because this is typically been the default approach to investor-state dispute settlement. Nevertheless, it is one of the principal options open to ASEAN with respect to ISDS under RCEP. The second is perhaps more politically available, and this is modified investor-state arbitration. And I want to focus on 2 particular aspects here: the use of an appellate mechanism and the use of mediation as potentially changing the dynamic of ordinary investor-state arbitration. So starting with the appellate mechanism point, as has been discussed already, in the work of UNCITRAL Working Group 3, there have been discussions of many different ways in which to change, amend, modify investor-state dispute settlement. And one of them has been to establish the possibility that after one after the parties have their initial investor state arbitration, there might be an appellate body or an appellate mechanism that could be used, which would allow the parties, either the state or the investor, to bring an appeal to that body. And now this would differ, of course, from set aside or annulment that we're used to, because it would allow the appellate body in principle to a deeper scrutiny of the award, reviewing for errors of law, for example, or perhaps even manifest errors of fact. And this would be an international body. This would not be bringing an appeal to a domestic court, but rather an appeal to a standing international appellate mechanism, or perhaps one that's set up ad hoc by the parties under their particular treaty. It's been in discussion for more than 20 years. The United States first talked about it in 2004, but now finally with the work of Working Group 3, the possibility is going to concretize, and there will be an avenue for states to use such a mechanism if they choose. So that's one option that could be considered for RCEP that would change the dynamic of ordinary investor-state arbitration. The other is the use of mediation, which we've talked about quite a lot. And there are really three approaches to mediation. The first that we've heard discussed is optional mediation upon agreement of the parties. And this does not make mediation a precondition to bringing an arbitration. This is what Inter-Trial Working Group 3 was able to agree upon among its membership. But that does not mean that other mechanisms are not available or perhaps not even superior. It's simply the lowest common denominator that the members of Working Group 3 were able to agree upon. The alternative is to make mediation an actual precondition before you can even bring an arbitration, before you can even send a notice of arbitration. And here there are two models. One is including in the treaty the statement that mediation shall be mandatory, full stop. So it's mandatory a priori. It's mandatory from the moment the treaty is signed on both the state and the investor, if the investor wishes to pursue a dispute. The second approach is to make it mandatory when the disputing state decides to make it mandatory. In other words, to allow the disputing state the possibility of saying, we want this case or this dispute to go to mediation before arbitration. This is rare, but it is already found in ASEAN practice, particularly in two CEPAs that Indonesia concluded, one with Korea and one with Australia. We also see it in some of the practice of the United Arab Emirates. To my mind, this is perhaps the most enticing or the most promising of the mechanisms. As Roberto Ochandi talked about before, there's no sense in putting the parties in arbitration, especially the state, if the state is not prepared. This allows the state to determine whether or not it is prepared and whether it believes in its interest to pursue mediation, and then makes that, again, a precondition before the investor can even start arbitration. Now, third possibility is to get rid of investor-state arbitration altogether and to judicialize the process. And this is the approach that the European Union has taken since about 2008 or so, and is now concluded in its treaties with Vietnam, with Singapore, with Canada, and others. What this sets up is a system where you essentially have investment courts. And you don't have arbitrators that are appointed by the parties, but rather you have judges who have been appointed by the parties to the treaty or whatever instrument sets up the body. So you have a first instance court and you have an appellate body court. There are a variety of ways that RCEP could institutionalize this kind of approach, which, at least for the Europeans, has been seen as much more politically palatable than investor-state arbitration. UNCITRAL is presently finalizing a mechanism, or rather an instrument, that will establish a multilateral investment court, which could be appropriated and used for RCEP. Or RCEP could decide to use the multilateral investment court, but then append to it the idea that there would be a special RCEP chamber of dedicated judges who would hear disputes that arise under RCEP. The fourth is simply to get rid of binding investor-state dispute resolution altogether. This is the approach that Brazil has taken in its cooperation and facilitation investment agreements. Brazil, of course, has never ever entered into a treaty with binding ISDS. But in these agreements, they've come up with an interesting and thought-provoking approach to dispute resolution. These treaties are focused as much on cooperation and facilitation as they are on dispute resolution. And so each state is obligated to establish a national contact point, which will serve as the central entry point for investors who have grievances with the state. And the investor may approach the national contact point and say, I believe you've indirectly expropriated my property. Well, if that cannot be resolved between the investor and the state's national contact point, then it's possible for the investor to ask its own state to raise the issue at the level of the joint committee that is established under that treaty. Now, the joint committee then has the opportunity to discuss the claim, decide whether it can be resolved or should be resolved. In the event it can't be resolved, then the investor's home state may take the host state to ad hoc arbitration. But note that the investor is not in the picture anymore. It's not the investor's choice, it's the state's choice whether to raise the claim. And this brings us back to the old days of diplomatic protection, of course, but it also brings us into a kind of parallel with what we see at the WTO, where individual traders are not empowered to bring claims, only their states. And now we come to the elephant. So here's the elephant. RCEP is a massive regional comprehensive economic treaty. But in ASEAN practice, RCEP does not replace the existing treaties between ASEAN states and their non-ASEAN parties. So even after RCEP, we will still have an ASEAN Australia-New Zealand free trade agreement with its own investment chapter and its own dispute settlement mechanism. And we will still have a China-ASEAN investment treaty, again, with its own dispute settlement process. So whatever ASEAN ends up doing in RCEP, if an investor from one country thinks that it's not advantageous, it can simply bypass that by deciding to use one of the older bilateral treaties that does not have the new mechanism that ASEAN has come up with for RCEP. And so, in just one academic's humble opinion, if you really want to make ISDS in RCEP effective, and if you really want to modernize through RCEP, then the only way to do that is to have RCEP replace the investment chapters or the investment treaties that are already in force with ASEAN's partners. That seems unlikely to happen, however. Big elephant. Thank you.
Thank you, Jansen. Thank you very much for your very comprehensive as well as very thoughtful presentation made. And then I think he has provided us with numerous agenda items to think about. So one option is to stick to the regional, the context of the arbitration. Another option is the modified framework under the RCEP, and also how to make the mediation as a prior requirement. depending upon the different degree of the requirement, and also whether to have a separate appellate body mechanism or not to replace the ISDM procedure entirely, or another layer of the appellate body, the procedure. And then the last but not least, and also the Brazilian the case, I mean, the more flexible approach. And the last but not least, the elephant issue you have alluded to, for example, whether any kind of new ISDM mechanism to be embraced by the RCEP members in the future, whether it can be effective enough, because the RCEP members have a lot of the existing the provisions available under the different BITs and the FDA provisions. So then whether there could be the notable syndrome type of thing, and also whether we can make the RCEP provisions more effective in the future. So with that, I'd like to, we can go back to this very important issues and then the options to be thought about by the RCEP member concerning the future later. But before we move on to that specific issue, let me ask Mr. Toffee, because we are all wondering about the current status of the discussions among the RCEP members about this very important issue. And because you have been involved in that process, perhaps you can share with us your knowledge about this.
Thank you, Director Kang, for giving me the floor. First of all, I would like to thank ADB and ADBI and Deputy Dean ADBI for hosting us this event. And regarding the status of the ISDS discussion in RCEP, basically the ISDS discussion is taken in one of the subsidiary bodies, the Committee on Services and Investment. The last meeting was held last year. Because basically the subsidiary body is monitoring all the implementation issues, including the built-in agenda. As we all know that ISDS is one of the built-in agenda under the RCEP agreement, where under the Article 1018 of the RCEP agreement, the parties shall enter into discussion 2 years after the entry into force and shall conclude within three years after the commencement of the discussion. So far, we haven't really discussed into a substantive discussion on these particular matters. But of course, since it is given already in the agreement, of course, parties are keen or open to discuss. But I think, as we all know, that many are shifting from during the negotiations up until now. So, and maybe I would like to also update the participants in the meeting room. Next year, RCEP is scheduled to have a general review. Of course, ISDS is something that the parties can also consider whether we will include this at the next the first review. Of course, I cannot overstep because I'm not representing the position of all the 15 parties here. But I think there's a window of opportunity next year. At the moment, the discussion is still in the early stage of the general review. The joint committee is still working to explore the possible scope, or the low-hanging fruits, the priorities for RCEP parties to include or to follow up all the built-in agenda, including to add additional chapters on emerging issues. Because as we all know that last year we just had the first RCEP summit after the entry into force in Kuala Lumpur last year. One of the mandate is to modernize the agreement, including to include additional chapter of the RCEP, and including to make sure all the built-in agenda and all the the follow-up items well carried out. Thank you, Director Joe.
Okay, Mr. Taufik. I understand because the RCEP comprises the 15 members, right? ASEAN plus the China, Japan, Korea plus Australia and New Zealand, 15 members. The different countries and jurisdictions may have different views about, and also they can have different stances about whether to introduce the ISDS into the RCEP or not. So even during the RCEP negotiations, I recall that until 2019, most of members were quite in favor of including the ISDN, but I think that Malaysia in particular turned their position and that they became against the ISDS, and that the members were not able to include ISDN eventually. I also think that perhaps the +3 countries like Korea, Japan, and China could be more in a favorable stand in supporting the ISDN, but this could be a bit subtle contrast with the potential stance embraced by the ASEAN member countries in particular. I think the Indonesia was also aligned with their stance with Malaysia in terms of going against ISDM during the RCEP negotiation. And Thailand, I'm not so much about the Thailand stand, but perhaps we can listen to country representatives here joining us today, the Thailand, Indonesia. What kind of the views and perspectives do your government have at the moment in terms of the introducing ISDS into the RCEP arrangement? So perhaps Mr. Therawat first from Thailand.
So thank you very much for the opportunity. Actually, on this topic, in order to make my contribution more meaningful, I would have to make a disclaimer. I think I would rather offer personal reflections or perspectives on this matter, because there has been no official position with regard to the review of the RCEP provisions.
Again, we also follow Chatham House rules, so nothing will be disclosed outside.
Anyway, but in order so that I can speak more clearly. However, my perspectives are not completely random. They are informed by the my experiences. I have been involved in not the RCEP negotiations, but in the ASEAN-China update investment agreement negotiations, but also current ASEAN-Canada investment chapter, and also I'm involved in the bilateral investment treaties of Thailand, which actually informs the positions in the investment chapter in FTA. So I would rather offer this perspective from that regard. I think there are a few questions that we have to address. I think first, the review will answer the question whether we will even have the ISDS provisions in the first place. Of course, for Thailand, we were in favor of including the ISDS provisions in the original RCEP, but because of disagreements among some members, we could not have it. So I see no reason why we wouldn't support ISDS provisions in the review. That's I think the official position. We also would like to align the investment chapter in the FTA with the BITs. And so in the BIT model in 2020, we have reformed the ISDS provisions to include new developments, such as transparency rules or counterclaims, third-party funding. So I would imagine that in the ISDS provisions for RCEP, Thailand would also like to modernize the ISDS provisions in that direction. So we would not necessarily support the traditional, basically your option 1, Professor Jansen. I think we would not go for that one. And I think maybe this option 2 might be the most plausible one from Thailand perspective. And the reason why we say that ISDS provision is very important for the RCEP agreement is because I think the agreement, we made commitment for investment protection, but we do not offer the procedure for remedies. It is like offering insurance policy without claims process. I could not fit the analogy in the marriage analogy, but I think that's the best analogy that I could give. I think also the modernized ISDS provisions in the RCEP would also give a credibility to the agreement itself. So I think from that perspective, we would be in favor of including the ISDS provisions. And as I already mentioned, that what kind, from my personal perspective, your Professor Jansen's option 2 in my opinion, would be the most plausible one. Of course, I could not speak for other RCEP members, but having seen the trends in the negotiations in the even ASEAN-China upgrade FTA, but also as well as the current ASEAN-Canada FTA negotiations, I think that is probably the most plausible one in my opinion. And also following the developments in the UNCITRAL trial, Working Group 3, that could be the best option for us. Of course, this will depend on, well, this is based on the assumption that we will have the review of the ISDS provisions at all, right? And also, in my opinion, we would see the ISDS provisions with the ADR provisions of some sort. This is based on the assessment of the outcome, well, the negotiation developments in the negotiation, let's say in the ASEAN-China FTAs, the upgrade, as well as the current ASEAN-Canada negotiations. Of course, this is without prejudice the final outcome of the negotiations, but I think there has been some positive consideration on the ADR provisions. For Thailand, we have the ADR provisions in our BIT model. However, we also have a question specifically, why we specifically address just mediation, because our position has always been we would be happy to include the ADR provisions, which also includes conciliation as well. And so whilst we may support the mediation clause in the provisions, I think we would also like to see other kinds of mediation reflected in the new ISDS provisions as well. So I think that's my preliminary opinions on the prospect of having ISDS provisions in RCEP. But if there is any further questions later on, I would be happy to engage. Thank you.
Okay, thank you, Mr. Terawak. So with the quite clear disclaimer attached here, you have expressed your preference for option 2 and also potential the inclusion of the pre-arbitration procedure, like not only mediation, but the conciliation as a kind of practical manner to facilitate the dispute settlement procedure and the mechanism in the future. So that would be quite practical and constructive options that can be considered by the RCEP members. So let me now move on to the Miss Amanda from Indonesia.
Thank you, moderator. Actually, same position with Rawat. I don't really involve in the negotiations and also discussion of RCEP. But let me share you my personal view on RCEP, which I believe RCEP include the substantive investment protections, but differ to ISDS. This should be understood as sequencing, not hesitations. I think it gives us time to secure predictability for investor while taking the necessary time to consider how dispute settlement can be aligned with our national development priorities and also regulatory space. In Indonesia, we have strengthened our dispute preventions and early engagement mechanisms. We also familiar with court-annexed mediations in civil proceedings, which reflects our preference for resolving dispute efficiently and amicably where possible. At the same time, we are also in process of revisions of legal frameworks related to arbitrations and ADR law and even civil code, as yesterday's speaker from Indonesia, Ministry of Law, mentions. These processes are directly relevant in shaping how we will think about the future of ISDS under RCEP. But for my personal view, if RCEP were to adopt an ISDS mechanisms, I think Indonesia would see value in mediations or consultation as a mandatory first step to preserve the relationship and also avoid premature escalations. We may consider of the exhaustions of local remedies to strengthen domestic institutions and also clear safeguards for public policy, including in environmental protections or public health. There's no many things I can say because we don't really have the formal positions here. But thank you, moderator.
Thank you, Ms. Amanda. So at least we can draw from both of the country representative that there is some positive consideration of the potential merit of introducing the ISDM into the RCEP agreement. Now let me move on to Jansen, because you have provided us with very good menus and options for consideration by the policymakers. So if you're asked to make presentation in front of the RCEP authorities in terms of the various menus and options you can present to them for their consideration, and then if they ask you to prioritize, of course, those the options from you can also attach the clear disclaimer from the academia. You don't have any authority to impose any option on them, but from purely academic perspective and the practitioner's perspective, how would you prioritize, or at least put more emphasis on?
Right. Well, from my unpaid position, I don't really have a priority in a sense. I mean, I don't think that option one works anymore, and states realize that classical investor state arbitration is not really fit for purpose. It can be improved, and there are improvements as has been mentioned. But with respect to modified, with respect to an investment court, with respect to the Brazilian model, for me, in a sense, I would just follow up on Tirawat's point. Sort of the worst case scenario is that there's nothing. And so this investment chapter has been negotiated and substantive terms have been agreed, and then there's simply no mechanism for dispute settlement. I think that doesn't look good. I think it's a waste of time. And what I would suggest is that states approach this issue with flexibility and keep their eye on what they're really trying to accomplish here, and things that we've been talking about this week. Talking about keeping pathways open where you can continue the relationship with the investor. And that, I think, means making mediation a prerequisite before bringing an arbitration. And of course, that doesn't discount all of the grievance mechanisms and possibilities for pre-dispute resolution that we've been talking about the past days. But when you get to the treaty, you can still make mediation a prerequisite before you finally pull the trigger and get to the arbitration. I will say this, though, that I'm encouraged to hear that in the Canada and in China negotiations, there is movement on ADR, because historically, ASEAN has been very slow in terms of adopting ADR as part of its investment dispute provisions. And I think that's demonstrated in the ANSFTA upgrade, where, frankly, the provision on conciliation is a little weak. So I would encourage them, if I was being asked, to consider more robust mechanisms for ADR.
Oh, thank you very much. So there could be the various options to be considered by policymakers. I think perhaps one option also could be having a plurilateral arrangement within the RCEP. If not all the members can agree on the robust mechanism in terms of the embracing ISDM inside the RCEP, then potentially part of the RCEP member country can agree on at least some common ground. I just wonder whether that's worth considering by the RCEP member, or it may take the risk of undermining the spirit of the RCEP unity and then the economic cooperation among the 15 member countries across the Asia and the Pacific. Another option could be potentially carving out some sensitive sectors such as health, environment, climate-related sectors to cover not all the sectors all at once, but over time we can try to expand the scope of the industries to be covered. But we can begin from some small common ground where we can agree on relatively easily. So that kind of gradual approach, whether that's worth considering. I may ask Mr. Taufik's views and reaction to that kind of option.
Thank you, Director Jung, and also thank you, Prof. Jansen, for the options provided. And after listening Mr. T and Amanda from Indonesia, basically Thailand and Indonesia is open and agree on the importance of having this ISDS. And I think after the suggestion from Professor Jansen that the option two, that I think for the future ISDS is RCEP parties might consider the modified approach because I think it is also important for the parties to see the lesson learned also from the other agreement. I agree with you, Director Jung, that the case law has taught us that the newer generation agreement, like the recent issues like in the CPTPP, where there is an exception from ISDS on claims challenging tobacco control measures, for example, on Australia case. And also even Director Jung, in CPTPP, due to certain sensitivities, some parties carve out from ISDS as well. So I think again, it is also depends on the future discussion. Of course, in exploring all the possibilities, whether we can have a plurilateral ISDS under the framework of RCEP. Of course, this is one of the possible way forward for the future discussion. But again, as you know, that in ASEAN or also in RCEP, we work based on the consensus. The challenge in RCEP, as we all know, it's the dynamics, not only the size of the agreement, but the dynamics also among the dialogue partners that we need to see. Even like, for example, like Australia, it is published in their website that at the moment they cannot negotiate the new ISDS provision in new FTA. So it is published in their website. But again, of course, this is something already in the agreement. We need to keep exploring. And I think we agree that it is on the importance of to enhance the capacity. I think such kind of activity like this, I think this is important to help better understand the RCEP parties, especially the ASEAN member state, to be able to enable the government. I think one of the takeaway from the previous session that it is important. Roberto mentioned that to enable the government to do the mediation. I think because this 2-3 days event is under the umbrella of the ADR. I think we agree that it is important to strengthen the ADR mechanism. Maybe it is something that is feasible to be included in the future RCEP ISDS. Thank you, Director.
Okay, good. Thank you. So my last question to the panelists will be on the so-called elephant matter, which was brought up by the Jansen. But before doing that, let me open the floor to the audience and participants. If you have any feedback, comments, or questions to the speakers, yeah, please, yeah. Robert.
Yes, I would like to provoke the audience as usual, because I think that the discussion that has happened in ISDS is rational in the sense that we had an explosion of ISDS mechanisms were not perfect. So I fully agree with Professor Calamita that, ISDS without modernization doesn't work. Now, putting that discussion aside, I just want to make 2 reflections. One is that if our experience shows that if there's no the possibility to have an effective ISDS in the prospect of a discussion, it's very difficult for governments to have the pressure to put their house in order. In other words, if we want to promote non-litigious mediation without any potential threat or potential pressure that if I don't put everything in order, governments will not move. Okay? That's the first point. The second point is the political imbalance. I just would like you to think. We tend to think on investment in a very defensive terms. I come from a developing country, by the way. But we joined ICSID because we had a dispute with the United States. And I want to speak not on behalf of the World Bank, but I'm going to say now it's totally personal. When you have such a power imbalances, right? It's extremely important to have rule-oriented mechanisms to settle any disputes. We had a Santa Elena case. Probably you have heard about it. It was one of the first cases in ICSID about green things. It was an expropriation of a forest, of a national park. We wanted to pay $10 million. The American investor said, I want 100 million. And we say, no, 10, no, 100. Long story short, because of that, I was with the minister when he received calls from the ambassador of the United States saying, Mr. Minister, you know, if you don't settle this, do you remember all the loans in the World Bank? Do you remember, you know, the CBI, that tariff-free is kind of the GSP that we used to have? That will be gone. Bullying. This was 30 years ago. Today, what are we seeing? What are we seeing? If we had today a rule-oriented system that worked more effectively, I mean, I'm actually discussing with, you know, I'm very tempted, once I've retired from the World Bank, to go back to practice, and I'm very tempted to get a Costa Rican investor in the United States if it's affected by the policies that they're taking, because it will be interesting to see, yes, the governments will never dare to challenge the Trump administration, but maybe an investor may. So my point here is not to generate this kind of discussion. My point is the importance of rule of law to balance asymmetries of power. So that's things that are usually not considered, but in your A region, you have a lot of small countries too. And you have a lot of power asymmetries too. So think also about that dimension of having a rule-oriented mechanisms to enable the non-litigious to work, and second, to balance powers. Because if you don't have nothing, then power will be the way to solve. Remember the era of diplomatic protection? Remember gunboat diplomacy? There's plenty of documentation on that. It's history. And we are getting back to gunboat diplomacy today.
Okay, yeah.
Thank you so much. First of all, I would like to give my thanks to the Director Kang, because he showed some statistic, the evidence, really ISDS matters for inducing a foreign direct investment with the study. Thank you so much. And another point is that, as you mentioned, that multilateralism is much better than bilateral negotiation when it comes to there is a no balance in terms of power. And in case of RCEP, look at the consisting member country, 15 countries, Korea, Japan, China now is emerging. 3 countries, Australia, a bit of the advanced, but compared to CPTPP or other multilateral the agreements, I think the Korea also faced the struggle, the ISDS from the investor from other Western country. China also. I think in terms of understanding the atmosphere of a developing country, both China, Korea is in favor of some adjustment reform of the ISDS mechanism. I don't know whether Japan is ready to be in favor of the atmosphere of a developing country. Austria, I don't know. But since you, many of ASEAN member countries already a member of CPTPP, therefore they are familiar with the very advanced ISDS tools. You consider already the reform, the carve out some health or public matters. It's reasonable. It could be acceptable for advanced country. In that sense, I think it's a right timing for RCEP to consider to include that, the ISDS provision in your multilateral agreement. It's very important because regional cooperation integration really should work in this geopolitical uncertainty. In order to make RCEP alive, you should move. So don't just postpone because it's your mechanism. It's your economic cooperation mechanism. It's helpful for your side. So as a minimum level, think about how to accommodate, reflect your interest, because I believe that advanced country, among ASEAN countries, would be ready to listen to your concern.
Thank you.
One more question.
Yes, please.
Good morning. It's not a question, but just to enlighten you with the history of the RCEP negotiations, why ISDS is not included, and then why the mediation is not included in the text. I think Professor Mr. Jung has enlightened us with some backgrounds of why the ISDS was a concern and was not included in the RCEP. But I would like to recall the history of our negotiations. The RCEP negotiations started in 2013. And then if you look back into the Ancestral Working Group 3, that was tasked to look into the ISDS dispute settlement mechanism and the investment facilitation, so on and forth. It was in 2017. Please correct me if I'm wrong. So most of the negotiations took place earlier than what just happened later, and also the Singapore Convention. Therefore, many negotiators, including me, myself, and my colleagues here who used to chair the RCEP Working Group on Investment, we put more focus on the conventional way of dispute settlement, which is ICSID, ad hoc arbitration, or the ancestral rule of arbitrations. And that was our focus. And I think throughout the negotiation, each negotiator had the mandate. So once we secured a mandate, we couldn't explore a better option. But in the ISDS, there was another approach proposed by few countries, including Cambodia, I myself, which is separate written agreement, which did not fly at all from the investor perspective. Therefore, if that separate written agreement, prior consent, was not working, then we couldn't explore the better ways. But now that we have this investor state dispute mediation in place, I think it's a good time for the RCEP to revisit this. However, one warning: it depends on who the negotiator are and the policy of the government. But back then, we were tied by the claim against the government, including Korea, like Mr. Alex mentioned yesterday, including many countries who were the negotiator also participate in those claims and exit. That's why the ISDS was not in a chapter. I mean, in RCEP. Thank you very much.
Okay, thank you for sharing your perspective and the recollection from the historical background of RCEP negotiations around the area of the ISDM. I also think the rules-based system should work the best, but at the same time, why don't we try to explore other various options provided by the ADR, and because also given the context of a lot of the new developments having been made over time, so we are not in a better position to explore various options available. And also the power imbalance issue, I don't think there is any clear solution, because as long as we don't have a supranational authority who can rebalance different powers across different jurisdictions, there is no clear solution. But at least we can try to help government, in particular those with weak institutional capacity. I think that Krishna here is sitting here, and the Deputy Dean Jung is quite proactive and active in the providing capacity building programs for the government officials and the sovereign authorities. So I think that way we can try to gradually address some of the potential issues of power imbalance between investor and the states over time. We don't have much time, but yeah, Johnson. Yeah.
So the reason I use the phrase elephant in the room, which is an English expression to mean something big and important that nobody notices. And we haven't gotten back to the elephant. Whatever the ASEAN states do in RCEP will be totally avoidable unless they change or get rid of the ASEAN Plus agreements with investment chapters. So if you impose mediation as a prerequisite for arbitration in RCEP, and an Australian investor investing in Indonesia does not want to go to mediation, then they will simply use the Australia, the ANSFTA, or they might even use the Australia-Indonesia agreement. You know, there's such a web of agreements in ASEAN. And ASEAN, if I may say, one of the principal things that undermines coherence ASEAN treaty making is that ASEAN never replaces the old treaties when they adopt new ones. With respect to the carve-outs for tobacco or for this or that, it's a great idea. My concern is that that means actually reopening the substantive parts of the investment chapter as well. I don't know that you can only do that in terms of the procedural aspects. And my last point on power imbalance, yes, power imbalance, especially if you don't have a bit, it's very important. Look what happened to Argentina. Argentina didn't want to play. Argentina lost a lot of bit cases against the United States investors. They didn't want to pay. The United States threatened to withhold further World Bank funding from them. Argentina found a way to resolve those payment issues. Russia lost a $60 billion claim, but it's Russia. Nobody has the leverage over Russia. They haven't paid the award. Even with rules-based systems, power imbalances don't go away.
Very interesting discussions. And on the elephant issue you have brought up, I think this reminds me of the so-called notable syndrome issue in the context of different FTAs, in particular in terms of availing of the concessional treatment available from different rules of origin. So one of the key concerns with respect to the RCEP utilization ratio, low utilization ratio is also anchored on that the notables in different rules of origin across different FTAs. But still, I think, for example, through the ISDM, ISDS, and the RCEP, we can provide some harmonized approach or standardization of the ISDM approach across the 50 member countries. Then member countries may find some merits and the benefits of utilizing those ISDM available under the RCEP. So that's where we can have some hope, maintain hope with the future negotiation among the member countries. With that, I'd like to ask you join me in giving a big applause to our esteemed panelists. Thanks.
Thank you very much to all panelists and presenters for this very insightful session on incorporating investment dispute settlement in the RCEP. It was really, really interesting to listen to you. So it is now time for lunch. So please enjoy the break, and we will be back for next session at 1:10. Yeah, 1:10. Which is perfect because it's 12:10 now. So.
Hey.
No, and I live in the world that exists too. Yes, we're very waiting for you. Yeah. Well, that's why I said it would be bad if you didn't have it. Just like it would be bad for the EU if they cannot.
Well, as you rightly point out, even if we come up with a good ISDS chapter, but if it's not something that, I mean, it's good for state, for instance, but not so most favorable for the investor in that particular dispute, they can just use other.
I suppose the possibility is
other
really good at percent. and then all the RCEP states. This seems pretty good. Maybe we should replace.
Has this for, you know, well, like when it depends on yes. Yeah. Some states might think this is good for us, but then some other states might think, okay, we still need maximum partnership.
Singapore. Yeah, well, Thailand's down. You know, they're both way close. Yeah.
And now I think we are
Good one. Always good to talk with you, T. Sure. Elephants. Yeah.
Has that been the subject of some analysis for the other academics that have looked into that?
Yeah, I mean, I wrote a book a couple of years ago about ISDS reform in ASEAN, and we talked extensively about this elephant really sort of inhibiting coherent or comprehensive reform in the region because of what was called the spaghetti, it's sometimes called the spaghetti bowl, this web of agreements that you change one, it's like whack-a-mole.
Yeah.
You change one, but another one pops up because it hasn't been changed.
And there's no room for the analysis being that what's come since is sufficiently comprehensive, but there's an implied wave from previous provisions.
No, because frankly, actually, some of them specifically say that they do not. They don't. And I don't think you could do a sort of law of treaties analysis that says this is a superseding agreement. Because there's really no indication, and they all recognize it.
Yeah. So there's a sort of consensus that the elephant is there, rather than some people say it is, some people say it is.
I think that that's right. I don't think what I was saying was controversial in terms of a legal analysis, and it's just from the political perspective. It's not going to change anytime soon. It's the world we live in.
Thank you so
Pleasure.
So much.
Where were you on the bench in the UK?
I am.
You are still on the bench.
You come across that?
Well, I actually worked on a project to help Botswana establish a specialized ownership court, and ended up finding valuable the materials produced by the international group. I can never remember the acronym. Yes, exactly. Oh, right. Well, I understand, having done that project a year and a half, I understand from talking with them a couple of months, that they are indeed moving ahead. And I had encouraged that. I couldn't remember at the time observers, but I did encourage them to reach out.
They have closed down. They aren't as participative.
And I did suggest to them that, I can come up with ideas for you and present them about the things. You have this great resource where you get peer-to-peer learning and advice. You can't do what the Queen's Bench does, overnight. But start with other compliments, small examples.
What we did do last year, went sufficiently well. I put some of the ideas and those who sort of from the place. I think they'll do the same again. There's a network called Arbitration.
Okay.
But this is superb. If you're the only study
I do a lot of consulting around the world, but yeah, the encouraging thing is they had a champion. It wasn't just a consultant coming in and saying, the Chief Justice was champion because he sees the backlogs of their caseload and is looking for ways out.
You can make a difference. That's literally. Right. What do you call his name? Sorry,
I'm poor with African, remembering African names. Yeah, I don't have it off the top of my head. Oh, well. CJ is of course in there. Last year, he and the Chief Justice of Indonesia organized a workshop, three-day workshop for judges from around Asia to talk about case management systems, IP issues, substantive and procedural, and then asked me to talk to judges about how investment treatments actually apply to what they do. Judges are often look very shocked when they realize that, wait, someone could be looking over my shoulder.
That's great. The university yourself and to have that within jurisdiction, that's what we're talking about.
That's kind of the purpose. Met something called the Center for International Law. Our idea is academic, rigorous research with practical policy application. And my background is practice and government work.
So, you referenced
I was at Arnold and Porter in New York for when I started, and I went to Untitled for 1 year, and then I was at the U.S. State Department. And then I decided I want to work for myself. I want to be an academic.
That's what it's like
Sort of. I mean, I'm in a good position. I get to pursue the projects that I want to, and I'm interested.
Yeah, there's some of the realities we're going to do. Yes, yes. Yes. What we can read is you work for the yeah, that's something. Yeah. Yeah. Yes, that's the thing where we are. With our process specific how they say utilize their resources there. Yes, yes, correct, yes, yes, correct. Yes. What the rules during object.
Yes, exactly.
Perfect setup. Great. Okay.
Hi, nice to see you. Good to see you. Uh,
So you saw my notes? Yeah, yeah. Okay, great. Yeah. Oh, I thought you were in this session. My apologies. We have so many panelists.
Hello, Professor Lee. Can you hear us?
Yeah, there's 9
Yes, I can hear you well. Can you hear me?
Yes, loud and clear, and we can see you. Great.
Great.
So
Can I try
we're
sharing my presentation?
sure. Please go ahead.
Thank you.
Sure. Yeah. Well, that's quite a lot of places to go. Interesting trips.
Can you see my shared screen?
Yes, yes, we can see them. And
Thank
then
you.
just
I'll just
please,
stop.
is this in full
Yes.
screen?
Sorry? Did you want me to stop sharing or?
We can see your slides, but could you make it full screen?
Full screen. Let me try. Is it better or is it not enough?
Um, it's a bit small.
Small. Okay.
Yeah. Yeah. Well, I'm in the procedure. Exactly. But I still work.
Now it's clear. It's better now.
I see. Okay.
Okay, so yeah, we'll be starting with a keynote speech from Claudia Salomon at 1:10, so in about 10 minutes.
Yes.
And then
Yes.
it's 15 minutes, and then after that, we'll proceed with session 7. So
I see.
Professor Jansen will introduce Professor Amnart, and then you as well.
I see. Thank you very much.
Okay, thank you. We'll see you shortly.
If I remain this size, is it too small?
Yeah, this view is too small.
I see. Okay.
The previous one was better,
I see. Thank you.
if possible. Thank you. We'll see you shortly.
Yeah.
Nice meeting you. Okay. Thank you. For this session, we have 9 panelists. Me too. Yeah, plus 2 speakers, plus me.
Right. I think it's actually 11 total.
Yeah, that's us.
11 total, right?
Yeah.
So 8 panelists, 2 presenters.
Oh, did we just? Maybe we. I thought we had 900.
So 8 panelists, 2 presenters, and moderator, right? Yeah.
I'm going to prepare then tomorrow.
Yes, exactly.
Let me just tell you. Okay.
Sorry, I'm not too much shared, but yeah.
Yeah, okay. Yeah, as long as we have to share. Okay, yeah.
Yeah, for now, I'm like this. Okay.
Well, no.
No, I think the last session was pretty good. Only this morning. That was
It was refreshing.
refreshing. That was refreshing. That was actually.
Yeah.
Yeah.
Someone additional thing. Oh. Okay. Right.
Yeah. Two people online.
Yeah.
That's to be behind.
only half a day, and then you can relax.
Indeed.
That's
For
allowed.
most of the people here, actually.
Well, actually, it continues tomorrow, doesn't it, for some?
For some, exactly. Just for the ASEAN member states, it's representative. Yeah.
So your duty then,
You're leaving tomorrow?
I'm leaving.
Okay. Okay.
But you're involved in that too, are you?
I will be here, not actively emceeing for tomorrow, but I will be around. Yeah. Making sure that everything goes smoothly.
How long have you been working with ADBI?
It's been a year.
And is it a fixed term thing, or you here?
No. Well, yes, it is a fixed term. Yeah, indeed. So it's a couple of years usually.
Okay.
Yeah.
Okay. And what's the plan after that? Have you formed one? What do you want to do next?
Oh, what I want to do next? Well, I'm Italian, so I am considering possibly going back to Europe after. Yeah. We will see. I mean, not necessarily Italy, but I am considering Europe again. I love Europe.
Europe's a very good place.
Yeah.
I commend it.
Yeah, definitely. Where are you based?
London.
Okay.
So,
You understand my feelings.
Not quite as beautiful as but it's
But
a
yes,
good,
it's
it's a, mind you, it's
definitely.
what a aren't we lucky to have the chance to be in these different places?
Yeah, I mean it's a very enriching experience, and especially when it's like a limited amount of
Hello,
time
Miss.
that you know
Can
that
you hear us?
it is. You can get the most out of it. Really.
Hi, I hear you very well. Do you hear me clear and loud?
Working on it, yes. I mean,
Yes, loud and clear, and we can see your video as well.
Okay, thank you very much. Do I have to turn on the video throughout the entire session, or can I turn the camera? No,
Maybe just
I'll definitely follow your
just during the
instruction.
panel part.
Just for the no, okay, so it will be Claudia's keynote speech first, right?
Thank you.
Yes, so we'll have the keynote speech first, and then session 7.
Okay, and can I change? I'm sorry, I wanted to change my name. So it's shown as Youngshin KCAB International. Is this workable with you?
Yes, you can, if you right-click on your name, then you can
No, I
rename
already
yourself.
changed myself. I'm getting your post approval. Sorry about that, but I already changed, so I
Okay.
just wanted to confirm with you whether this is
Okay.
workable.
Yes, we can see it.
Okay, then I will turn my camera off, and then I'll turn it on when Jensen starts some moderation for panel 7.
Great. Thank
Okay,
you.
thank you very
See you in a bit.
much.
Thank you.
Thank you.
Welcome back, everyone. Please take a seat. We're ready to restart with this afternoon's sessions. I hope you enjoyed your lunch break. So let's now continue with the program for today. I am very pleased to introduce Ms. Claudia Salomon, President of the International Court of Arbitration at the International Chamber of Commerce. Ms. Salomon is the first woman serving as president of ICC in its 100-year history. She's a leading arbitration practitioner with extensive experience in some of the most complex and significant disputes. Today, she's joining us to deliver her keynote speech that will explore how to attract foreign investments through international investment contracts rather than the current framework of investment treaties. This will set the scene for the session that will follow. Ms. Salomon, when you're ready, the floor is yours.
Hello to all of you, distinguished guests. Dean Jung, thank you so much for having me. It's really a pleasure to get to connect with all of you. When I speak with government officials from around the world, whether in Asia, Africa, or elsewhere, I hear one common theme. They are focused on attracting more foreign investment. And why is that? Because foreign investment plays a vital role in contributing to economic development, generating employment, facilitating the transfer of technology, and providing benefits to host states. but there has been a growing recognition that the traditional architecture of investment protection focused primarily on the bilateral relationship between investors and the state fails to adequately account for the broader societal context in which investment projects operate. Investment projects, particularly those of significant scale and duration, inevitably affect a range of stakeholders beyond contracting parties, including the local communities, workers, indigenous peoples, and the environment. Many of the current bilateral investment treaties, BITs, were negotiated in circumstances that have since evolved substantially, economically, politically, and in terms of the expectations placed upon both states and investors regarding sustainable human rights and environmental protection. Concerns have also emerged that traditional investment treaty protections, while successful in attracting foreign investment, may in certain cases have unduly constrained states' regulatory freedom or created imbalances between investor rights and the broader public interest. So it is against this backdrop that UNIDROIT and the International Chamber of Commerce Institute of World Business Law, led by Eduardo Silva Romero, have been working together over the last few years to jointly develop an instrument to respond to the recognized need for a comprehensive, balanced, internationally harmonized guidance on international investment contracts. And those are known as IICs, which is different from the ICC, International Chamber of Commerce. So I'll try to keep my acronyms straight. International investment contracts, IICs, have a unique position in the landscape of transnational commercial relationships. These contracts typically concern public interests, public purpose, and frequently involve the exercise of public authority, the allocation of public resources, and sustained interaction between private investors and state officials. IICs are also typically long-term and high-value agreements, and that necessitates particular attention to issues of sustainability, predictability, and the management of changes over time. We had not identified any instrument, any document that provides tailored guidance specifically for investment contracts concluded directly between states or state-related entities and foreign investors. So the ICC UNIDROIT instrument thus aims to fill this gap by providing principles and model clauses, both accompanied by detailed commentary that address the issues relevant to such contracts. And this should assist all contracting states, state enterprises, or investors in negotiating, drafting, interpreting, and performing investment contracts in a manner that reflects contemporary best practices and achieves an appropriate balance, right, between the legitimate interests of all stakeholders. The instrument solves three major problems with current international investment law. First, BITs contain protections that are perceived as vague, subject to varying interpretations, and thus they create inconsistent interpretations and approaches by the arbitrators deciding the claims. These international investment contracts, however, set precise rights and precise obligations that are negotiated and agreed upon by both parties. Second, the instrument avoids the asymmetries that have sometimes characterized treaty-based investment protection, where investors enjoy all the rights without corresponding obligations enforced against them. Under the current network of BITs, only the investor and not the state can typically bring a claim, and states do not typically have the right to bring counterclaims. Contracts, however, are bilateral by definition. both the state or state-related entity and the investor undertaking contractual obligations, and both have access to contractual remedies in the event of a breach. This means that the state may bring claims against the investor or bring counterclaims. One high-level government official told me recently that his country is used to playing football, and they're used to playing defense. So it was music to his ears to hear that with an investment contract, rather than a BIT, they could also play offense. So the third problem with the current investment framework that the instrument aims to solve is the imbalance between investor rights and broad public interests. The instrument provides a contractual mechanism that gives a level of protection for investors that's functionally compared to what is traditionally in BITs, while simultaneously reflecting the current state of debate on the appropriate balance between investment protection and other legitimate policy objectives. Contemporary investment agreements increasingly incorporate provisions addressing environmental protection, labor standards, human rights, anti-corruption, and sustainable development in general. The instrument also draws upon and advances these developments, integrating sustainability considerations as a core element of the contract, rather than as an afterthought or optional addition. In doing so, it seeks to demonstrate that robust investor protection and meaningful sustainability commitments are not mutually exclusive, but can and should be pursued together in a balanced and coherent manner. So given the long-term, high value, and complex nature of international investment agreements, disputes are inevitable. So how does the instrument propose that these disputes be resolved? There's 5 key elements to keep in mind, and let me go through those. First, the goal is to ensure that disputes are resolved effectively and predictably. To that end, the instrument favors a multi-tiered approach that prioritizes amicable settlement as the first step before escalating to binding adjudicatory mechanisms. And this approach aligns perfectly with the theme of today's conference, institutionalizing mediation and other forms of ADR and ISDS management. IICs are fundamentally long-term cooperative relationships in which the preservation of the investment relationship is itself a value worth protecting. So direct negotiations between the parties, mediation, conciliation, expert proceedings, and dispute boards are each recognized as valuable tools for resolving disputes without the costs, delay, and adversarial dynamics that formal proceedings entail. At the same time, the instrument does not impose mandatory sequence processes. The model clauses are intentionally flexible, allowing parties to structure the dispute resolution sequence according to their specific needs. Second, what is the forum for binding dispute resolution if the ADR is not successful? Now, while some parties and states may prefer to resolve disputes in their domestic courts, investors frequently consider a neutral third-party mechanism to be of paramount importance. And international arbitration is identified as that mechanism that most naturally responds to this concern. The instrument does not prescribe a single arbitral institution, but instead provides flexible model clauses that accommodate a range of options, including institutional arbitration such as ICC or ICSID, and ad hoc arbitration under the UNCITRAL arbitration rules, leaving the choice to the parties. Third, what about the governing law? In arbitration, parties enjoy substantial freedom to choose non-state rules of law, including soft instruments such as the UNIDROIT principles of international commercial contracts, known as UPICC, as the rules on which the arbitrators are to base their decisions. But even in the states that require their own national law, as the governing law of a contract. The parties to an IIC may incorporate those principles in the instrument as terms of contract. Fourth, the risk of parallel and overlapping proceedings is also addressed. Given that investors may have access to multiple fora, including treaty-based arbitration, contract-based arbitration, and domestic courts, the instrument encourages parties to designate one exclusive dispute resolution forum in the IIC and to explicitly waive their rights to pursue dispute resolution elsewhere. Parallel proceedings increase costs, decrease predictability, and may lead to conflicting decisions, all of which are detrimental to the stability of the investment relationship. Fifth, the public interest dimension is also relevant. Issues of transparency and conflicts of interest in arbitral proceedings are addressed in recognition of the legitimate interests of states and other stakeholders in the conduct and outcome of proceedings that affect public resources and public policy. At the same time, the instrument does not prescribe a uniform approach. Instead, it encourages parties to consider the procedural rules applicable to their chosen arbitration forum and to reach an informed agreement on the degree of transparency or confidentiality appropriate to their specific context. So let me tell you a bit about the model clauses and next steps. A distinctive feature of the instrument is the inclusion of model clauses alongside the principles and commentary. The model clauses are designed to be of immediate practical utility for negotiators and drafters of these contracts, providing a common starting point for negotiations. They can help level the playing field between the parties with unequal bargaining power and can reduce the transactional costs associated with drafting such agreements. But I want to emphasize this. The model clauses are not intended to be adopted without consideration of the specific circumstances of each investment project. Instead, they're designed to be adapted to the specific needs of the parties. Now, in terms of next steps, the comment period will soon open for states to provide their input on the draft instrument, and the aim is to release the instrument by the end of 2026. So I urge all of you to provide your comments. And once released, we'll also have extensive training programs about the instrument. So it is my greatest hope that this instrument will be a valuable additional tool to help each of you attract further foreign investment and resolve your disputes peacefully. So before I close, let me leave you with this thought. More than 100 years ago, the founders of the International Chamber of Commerce wanted to foster more cross-border trade and investment with the belief that if there was more cross-border trade, there would be more peace and prosperity. They called themselves the merchants of peace. They also understood that international investment and trade would not increase unless there is a trusted mechanism for parties to resolve their cross-border disputes. And that is why these merchants of peace then founded the ICC, International Court of Arbitration, in 1923, that I have the honor of leading. Parties from almost 150 countries trust ICC arbitration for the resolution of their disputes. Almost 25% of the parties come from Asia Pacific, and this includes a wide variety of states and state entities. In this rapidly shifting, extremely uncertain geopolitical environment, a trusted, independent, and impartial mechanism for the peaceful resolution of disputes is more important than ever. When we consider the types of disputes that arise in our cases, with 40% of the cases involving construction or energy, these are cases that involve precious resources with states and state entities. that in another context might not be resolved by arbitration, but instead by war. Now, at the ICC court, we want to ensure that all of you have the tools you need to resolve your disputes efficiently, effectively, and peacefully. Thank you very much.
Thank you very much, Ms. Salomon, for this very insightful keynote speech highlighting the important role, the great value that these instruments can bring. So let's now continue and move into the discussion with the topic of arbitration management. This next session is titled Management of Arbitration and Building Sustainable ISDS Management Systems. To begin, please welcome the moderator for this session, Professor Jensen Calamita.
I feel a bit like Richard Nixon. You can't quite get rid of me yet. Let me just begin by calling up our one speaker who's in the room, Professor Amnart from Thailand. Please come and join me on the stage. We have 9 panelists, so I'm afraid we don't have space to include all of the panelists at the outset. Otherwise, you wouldn't be able to see the presentations. But let me just start with a little overview. It's been mentioned this session is about managing investor-state disputes, and particularly investor-state arbitration from the state's perspective. And I begin with just a very short story. It was the 30th of October, 1998. It was 4 years after the North American Free Trade Agreement had come into force. This was the first regional trade agreement to include an investment chapter. And the United States received a claim from a Canadian investor named Lowen, who complained that he had been denied justice through the judicial system of the state of Mississippi. I don't know if any of you have ever been to Mississippi, but if you've been to Mississippi, you can see perhaps his claim was plausible. The problem for the United States was that it had never thought about what would happen if it received a claim. It expected that American investors would bring claims against Mexico or Canada, but not that it would receive a claim. And so consequently, there was no agreement within the US government as to who would represent the United States in responding to this claim. And that led to a dispute between the Department of Justice on the one hand, which represents the United States in proceedings in the federal courts and the state courts, and the Department of State, which represents the United States in international proceedings. And ultimately, the parties battled it out, the two agencies battled it out, and it took 2 years. And it required the decision of President Clinton to finally give exclusive authority to the Department of State. Now, during that time, the United States made a jurisdictional objection that to this day, I'm sure they wish they had never made, and they claimed that the actions of a court were not reviewable as a matter of public international law under the NAFTA. In any case, from that very fraught beginning, the United States has developed a standing and robust system of defending itself in investment treaty claims. And for many states, that's the position they often find themselves in today. What do we do when we have a claim? Who will respond? How do we respond? What's the most efficient way for us to respond? So that's the general landscape within which our discussion takes place. We have a great selection of panelists and 2 brilliant speakers. Professor Amnart, let me start with you and turn things over to you for your presentation. Thank you.
Thank you, Professor Jensen. It's interesting that you raised the Loven case. The case was so interesting, including the appointment of arbitrator by the U.S. Judge Mikwa. Good morning, everyone. Thank you, the ADB and ADBI, for having me. It's a pleasure. So my presentation, I think this is the first and only session maybe that we're gonna focus on arbitration. So my presentation will be separated into two parts. The first one will touch upon the process of arbitration in general, just for those who may not be so familiar with the arbitration processes in ISDS, investment treaty arbitration. And the second part will draw some lessons and also share with you some of the experiences that Thailand has developed post cases that we have faced in the past 15 years. So this slide shows you kind of like the summary of what's going to happen in an arbitration. Of course, it does not intend to be one and only kind of arbitration that you will have in investment treaty arbitration, but the process should look like this. So of course you have the pre-arbitration phase, right? When you have all the ADRs, you have multi-tier arbitration clause in the investment treaties. Maybe you are asked to do negotiation or conciliation for, let's say, 3 months or 6 months before the investor could proceed to arbitration. And that applies to many treaties that Thailand conclude actually, and also ASEAN member states in ASEAN treaties, right? And then we move to the commencement of arbitration, and now it depends on the rules or arbitration rules that govern your arbitration. So normally it would be like ancestral arbitration rules. It would be ICSID arbitration rules. In some cases, ICC arbitration rules, for example, how to commence the arbitration. And then in this stage, you have to appoint arbitrators, and then you have the first meeting that you will have to discuss what would be the process of this arbitration. And then you have to decide whether you will bifurcate the case or not, whether you want to discuss jurisdiction first before moving to the merits. So as you could see here, just at the commencement of the arbitration here, there are many things that you have to consider already. And as Professor Kalamita mentioned yesterday, coordination is the most important thing. And I would encourage that you set up the home team quite quickly at the start, right? Not when the notice of arbitration was filed against you, but maybe you should consider having this home team set in place, maybe at the time of the notice of dispute, for example, or even before that. So that's one thing that you should consider. And when we talk about the team setup here, Thailand and many other countries may not have the privilege that the USA have, that you have like internal team that could handle the case from the start to the finish. So you may want to consider having external counsels helping you with running the cases as well. And in this kind of like preparation phase, there are a few things that you should consider: factual investigation, personnel charting, who are involved in the disputes, who are the triggering authorities, who are the one who's supposed to make decisions, for example, and then document gathering, information gathering is important. And bear in mind that throughout the whole process of arbitration, mediation, conciliation, or negotiation are still possible. Settlement are still possible along the way. So you can have mediation in parallel of arbitration. And even even after the award is rendered, negotiation is still possible to have a settlement. So after the commencement, you have like proceedings. Normally you have like submissions of the states and investors. Investors go first, obviously. And normally in investor state arbitration, you have the memorials format. That means everything will be in the submissions instead of just putting kind of like a skeleton into the pleadings or the pleading style that you see in commercial arbitration. So you should be mindful of that. And then there may be document production after the first round of exchange of written submissions. I forgot to mention that normally there will be like 2 rounds of submissions: statement of claim, statement of defense, reply, and then rejoinder. So there will be document production in between. And then of course you will have hearings. You will need to do witness preparation, for example. And after the hearings, there will be closing submissions, cost submissions. The arbitrators will deliberate, and then they will render the award. After the award is rendered, you have to think about the next step, whether you would comply with the award in case that you lose, or whether you want to file an annulment proceedings, either in ICSID or in domestic court. depending on the regime, New York Convention or ICSID Convention. So many things to consider here, and that's kind of like a snapshot of how arbitration may look like. Next, let me move to the experiences of Thailand to share with you a bit. So we have had about like 40 to 50 effective international investment treaties. About 80% of them are BITs, and then we have like treaty with investment provisions or FTAs with investment chapters. We have signed the ICSID Convention in 1985, but we never ratified it. But there's now a commission set up to consider whether we would ratify it or not at the present moment. So that means many BITs or FTAs that we conclude, even though they have ISDS clauses allowing the parties to go to arbitration, in particular ICSID arbitration, you cannot use it at the moment. So far, we have had like 2 ISDS arbitrations. The first one was with Germany starting in 2006. Not many people know about the case until the enforcement process, whereby the airplane of the Crown Prince was seized in Germany, and that stirs some news in the outlets. And the second case was the King's Gate case against the Australian company. So for the first case, we lost, and we were ordered to pay about 30 million euros plus interest. And in the King's Gate case, the case was settled, and I will touch upon the settlement thing a bit later. So you may wonder what happened to us after we have had these 2 cases. I have to say, after the first case, the water bowl case, I don't think there's much development. There's not much thing to do in terms of institutionalization. I would argue that institutionalization of ISDS mechanism in Thailand start after the King's Gate case. But in any case, the fact that we had the first case of water bowl brought us some benefit because more people are interested in the subject. And for example, myself and one of my colleagues who from Thailand here, we got government scholarship to pursue our PhD to do international investment law, so that now we have some know-how to deal with the matter today. After the King's Gate case, we start having the institution that deals with the matter. Even though like the King's Gate case commenced in 2017, we adopted this regulation of the Office of Prime Minister in 2019 to set up the Committee on International Investment Protection. So I would say it's quite similar to what South Korea is doing at the moment, to have some centralization so that when there's an issue, the triggering authority will have to notify this committee that a dispute under investment treaty has arisen. And this committee comprises 20 high-level representatives all across departments, led by the Deputy Prime Minister. And then there's Minister of the Ministry of Foreign Affairs, and then permanent secretaries of various departments in Thailand sitting in one place. So there are 3 functions of this committee: policy development, dispute prevention, and dispute management. So these are their 3 main goals. Of course, the committee, because they comprise of high-level representatives, they are quite slow. So we set up also subcommittees so far. So far, there are 2 subcommittees. One deal with policy development, and one deal with dispute prevention and dispute management. And then whenever a case arises, we set up a separate ISDS working group to deal with that particular case. And that's what happened in King's Gate, the second case that we had. And also, I would argue that because that we have this kind of like committee in place, we were able to settle the dispute with King's Gate because there's kind of like a resolution of this committee saying that settlement is possible to avoid criminal liabilities or liabilities of the people who make decision to settle, something that challenges in terms of mediation. Last point that I want to make is Thailand's involvement in international forum, in particular the Working Group 3. So Thailand so far, because of our experience in the water bowl case quite early in 2006, we have been active participant in Working Group 3. We have submitted a few working papers. From my observation, our main concerns would be time and cost, and the state's position, disadvantageous position to make our defense. So that's why we propose some potential possible reforms, including the Advisory Center on International Investment Dispute Resolution. As Jay mentioned yesterday, the statute was about to be endorsed by the Ancestral Commission later this year, and we hope there will be a decision on where the headquarters would be in the near future. And that concludes my presentation. Please let me know if you have any questions. Thank you.
Thank you very much. You have set the standard for keeping the time, and let us try to do that as well. And really just hitting on the crucial point that we've addressed, I think already, coordination and planning being such key components to the state's ability to respond effectively in situations involving investor grievances and especially investor disputes. Let me turn now to Professor Hae-Min Lee, who's joining us online from Seoul National University to talk about Korea's experience. Please, Professor Lee, go right ahead.
Yes, thank you, Professor Jansen, and good afternoon, distinguished colleagues and panelists. Thank you for ADB and ADBI for inviting me. I regret not being able to join you in person, but it is a great honor to participate in this dialogue, which I find particularly meaningful, both globally and personally. I personally obtained my master's degree on ISDS like 15 years ago, and actually it was about the law and case and the denial of justice. And since then, while serving as a judge and later in academia, I have been engaged in ISDS-related work, including participation in ancestral working groups. And through these experiences, I have observed an important shift in Korea. What was once characterized by concern and skepticism toward ISDS is gradually evolving into a more structured and confident approach to its management. Based on this experience, I would like to share how, drawing on Korea's experience, a systematic approach and capacity building at the state level may contribute to reinforcing ISDS as a legitimate and effective dispute resolution mechanism. As has been laid out in many presentations, just a second. Yes, as has been laid out already, there is a clear need for systematic ISDS management. ISDS cases often involve significant financial exposure and regulatory implications. They also attract a high level of public scrutiny and sensitivity, and yet governments frequently face fragmented responses with issues and evidence dispersed across multiple agencies. Against this background, I would like to briefly outline an ideal step-by-step state approach to ISDS. First, at the treaty design stage, it is important to carefully structure dispute settlement clauses and define clear jurisdictional requirements, such as exhaustion of local remedies rule. And second, dispute prevention is critical, as was well elaborated in yesterday's discussion. And this includes raising ISDS awareness across government institutions and establishing screening and early warning mechanisms, particularly in relation to large-scale investments. And third, and this is the main focus of today's presentation, once a dispute arises, the state needs an institutionalized case management system that ensures consistency and effective coordination. And finally, from a forward-looking perspective, states should actively engage in broader ISDS reform discussions, such as promoting transparency, and that includes third-party funding disclosure, and ensuring fair adjudication, and contributing to ongoing discussions on enforcement, appellate mechanisms, and even investment court. Let me now turn to Korea's experience, which may offer some practical insights. Korea has been a respondent in several major ISDS cases, and overall, it has managed to defend these cases relatively successfully. In many cases, although the claims were substantial, the claims were either dismissed or the amounts awarded were significantly lower than those claimed. Moreover, recently, the award in the Lone Star case has been annulled in ICSID annulment proceedings, And in Elliott case, the word has been set aside and remitted by the English courts. These outcomes were possible due to strategic case management at the government level. And let me highlight some key suggestions that may be of particular interest. First, coordination at the state level is essential, and this may involve combining interagency coordination mechanisms with a standing unit responsible for ISDS matters. In Korea, this took the form of an intergovernmental committee for policy consideration, alongside with a dedicated division within the Ministry of Justice, staffed by competent prosecutors who are actually with us today, that handles dispute prevention and case management. And second, strategic case management is crucial. This includes transparent selection of external counsel, a strong government-led oversight, and maintaining a consistent legal strategy across all stages of proceedings, from pre-arbitration to post-award phases such as enforcement or annulment proceedings. For instance, in Korea, counsel for each case is selected through a competitive and transparent process, and local firms are typically encouraged to make partnerships with international firms. And in this way, the legal expertise can be retained and accumulated domestically. Mediation may be considered as a viable option. This, however, requires two conditions: a thorough legal assessment of the case and a decision-making environment that allows for good faith settlements without undue political consequences. Third, the role of the judiciary deserves attention. In Korea, judges have not only been trained, but also have contributed through research activities and participation in international discussions, thereby supporting long-term capacity building in ISDS. If I take my example, during my time as a judge, I worked with other judges to publish a book on ISDS with the support of the Supreme Court. And I also participated in the UNCITRAL working group discussions and research. Let me conclude with a brief remark. From the perspective of respondent states, ISDS can impose significant financial burdens and may also constrain regulatory space, and effective management is a key to address these challenges. It requires building institutional capacity, ensuring coordination across government, and approaching disputes strategically over the long term. And in this sense, ISDS management is not only about litigation, but also about governance. And ultimately, such an approach may help strengthen confidence in ISDS as a fair and effective system for resolving investment disputes. Thank you very much, and I look forward to the discussion.
Thank you very much, Professor Lee, for your presentation, which I think, again, reinforces the concepts of coordination and planning, also highlights the way these things tend to evolve within government as experience and lessons are learned. We have 9 panelists, so let me invite them to come and join us on the stage. Our panelists come from government, they come from academia, and they come from centers for dispute settlement and arbitration. Given the numbers and in the interest of time, I've asked them each to be brief in their remarks. We're going to start off by hearing from our colleagues from government, again, to share their experiences about the organization of the state's representation, the management of that representation, how things have evolved over time, ways in which, as one colleague once told me, never let a good ISDS case go to waste. How can the state actually take benefits from the experience of being sued so that next time it can represent itself more thoroughly, more cost effectively, and more knowledgeably? As we'd organized this, I'm not going to be able to introduce all of our speakers right at the beginning, so let me do that as we come along to them. But let me start off with our colleague from the Korean Ministry of Justice, which, as it turns out, I hope Professor Lee hasn't stolen too much of your thunder. But perhaps you could share with us some further insights on Korea's developments.
Yeah, thank you, Professor Kalamita. Good afternoon, distinguished colleagues. I am Junior Alex Yang, a public prosecutor and team leader at the International Dispute Settlement Division of the Korean Ministry of Justice. Some of you may have attended Korea's presentation yesterday evening where I presented Korea's three-level whole-of-government ISDS response system and our recent case outcomes, including 4 consecutive ISDS victories in detail. Today, rather than repeating that presentation, I'd like to engage directly with the questions Professor Kalamita has framed for this session, drawing on Korea's practical experience. Regarding question 4 and 5 on over-dependence on external counsel and knowledge retention, they are perhaps the most important structure questions for developing member countries. Let me address the problem first, then Korea's legislation solution. First, the problem is well described in our session brief. When cases are handled on a one-off basis through external firms, you lose institutional learning. From Korea's own experience, I would identify 3 specific problems. First, knowledge walks out the door. When a case concludes, the firm's partners move on, and the government state starts from zero on the next dispute. Second, costs escalate unchecked. Without strong in-house expertise, the government cannot effectively challenge billing. And third, and most dangerously, legal positions become inconsistent across cases. Thus, Korea's solution has been to build permanent in-house capabilities. Our KMOJ's ISDS division functions as the state's own law firm, maintaining comprehensive internal records for every case so that institutional knowledge survives personal rotations. But here is the crucial point. Until recently, this system rested on administrative presidential directives, which can be weakened by any incoming and changing administration. To make it permanent, Korea is now pursuing legislation, the draft bill. In March 2026, Korean Representative Park introduced the bill on the prevention and response to international investment disputes in the Korean National Assembly. Let me highlight 5 elements of this bill that directly respond to the challenges we're discussing. Number 1, 5-year strategic planning, requiring the Minister of Justice to formulate a basic plan for ISDS response and prevention every 5 years. Number 2, budget accountability. The triggering authority, which causes the ISDS dispute in the case, must bear the legal cost and damages award, creating a direct incentive for dispute prevention. Number 3, expanded institutional coverage, extending the framework beyond the executive branch to cover all state organs, including legislation and judiciary. 4, statutory data collection authority. The bill gives the Interministerial ISDS Response Task Force, led by Ministry of Justice, a statutory basis to request information and materials from all government agencies, overcoming bureaucratic friction between ministries. Number 5, professional capacity building, designating specialist training institutions for ISDS professionals with governmental financial support. We believe this kind of legal codification is the key to making ISDS management capacity truly sustainable. And next, regarding question 6, effective dispute management. Rather than repeat yesterday's case details, let me briefly share examples and then explain the institutional system behind them, since Professor Kalamita has asked us to develop economies to indicate how we build our approach in ISDS response. Each of our 4 recent victories succeeded for different technical reasons. In the Lone Star tournament, isolating a precise due process defect against 1.6% annulment odds. And in the Schindler case, coordinating evidence across 3 separate regulatory agencies to demonstrate legitimate regulatory authority of Korean government. And third, in the Chinese investor Min case, identifying the illegality of the claimant's investment, which was corrupted and obtained by bribery from the outset, and pursuing this legal theory rigorously throughout the proceedings. And in the Elliott case, initiating and sustaining set-aside proceedings in UK courts, even though there are a lot of negative outcomes to Korea by a senior level committee decision-making. But the common factor behind all four cases was institutional architecture of Korea. Let me briefly outline what this looks like in practice, Korea's three-level whole of government system. At the top level, an interministerial committee at the vice ministerial level provides strategic direction, which is similar to the Thailand investment committee. At the second level, a case-specific task force composed of senior officials from all relevant agencies ensures interagency coordination, translating strategy into actionable coordinated positions. And lastly, at the working level, our ISDS division in the Ministry of Justice functions as the state in-house law firm, staffed by prosecutors and lawyers. We manage day-to-day case conduct, instruct external counsel, control cost, and maintain a permanent institutional knowledge base. This system was not built overnight. Korea restructured its approach in 2019, like Thailand, designating the Ministry of Justice as the control tower for ISDS defense. It evolved through hard-won experience across multiple high-stakes ISDS cases. And as I mentioned, we are now pursuing legislation to make this framework permanent. The key lesson is that structured institutional capacity is what produces consistent result. If I may close with one sentence, Korea's experience shows that sustainable ISDS management requires not only winning cases, but building the institutional and legislative infrastructure to keep winning the cases. We would be very pleased to share our experience further. Thank you so much.
Thank you very much, Alex. The Korean example is a fascinating one, especially the idea and the concern about expertise walking out the door. And just to share one note, in the US Department of State, the Office of the Legal Advisor, all the legal advisors rotate from different subject areas to different subject areas, except for the team that represents the United States in investor-state dispute settlement. They stay together in order to preserve that kind of institutional experience and knowledge. Amanda, let me turn to you, if I might, for some perspectives from Indonesia.
Thank you, Professor. Unlike Korea, Indonesia still doesn't have a single agency to management of the SDS. But we deal with the ISDS by a coordinated government approach. At the core of the system is the Attorney General, Jaksa Pengacara Negara, that represents the state, and it also serves as the anchor of legal coherence to ensure that positions taken in arbitration are consistent with domestic law, institutional mandates, and long-term regulatory objective. Yeah, however, of course, the challenges is like the previous speaker mentions, is how to maintain the knowledge and also to ensure that dispute strategy remains aligned with the national policy priorities. Okay. For the system, I think I only can share about it, or do you need me to elaborate more about?
I mean, if you're able to share a bit more, that's brilliant. At the same time,
Just give the floor to
we have plenty of other speakers, but just in terms of Indonesia's experience, having faced a variety of claims over time and having actually been successful in those claims. But do you see an evolution in the way in which Indonesia is addressing disputes or preparing for future disputes?
Well, actually, in the investment state dispute settlements or the dispute related to the treaty, Indonesia has never been lost. The cases either win by in favor to the states or discontinue. But in the recent cases, we deal not with investment dispute, but commercial arbitrations that impact to the state's state assets in another or in not either not a party to the disputes, and I think it raises concerns among the governments, councils, legal councils, and also the attorney generals, and also the ministries and state-owned enterprises on dealing with the commercial contracts because in Indonesia, the state-owned enterprise may be presumed as the state's own, so I mean investor with not a good faith may try to claim the assets. I don't really cannot speak about the case because it's not investment disputes, but I think that even though Indonesia is win the and retain the assets of the diplomatic assets in one of that foreign country, but yeah, it raises concerns that how can commercial arbitrations decisions can impact a state, and it also raises the concerns on forum shopping, not merely treaty shoppings. I think that's the recent developments, but not in particular ISDS case. Thank you.
Thank you very much. I mean, you do raise a very important point, which is that sometimes the value of a commercial arbitral award against the state can be equal, if not larger, than an international investment treaty award. We're focusing, of course, on treaties today, but we shouldn't lose sight of that other potential exposure. Anwar, let me turn to you because Uzbekistan has been doing some very interesting things.
Thank you, Professor. Good afternoon, everyone. I will be go briefly because yesterday I already mentioned some ICDS mechanisms. So I want to speak from a very concrete vantage point that Uzbekistan has about 20 international investment disputes on its books, and in every case, 70 to 90% of our arbitration costs have gone to outside counsel fees. And until recently, each case was managed through a separate ad hoc government order that named counsel, set up a working group, identifying founding, and then dissolved when the case ended. I guess that this model was really common across DMCs, and it's precisely the model that guarantees institutional memory lives with the law firm. And the next case, yes, starts from zero, the same mistakes cost money twice. So in response, now Uzbekistan is finalizing a cabinet of ministries resolution that established for the first time a unified codifying framework for ICDS management. So under the new framework, any state body that learns of a potential or actual investment claim through an investor's written objection or a request to open negotiations or a notice of arbitration must notify the Minister of Justice within 3 working days. And the Minister of Justice then organizes Uzbekistan's legal defense in international arbitration and foreign courts, prepares a draft government order setting up the case working group, defining its mandate, and identifying the funding source. Also, Minister of Justice represents the Republic as a claimant, respondent, or third party, conducts and coordinates amicable settlement negotiations with the investor before arbitration commences, and also propose outside counsel to the Cabinet of Ministers for formal appointments. As I said yesterday, the coordinating council under the Deputy Prime Minister with the Minister of Investment, Industry and Trade as its working bodies, it's above this process to align positions across ministries and unified state position in formulating ones at the center, not separately in each affected ministry. Also, I want to give a little bit about institutional memory because I personally think that this matters most. So the resolution requires the Minister of Justice to maintain a systematic database of all Uzbekistan involved arbitrations and foreign court processings, including investigation, procedural and award materials. Analyze every final award and where relevant propose measures for its annulment, enforcement or follow-up action. Also, after each case, prepare recommendations for preventing similar disputes and submit them to the responsible state bodies. After that, drafts proposals for amending investment treaties and domestic legislation based on lessons learned. As I already mentioned yesterday, this Cabinet of Minister resolution also cover capacity building mechanisms. And also this resolution creates an incentive regime also, and responsible officials whose work on case documents and processing contributes to an outcome favorable to Uzbekistan can be rewarded. I think it's good case management should be professional, visible, yes. And I also mentioned about dispute avoidance protocol with TIAC, so Minister of Investment are working closely with Tashkent in arbitrational court, and we are now drafting the document which covers cooling off periods, also mechanisms. Thank you.
Thank you very much for those insights. I mean, I guess a lot of these presentations also emphasize how important it is that there be some kind of legal instrument within government that sets out these arrangements and makes lines of authority and responsibility clear, whether it's regulation or legislation or so forth. And obviously highlights that ad hoc arrangements tend not to serve the state best. Let me turn to our colleague from Japan, Shohei. Let me turn things over to you. Thank you.
Thank you, Professor. So my name is Shohei Nishimura, Director of International Legal Affairs from Ministry of Economy, Trade Industry. So thank you for very interesting comments from other countries. Honestly speaking, well, Japan is less experienced in terms of the number of disputes, including ISDS cases. So mostly, well, I have to learn from other government. But considering the potential cases or potential disputes, Japan has to share the concerns related to, let's say, how to handle the cases in the future, and what is the most efficient way to handle and address the investment treaty issues. So Professor fantastically listed up the, for example, 3 potential problems caused by, for example, too much dependency on international law firms. Of course, well, dependency with the international law firm is actually necessary in terms of system of ISDS. But these 3 problems are really illegitimate. And I'm going to say, firstly, statutory or institutional knowledge loss, which some of the co-panelists already mentioned. Knowledge loss is, yes, it's a problem. And well, my comment is that Professor Jansen talked about some rotation approach. And I have to confess that including a legal sector, Japanese government officials are rotated almost every 2 years, so including myself. So we must admit that the institutional knowledge will sooner or later lost or decreased. But admitting that reality, recently Japanese government, or I would say Japanese lawyers, may change the mindset. Let's say, well, let me put it this way. So institutional knowledge, consider the institutional knowledge among Japanese government in a bit broader sense. For example, including Japanese lawyers who have been involved in ISDS cases or potential disputes. And for example, some of them have been seconded to the government as part-time officials, and they have some experience, but coming back to the Japanese local firm, who may assist in new and potential cases as a local counsel or kind of assistant with the Japanese official. In that way, it's anyway inevitable that so newcomers in the legal division has zero knowledge on the what the fuck is ISDS. But somewhere in the country, there was some lawyer who has a previous experience of what is ISDS and what is the risk of ISDS and what is the policy objective which you would like to maintain. That kind of advice will be sustained. And then in a broader sense, we can keep institutional knowledge about how to address the cases. So that's not the ultimate solution, but kind of approach Japan is taking. And another point I would like to mention is that I guess this is most important, but the policy inconsistency caused by some ad hoc basis addressing of each case with the assistance of international law firms. Because, well, nowadays, some translation and interpretation cost and time will be improved because of the advancement of AI. But when I experienced some potential disputes a few years ago, some translation of Japanese legislation and all the Japanese inter-ministry meeting minutes in order to explain what was the background and what was the policy goal they would like to pursue in taking certain policy measure to international law firms who have zero knowledge about the Japanese traditional culture or the Japanese societal customary practice is really time consuming. And sometimes they don't understand what is a culture and what is a legal system or what is a real meaning of a certain Japanese administrative procedure. In that case, my experience is that if you have some Japanese lawyer in a local firm who can kind of transfer our message and translate in a true meaning into English so that foreign lawyers can present on behalf of Japanese government, understanding the real deep background of the policy goal. That is really important. So I think the educating a local firm in terms of knowledge loss and in order to ensure the policy consistency is kind of connected. And final comment is that, yeah, this is really important because nowadays my view is that the target of ISDS is not purely about the foreign direct investment. There might be some new legislation from the perspective of national security or anti-terrorism or some financial regulation, or maybe environmental reasons, to pursue a sustainable society. So if we face some disputes, our goal is not to win the case, not only to win the case, or not only to decrease the amount of compensation as much as possible, but to maintain our policy goal, maintain that our policy goal is legitimate and justifiable. In order to pursue this goal, so you need to, and all the team members, including foreign lawyers and Japanese law firms, should understand what is, in a deep sense, what was the background of this specific policy measure? And what kind of element did the government officials consider to specifically structure this target measure? And what was the process did they take? What kind of administrative procedure did you take? And how can you consider that specific process from the perspective of due process concept and in the ISDS regulation? Yeah, that's all. Thank you very much.
Thank you very much. It's very interesting. I think the Korean example and the Japanese example showing how even if people are rotating within government, you can develop capacity within the local bar. So using local firms develops that bar to assist the state in future cases. And also, of course, the importance of just record keeping of your own prior representations so that you know when you make an argument in this case, it's not completely opposed to an argument you made 5 years ago in another case. We're going to turn now from our speakers from government agencies tasked with representing the state and managing disputes to representatives from dispute settlement organizations, arbitral centers, asking the question for developing economies, how can they use their systems most efficiently and most cost effectively? Because that obviously has been one of the key concerns raised in discussions throughout UNCITRAL Working Group 3 and more generally. But I'm going to switch things up ever so slightly. I was going to start with you, Frauke, but I'm going to start with Heather, because Heather, I think you're actually going to share a little bit about the Malaysian experience in terms of government management. So let's add that to what we've already heard from our government officials.
Sure. Thank you so much, Professor. Heather from the AIAC. Of course, I don't speak on behalf of the Malaysian government. I don't have that authority to speak on their behalf, but I'd like to share a little bit of the Malaysian experience with ISDS. We have heard about Korea, we have heard about Japan, we have heard about Uzbekistan, and of course, missing the Malaysian perspective would be bad. So I would like to share a little bit about Malaysian perspective. In fact, Malaysia signed the ICSID Convention in 1966, and we actually welcome our very first ICSID case, all right, which is the ISDS proceeding against Malaysia in 1990s itself. Okay, this is by Belgium national. He actually initiated 3 cases against Malaysia on a BIT. All right, out of the 3, 2 didn't go on because he didn't pay one of it. One was decided. One was decided in favor of the government. However, in the annulment proceeding, he didn't pay as well. All right, and then the last one in 1994, that was registered in 1994. All right, we went to settlement. So the Malaysian government actually adopted this ad hoc approach of mediation, I guess, or settlement negotiation, even back then in 1990s, before the Singapore Convention is what we are focusing in this policy dialogue today. So thinking on that experience, actually, in 2025, then again, Malaysia, last year itself, Malaysia is also involved in one of the ISDS matter that it's brought under the treaty, which is called the ASEAN Comprehensive Investment Agreement, all right, ACIA. So under this ACIA, interesting fact, AIAC is also named as one of the administrative body under this agreement, all right, which means that AIAC can actually administer ISDS proceedings as initiated under this treaty. However, because Malaysia is actually the respondent in this matter, which I think was the reason why the claimant didn't proceed with the AIAC, I guess, and proceeded with ICSID. So now the progress of this matter is that it is with a tribunal appointed first, and it is ongoing. I think taking heed on the institutional memory, I guess, that Malaysians' involvement in ISDS proceedings and also eventually led to settlement as well in 1990s. I think hopefully one part of this that we can take away from this discussion is that hopefully we will achieve some amicable settlement than really going into this arbitration or going ahead with these arbitration proceedings under ICSID as well. Because ultimately, what we are looking at for foreign investment under all these treaties as well is actually to encourage the foreign investment into the country. So I think now relate back to the question posted by Professor, what are the how effective can mediation reduce the financial and procedural burdens? I guess looking at this is that if you look at the time and cost aspect of you going into the arbitration proceedings, then settling it. In these two cases I've given, in this one case that I've given, it actually got settled in within 2 years. So it didn't proceed with the whole arbitration proceeding because it got settled. All right. So if you manage to settle, of course, that would reduce the cost and of course the procedural burdens. But I have to say that mediation right now, it has you have to qualify that by saying that if you manage to settle, then it will reduce the cost and procedural burdens. But in case that you don't get to settle for ISDS proceedings, then again, it will come back to the arbitration proceedings. So I guess then a lot of other factors will come into play, whether the government or the member state on the one hand has that political view to actually settle the matter, and what are the interests on both parties as well. So if we go into mediation, it will be slightly different from arbitration, where it will be legal point arguments. When you go into mediation, of course, you're looking into more interest-based flexibility. At the same time, of course, the early assessment will be very important because you don't want to go into mediation at the very latest stage where you already incur a lot of cost. All right, so all these pre-case assessments by the Attorney General chambers, if the government is involved, all right, by the councils that are representing both parties, those are very important in coming into a position whether the matter itself is suitable for mediation at all. So I hope that answers the question for support.
That's great. No, thank you very much indeed. I'm conscious of our time and conscious of the number of panelists we have left. So, Farka, let me turn things over to you if I can.
Thank you. It's a real pleasure to be here and to have heard all the systems that you already put in place. You know, and we were talking earlier today about active investment dispute management, and there's always other things that can be done. But what you have shared from your jurisdiction, that is very far evolved. And I want to pick up on the one point that our colleague from Japan mentioned, the consultations and looking at regulatory changes and involving a broader stakeholder discussion early has been very effective in some jurisdictions. And the other aspect of prevention and management of investment disputes for the future is to have a look at the cases that you have had. Are they coming from a certain area? Do they refer to a specific agency? Are they coming from a specific economic sector? Not only how can we manage the arbitration, but what can we learn from it? And I have, by now, you know, I really like empirical data. And I have a couple of data points for you for ASEAN state parties on the left and ASEAN investors on the right. Yellow denotes settlement and blue rulings by tribunals. So if we stay on the left, there is a lower percentage than the third that we usually see in ICSID is settlements by ASEAN state parties. And if we go to the next slide, this is what I think is really interesting. On the left side, you see these are the outcomes in ICSID arbitrations. And on the left side, the ones with the ASEAN state parties. And if you find your way through all these words there, you will see that upholding claims in part or in full is 10%. And I just want to really look at that. We talk about arbitration, we talk about time and cost, but if you look at ASEAN state parties, of all the investment arbitrations instituted, only 10% upheld claims in part or in full. Compared to your investors, if they go abroad, they have more than double the winning chance if we look at the data. I'm conscious of time, so we go ahead. Here you see that you can have settlements in investment disputes, whether it's treaty, contract of law or law. We talked about it earlier, you picked it up. It depends on, is there willingness to negotiate? Is it in the interest of the state to do it? And this is another thing that I think is really interesting, and it may support our discussion on institutional readiness. Roberto Echandi did this research 15 years ago, and I doubted him at the time until I did it myself. And he was right, and now I know it, is that 66% of arbitrations, if they settle after registration and around tribunal constitution. Might be up to the memorial on the merits. It's a little more open than exactly the constitution. But that tells you that the institution of arbitration triggers something that might support the lack of institutional readiness, that framework helps with the settlement. Of course, we talked about mediation, that is possible all along the arbitration continuum. And we had a beautiful presentation earlier with the different steps of an arbitration in the life. And that brings us back to the mediation discussion that we're having. And Janssen and I were talking about like time and cost savings in arbitration. That is a point that we are discussing. Part of it is, as our friend from Malaysia pointed out, mediation has a different institutional setup or a different focus than arbitration. So it may not make up for the time and cost savings, but how can we do time and cost savings in arbitration? And there are different aspects that are time and cost related to the tribunal and to the council and to institutions. And there I encourage you as government representatives to really have an active management of your council. Check in at the hiring stage. There is, I can make a PR for the e-learning course at the ADBI. There is a great module of hiring external counsel. How can you make that with a budget from the start and a cap? How can you supervise, monitor counsel? Is this positioning, is this cost that is being incurred really needed for the defense of the state or pursuit of a claim? And so an active management also continues there, even if you have external counsel. Thank you.
Thank you very much, Frauke. When you pulled up slides, I got very worried, but you kept us within time. So thank you very much. And thank you for bringing us back to mediation as one way of potentially making things more efficient and more cost effective. I'm very happy now to turn things over to an old friend, Yongshin who could, I'm sure, also talk to us about Korea's experience in ISDS, but is now at KCAB. Yongshin, let me turn things to you, please, for your remarks.
Thank you, Professor Kalamita. Good to see you again. And thank you, ADB and ADB Institute for a kind invitation to KCAB International to join this panel. For your reference, my presentation or discussion today does not represent the official views of KCAB nor KCAB International. So turning on to the first question that I was asked by Professor Kalamita is the efficacy of mediation in investor-state arbitration. As many speakers have spoken, I will limit my points on two crucial points that I want to stress. First, there's nothing to deny that mediation can be one of the most effective tools available for investor-state interstate arbitration. But we have to keep in mind that not every investment arbitration is equally capable of being resolved through a mediation. So before recommending a mediation, the government or the party should consider several factors, including the complexity of the issues, the number of the parties involved, the nature of the governmental measure being challenged, and so forth, and see the practicality of commencing a mediation process before resolving the dispute at hand. And where a case is suitable, mediation can significantly reduce costs and time because it does not require lengthy pleadings, extensive document production, multiple rounds of evidence, expert evidence as in the arbitration proceeding. So we cannot deny the efficacy of mediation in resolving investor-state disputes. And another small point that I wanted to focus is that mediation can also provide remedies and outcomes that an arbitrary tribunal cannot always offer. For instance, mediation can come up with a revised permit, phase compliant, renegotiated concessions, and so forth. So this is, I believe that this is particularly valuable in investment disputes, where the investor may wish to continue operating in the host states, and also the states may wish to preserve ongoing relationships, infrastructure, or continuity of public services. The final point that I wanted to mention in relation to mediation is that mediation and arbitration should not be viewed as competing alternatives in investor-state dispute resolution context, but rather as a complementary tools. For instance, mediation can provide parties with the flexibility to preserve relationships, address regulatory sensitivities, and explore practical solutions that a tribunal may not be able to author. Arbitration, by contrast, offers the neutrality and finality which is necessary where binding determination and enforcement are required. But I believe that used together, both mediation and arbitration can form a continuum of dispute resolution options, allowing states and investors to choose the most suitable mechanism at the most appropriate stage of the dispute. Turning on to my second question, I was asked to answer on what strategies can government use to reduce the financial and procedural cost of arbitration. And in light of the time constraint, I will only focus on one point, which is the capacity building. I understand that many speakers from yesterday and today have been speaking about the capacity building. And I understand that there may be many different views as to the meaning of capacity building in this context, but among them, I would like to focus about the importance of developing the practical ability to conduct international arbitration proceedings. I think such competency is meaningful in a variety of issues, but first, internal capacity is essential for early case assessment. When the government authorities possesses the capacity to conduct actual international dispute proceedings, the ability to identify and assess the case at an early stage is significantly enhanced, which in turn helps in formulating the most effective response strategies. If that assessment can be performed internally at an early stage, the government can make informed decisions before substantial external legal fees are incurred. So I think that would bring a great benefit to governments. Secondly, capable internal teams can directly handle certain matters certain aspects of disputes, as not every matter requires full outsourcing. And third, internal expertise allows governments to manage external counsels more efficiently. If you have experience handling disputes yourself, you can give clear instructions, review works product critically, challenge unnecessary steps so then you can control cost. I recall that Professor Tanki Piman and also my former co-panelist spoke about the experience, how U.S. government operates its own team and the issue of language. I do agree that some countries, especially located in Asian continent, where English is not the native language, may encounter some language issues, and that may deter internal teams to build up capacity, like as it is the case in the US, Canada, or Singapore. However, due to that language issue, I think what it makes it more important for the government to build its own capacity, because most of the documents are written in in our own languages. So I think building capacity within the government itself will be critical in cost and time management in dealing with investor-state disputes. Last but not least, I was asked to share examples where investment disputes were managed effectively during ISDS proceedings. Unfortunately, I do not have any experience in administering investor-state dispute cases since joining the institution, but I wish to briefly share some examples based on my previous capacity or hats that I used to have before joining the institution. First, in one unilateral arbitration, the parties agreed that the case be administered by Hong Kong International Arbitration Center. That proved to be a highly effective arrangement. Although the arbitration proceeded under the UNCITRAL rules, the involvement of an experienced administering regional institution provided valuable logistical and procedural support, helping the case move forward in an organized and efficient manner. The matter was successful, not only in terms of its outcome, but also in terms of case management, and this is considered as a very flexible and efficient management of investor-state arbitration case. Second, in another case, which proceeded during the pandemic period, the parties faced practical difficulty in securing a suitable hearing venue. With the consent of the parties and with the leave of the tribunal, it was decided in principle that the hearing could be relocated to a regional arbitration center, although that plan did not ultimately materialize because public health conditions worsened. It nonetheless demonstrated that the willingness of the parties and tribunals to adapt proceedings creatively in response to external challenges. What these examples show is that there are often multiple ways to structure proceedings so that they are as efficient and practical as possible. So the broader lesson that I wanted to share is that there is no Bible to designing proceedings in investor-state arbitration, and it can be also shaped by how creative and cooperative that the process it may be designed. Thank you very much.
Thank you very much, Youngshim. I'm just thanking everybody at this point because we had so many people. Everybody only had 5 minutes. You've all done brilliantly to stay within your time. And with that, let me turn things over to you, Vivek, please.
That better? Yeah. Thank you. I'm going to make 3 broad points, which are mainly observations from us as an international arbitral institution. The first, I think, is that the challenges that we generally associate with ISDS are not unique, and they are also seen quite often in complex commercial arbitration cases, including those that involve states. And I'll explain that in just a moment. The second is that the key issue is often not the absence of procedural tools, but how you use them at an early stage, including tools, as I will explain, such as ArbMedUp and Prague statistics, I think, are very enlightening in that respect. And we looked at the earlier study as well. So it's good to see that's being continued. The third, I think, is that institutional frameworks can certainly support more effective dispute management, and it can cause parties and states to think about how you can structure your process better. And I'll explain that very briefly as well in the limited time I have. So firstly, the issues that we see mainly are cost, duration, and complexity, and coordination across proceedings. There are studies by the OECD and materials in the UNCITRAL working group, I think, that put the average cost at $6 to $8 million for ISDS cases. Now, that's an astronomical sum, which makes the lawyers very happy, but it's odd for a service that is intended not to add value, but to prevent further loss of value or to compensate for existing loss of value. No other professional service costs that much when it doesn't add value. But that, I think, tells us that there's inefficiencies in the system, and they probably result from a few factors, which are common across commercial and investment arbitrations: late crystallization of issues, fragmented internal coordination, I think, across state departments, companies at an early stage, and a lack of early engagement with external counsel quite often. Overly broad and unfocused pleadings, which are lengthy and adopt a kitchen sink approach is a major issue in international arbitration generally. And another issue, of course, is lack of prioritization of the cases and versus other priorities for a company or a business or a state, as the case may be. So there's a lack of focus and extensive and somewhat rigid procedural frameworks, which are used for every case, irrespective of the dispute, the issue that is in dispute, almost as a standard form, which can be changed. But this leads to the second point that I wanted to make, which is the importance of the structured decision making at an early stage. And most importantly, in this context, as I'm sure been said yesterday and today, the use of mediation. The studies from UNCTAD suggest that a significant proportion of the ISDS cases have been discontinued before a final award. And as Rakesh statistics show, the ICSID cases show that many of those settlements occurred at different stages of the process after the constitution of the tribunal, sometimes following the initial exchange of memorials on jurisdiction or merits. And sometimes it can be in the form of an agreed suspension, several suspensions, leading then finally to a settlement. But what that tells us, and this is also borne out in our own experience with commercial arbitration, is that parties have a better visibility on the strengths and weaknesses of their cases, not just at commencement, but at various stages through the process. And they have better visibility on the likely cost and duration of the proceedings because they've thought about it and they've engaged with lawyers and they're probably being told by an institution how much the process is going to cost. And they probably have a sense of the range of realistic outcomes of the process by that time. So it can be, I think, observed that the commencement of the arbitration itself sometimes can serve as a mechanism to get parties onto the negotiating table. And this suggests that the quality of decision-making improves once parties have better information and visibility on these factors, which is generally after the commencement of arbitration. So all of this leads me to make the point that the implication is that there's real value in developing structures and adopting mechanisms like ARB-MEDAB, which already exist in some form. And the existing discussions also indicate that there is acceptability for these kinds of hybrid dispute mechanisms. There are surveys by the Corporate Council International Arbitration Group done with the Queen Mary University. There's another survey by CIDRA, which is in Singapore, done in 2024, which shows that respondents are willing to consider, in the context of investor-state disputes, hybrid modes of mediation combined with arbitration, which can be effective for these reasons. Now, the existing protocol that does exist in the commercial world is the one that we have actually with the Singapore International Mediation Center. But of course, that can be tweaked and considered in the context of investor-state disputes. Now, the existing protocol allows parties to commence arbitration and then move to a structured mediation process, which is after the initial filings have been made and a tribunal has been constituted. Now, what that means is that it obliges parties to take mediation seriously in light of an already pending arbitration, and visibility on the cost of the arbitration, visibility on each other's positions, and probably by then, if all of the advice in this panel has been heeded, there has been some form of early assessment of the parties' positions as well, which means that when you go into the mediation, it's a structured time-bound process. You are likely to take it far more seriously and you'll be in a better position to approach that in a more professional manner. One other factor, I think, is that states are often faced with the question at the outset of an investment arbitration case and ask the question, are you in a position to settle? And because that is a requirement of many treaties. But very often states are not in a position to do so because they've not had an assessment or they don't have the people who have the authority at that stage to be able to settle. But kicking the can down the road, but in a structured manner, means that by the time you get to that mediation, you can have the right people there. You can have an informed decision that is being made on settlement. The last point I'll make, which is just to mention, and I'm out of time, I know, very quickly, is the fact that you can use procedural frameworks. We do have a set of rules, which is the investment arbitration rules, created specifically for this purpose, and it contains various mechanisms that have considered what is important for investors and states. I'll stop there in the interest of time. Thank you, Professor.
Thank you so much, Vivek. And I say only briefly that, coming out of our discussion about ISDS and RCEP, keeping an open mind to flexibility and perhaps looking at some of the approaches in commercial arbitration For example, you mentioned ARB. There are other ways still to conceive of dispute settlement that perhaps states should also consider for their treaties. So we come now to our, as we would say in baseball, our cleanup hitter, Professor Tomoko. You can do whatever you want here. This is all. This is all yours.
Be really quick. So the discussion reminds ourselves that the cost of ISDS do extend well beyond the costs of administration or financial costs associated with arbitration proceedings. The real cost, like as Janssen aptly noted yesterday, that the majority of investment treaty claimants, the investors, do exit the market, right? So the true cost may lie in the breakdown of the relationship between the investor and the host state. So this highlights the crucial importance of dispute prevention and dispute management at an early stage where the investor still keeps its presence in the host state. So this is highlighted by several panelists. So there are several pathways through which the escalation of disputes might be prevented, like the investment grievance or feedback mechanisms do play a key role. The antitrust toolkit on prevention and mitigation of investment disputes, it gives a number of country examples of such a mechanisms. However, many states still lack such institutionalized mechanisms. We should remember that the OECD's national contact points or the development bank's accountability mechanisms, they are not designed for investors to challenge the investment measures or the host state regulatory measures. So this creates a gap. So establishing a national institutionalized investor grievance mechanisms at the national level could fill this gap. So secondly, we of course have mediation, and this conference has already explored the potential and limitations and practical challenges of mediation. And I do agree that not all disputes are suited for mediation. So like the Philip Morris versus Australia, Philip Morris versus Uruguay, Australian government official reportedly, explicitly said that we will never accept mediation in this case. But mediation can be used successfully in many other cases, I believe. And if I may add one further perspective, it may be worthwhile to consider the use of project mediation in contracts between the investor and the host state. So Ms. Salomon and Amanda, you highlighted, the important role the international investment contract may play, and I do agree. And the project mediation has been successfully employed in construction disputes in the context of construction projects. And under this model, the project mediation model, a project mediator is appointed at a very early stage of the contract with costs agreed upfront. And the mediator follows the project closely and intervenes promptly when differences arise, preventing them from escalating to disputes. So the Center for Effective Dispute Resolution, UK, for example, provides a model project mediation protocol and agreement. Under this framework, mediators regularly visit the project site, maintain a working knowledge of its progress, and engage with project participants through ongoing dialogue. So this continuous involvement allows disputes to be addressed early. So when a dispute arises, project mediators may also serve as mediators to resolve the dispute. So the CDER, Center for Effective Dispute Resolution, notes that project mediation is particularly well suited for PPP or project finance initiative type arrangements, given their long-term nature and their reliance on sustained cooperative relationships. So this may indicate the potential of project mediation for investor-state relationships. So to conclude, the strengthening the preventive approaches in mediation or other grievance or investor grievance mechanisms could significantly reduce not only the costs of ISDS, but also the deeper and more lasting damage resulting from the breakdown of investment relationships.
Thank you so much, Tomoko, and thank you to all of our panelists. All of you were great. You didn't have as much time as you should have, but you made the most of the time that you had. So let's thank them in the usual way.
Thank you very much to all the panelists, and also for trying to stay within time. I know it was a bit tight given the amount of panelists that we had, but thank you very much for your insightful contributions. So we will have now a short coffee break. So please kindly be back by 3. So we're going to have around 5 minutes. So in case you need to use the restroom, go ahead and we'll meet you back at 3. Thank you.
It's so noisy. Hello, good morning, Secretary Jubin Brett. Can you hear us?
I can hear you very well. Can you hear and see me?
Can we get a little louder? I know it's where are you going?
Put this on.
Good morning. Sorry, could we test the sound with you again?
Yes, I'm here. Can you hear me?
Okay, great. Yes, loud and clear. So we'll return from coffee in a few minutes, and the MC will introduce you and Dean Bambang, and we will begin the fireside chat.
Okay, so it's 15 minutes, I understand.
Yes, correct.
Okay, fine. So I'm switching the camera off right now.
Okay, yes, that's fine. And we'll be
I'll be
back in about 5 minutes.
Okay, perfect. Thank you so much.
Thank you. See you soon.
See you soon.
I have a question. Hello.
Hello, yes.
Yeah, I have a question. So when should I return? I need to speak at the final session. When should I return?
The final session begins at 4:30.
4:30. Do you think there would be no delay?
We
I
are
will
trying
stand by
to
from
get back on
4:20.
schedule.
Okay,
Yes.
I will stand by from 4:20. I'll see you later.
Okay, thank you.
Okay, thank you.
the restroom real quick. Me too, but go ahead.
I sit there? Okay. All the briefing will be done by. Okay. Then I can go straight to the question. Okay.
We should turn this. Hello. Okay. Oh, okay. But I think you will be able to part of that. Okay. And then you will confirm the report. So I think if you put this maybe as for this the offset by okay. Okay. The deal oh, okay. So I think this is yeah. Okay.
Hello, everyone. Welcome back from this very quick and speedy coffee break. So please take a seat so that we can restart with the afternoon sessions. So let's go on with the sessions on the agenda. I am pleased to now move on to the Fireside Chat titled Regional Economic Cooperation and Integration Through Alternative Dispute Resolution. I am honored to introduce the moderator, ADBI Dean and CEO Bambang Brojonegoro, who is ready on stage. As you heard already, Dean Bambang Brojonegoro served the government of Indonesia in several senior leadership roles since 2011, as Indonesia's Minister of Finance, later as Minister of National Development Planning, and lastly as Minister of Research and Technology. Please allow me to also introduce our online speaker, Ms. Anna Jubin-Brett, Secretary at UNCITRAL, joining us from Vienna. Ms. Jubin-Brett also holds the role of Director at the International Trade Law Division in the Office of Legal Affairs of the United Nations. Without further ado, Dean Bambang, the floor is yours.
Thank you, Leticia. And thank you so much for Ms. Anna Jubin-Brett for joining our event virtually. And we are conducting now the workshop and also conference on ADR, especially on mediation. So if you don't mind, let me start with my first question. How does ADR, Alternative Dispute Resolution, contribute to regional economic cooperation and integration?
Well, thank you very much. First of all, thank you for having me, even if it's virtual. And as you can see from my surrounding, I've tried to make it like a fireside chat. So I sit in my fireside armchair by the window in Vienna, and I'm very pleased to be joining you and to join my colleague Jae-sung, who has been with you in person. Thank you very much for this question. I think dispute resolution is part and parcel of any international treaty or international arrangement for integration, economic, military, whatever kind of monetary, whatever type of integration, you always have dispute resolution clauses. And in the case of economic integration, of course, it goes beyond the states that are party to the integration. It includes a number of economic stakeholders, and in this case, particularly investors who are foreign investors that may be from the region or from outside the region. And therefore, it's important to have dispute resolution provisions that are appealing and that are protective of these foreign investors, these foreign players, and also these domestic players that are the subject matter itself of this regional integration mechanism. Therefore, having a broad dispute resolution clause that offers many avenues and not only one for settling the disputes is really desirable. And from that point of view, what is better than also including ADR into the offer, into the mix? Because ADR comes with not only one, but several methods for settling disputes that arise under these economic integration agreements. That can be, of course, mediation, which is one of the aspects that you have been focusing on in this event. It can be arbitration, of course. It can be adjudication. It can be neutral evaluation. So there's a full range, there's a full suite of methods to settle disputes that are very well suited for economic integration agreements and economic integration schemes, like the ones that you've been discussing, and I'm thinking particularly of RCEP.
Okay, thank you so much. Loud and clear. So if I can continue with the second question, what will be the best way to promote international commercial mediation?
Well, there are many ways that need to come together and to be used in parallel to promote international mediation. First of all, depending on the region where we want to promote mediation, we have to look into the tradition, into the existing practice. In some regions, mediation is quite developed. There are different forms, different ways of approaching mediation. And in other regions, it's completely, it's terra incognita, if I may say. It's totally unused or underused. And therefore, we have to really adapt the promotion of mediation to the geographic regions or to the economic regions that we are approaching. I think there are different aspects that come to promote mediation. First of all, there needs to be a conducive legal framework, at least when we're talking about treaties or about international investment contracts. It needs to be very clear that mediation is one of the ways available. It can be a mandatory step, for example, for 3 months or 6 months before it's possible to resort to arbitration or other means, for example, going to court. But it's also it's important that it is available. That's available among the means of settling disputes that the parties can, I would say, almost automatically go to. So it's important to have a broad avenue for mediation. The second important aspect is beyond the offer of mediation in the treaty itself or in the contract itself. It's important to have an infrastructure in place to promote mediation. And most of the arbitration institutions in the region also include mediation services, mediation training, mediation promotion, training of mediators, accreditation of mediators, and also training of parties. And I think that brings me to the third point. Mediation is not yet taught, for example, in universities as part of the curriculum of lawyers. So there is often a deficit of practice and a deficit of knowledge about how to approach mediation. It's not complicated per se, it's not procedurally complicated, but it requires skills, knowledge that are that have to be acquired. So in my view, an important part of the promotion of mediation lies also in the skills training, in the capacity building, and in the awareness building. So skills training for mediators, capacity building for parties involved in a mediation, and awareness training for the authorities. We should say awareness raising, because obviously you're not going to train a minister, but awareness raising to the availability of mediation, what it entails, how the state has to be prepared for it. And I think that's really an important part. When I mentioned the availability of mediation as an offer for settling of disputes for the parties to a contract or parties to a treaty or the subject matters of a treaty, for example, the investors, I should also add the availability of rules, of course, and that's where UNCITRAL comes into play. UNCITRAL has developed over the years a full suite of texts that it's a complete framework, just as you have a very complete framework for arbitration, where you have the New York Convention, where you have the model law, where you have the rules, where you have explanatory notes, where you have model provisions, clauses. You have the same thing in the UNCITRAL framework on mediation. You have the Singapore Convention, you have the model law, you have the mediation rules, you have all the suite of texts that form part of this framework. And it's important that this framework is disseminated, that countries adapt and adopt these accede to the Singapore Convention. That's, I think, really a very strong way of promoting mediation. And what stronger signal on the part of government authorities than to adhere to the Singapore Convention, and also that they include the provisions of the model law on mediation into their domestic law on ADR.
Very well noted. I think mediation is indeed very promising, but as you mentioned rightly, there are a lot of soft infrastructure that needs to be established, including education even at the university level. So let me go to the last question. You already mentioned several times about Singapore Convention. So I really like to know your take or your prospect on Singapore Convention on mediation itself.
Well, the Singapore Convention for us is a very, very efficient and very successful instrument. The signing ceremony itself was attended by 50 more countries. We have currently 21 countries that have already ratified. We have 44 countries that are still in the process of ratification. And that, if you take that into account, that it's only 7 years. So if you think about the time it has taken for the New York Convention to become quasi-universal, as it currently the case with 172 member states, but the New York Convention is over 60 years old. We're talking here about a convention that is barely 7 years old. So having such an uptake in states from every region is really very promising, and it's really a clear signal for the interest in mediation and the uptake on the part of states. What governments have realized that mediation comes with many advantages. Of course, it comes with advantages for the judiciary, because mediation is a clear way for clearing dockets, or at least advancing on the number of cases that are pending, be it in family or in commercial disputes before courts. And for example, I'm from a region where mediation is systematically offered in labor disputes and in commercial disputes. But what the countries or the states adhering to the Singapore Convention have also seen is the merits in offering a broader range of dispute resolution mechanisms that go beyond the domestic courts, that go beyond specialized commercial courts as exist in several jurisdictions, and to also have a very strong and very broad offer for ADR. And so many countries have from the outset joined the Singapore Convention with this clear understanding that it's a way of signaling their availability for ADR, bearing in mind that for a long time, and you probably remember that in your previous endeavor as a minister in Indonesia, that the ranking of the World Bank doing business included several criteria, such as being a party to the New York Convention, offering alternative dispute resolution means, to show the ease of doing business. And although the World Bank no longer, or the ADB for that matter, probably no longer does this benchmarking of states with very strict criteria, identifying the policies and the laws that are conducive to foreign investment, to business, to doing business, include, of course, having a broad offer of dispute resolution, and an offer that not only is available for us from a procedural point of view, but also is recognizable and enforceable. And that is where the Singapore Convention comes with an additional incentive, because it makes it very clear that mediation is not only there to be used, but it will also be given full recognition and enforcement on the part of the host country of an investment, or a country where the business transaction is taking place. So I think from that point of view, for us, the Singapore Convention actually ticks all the boxes. It's already very successful in the sense that, as I said, many jurisdictions have from the outset, and now also regularly, several times a year, we have new acceding countries. It's also important to bear in mind that the process for states to accede to an international convention is not always very straightforward. It requires passing through parliament. It requires an entire procedure, domestic procedure, and having undertaken this in such a short time for many states is really a very strong signal. What we also see is the increasing traction that mediation has, including it as an important feature in the reform of investor-state dispute resolution, as we have done in UNCITRAL's Working Group 3. One of the first elements for reform were to develop model provisions to be included into treaties on ISDS mediation, and also guidelines for parties in mediation, and also in the dispute prevention toolkit that Professor Tomoko was mentioning just in the previous panel, also features mediation prominently. And why can we do that with confidence is because we have the Singapore Convention, we have the model law, and that states have that in their legislation and can include that in their legislation, so that it's not only, it's not merely a soft undertaking, but it's a hard law commitment that is made to mediation through the Singapore Convention. So really for us, it is the, and it's interesting to see that the two frameworks, the arbitration framework and the mediation framework, have developed, I would say, almost upside down. In the arbitration framework, it began with the New York Convention, and then trickled down into the model law and rules, and all the later developments, including the expedited arbitration rules, the speeder clauses. Everything depends on the construct with the convention at the origin. And in mediation, we did it almost the other way around. So we built a mediation framework, and it, as a culmination, came the conclusion of the Singapore Convention. So it's really a very strong, very successful instrument. It's an instrument that we encourage and promote everywhere we can, as strongly as we can. And every investment treaty, every regional integration scheme or convention should really include the adhering to the Singapore Convention as one of the parallel commitments that states take, so that ADR can really be grounded on very solid foundations.
Okay, thank you so much, Ms. N. Jubin Brett, for sharing UNCITRAL view with us. Really appreciate your time. Thank you again so much.
It's my pleasure, and I wish you a very successful conference. And I wish I could be at a fireside with all the participants, but I hope that this way I could also contribute to the discussions and the deliberations. Thank you very much, and have a very good afternoon.
Thank you very much. Thank you, Anna, for joining us online. And absolutely, your contributions are very, very welcome and useful for our discussion. So thank you also, Dimbambang, for moderating this quick fireside chat. So now we are ready to move into our next panel discussion. Before, as a request from our photographer, I would like to ask Dimbambang, Claudia, and Didi Jung to kindly join on stage for a quick picture. If my colleagues could raise the screen behind us very quickly. Thank you.
Well, would you like me to stay online as well?
Actually, we are on stage right now, so there's no need for you to join this part, but thank you very much.
Pleasure. Thank you so much.
Thank you very much. Thank you very much. So we are ready now to move into our next session for this afternoon, which will explore the future of alternative dispute resolution in the digital era. The session will address how online dispute resolution can be adopted effectively and the role that AI can also play in this context. To begin, let me introduce the moderator for the session, Pongbo Ben Mitakulawat, Capacity Building Specialist at the Asian Development Bank Institute. So Ben, the floor is yours.
Thank you, Leticia. Good afternoon, everyone. Welcome to the second last session of today. Hopefully everyone's still with us. So welcome to this session on how ADR should advance in digital era. And in particular, what the rise of online dispute resolution and AI means for cross-border commercial disputes. I want to start with simple observation. These days, commerce is digital, but our dispute resolution systems are still catching up. Disputes today move faster, involve more data, and cross more jurisdictions than ever before. And people using these systems, for example, companies, counsel, arbitrators, increasingly expect them to be accessible, efficient, and fit for digital world. So these sessions is really organized around two connected questions. First, how is digitalization changing the nature of disputes we see? Second, how should dispute resolution systems evolve in response? So today we have a terrific group of speakers with us today, representing academia, mediation and arbitral institutions, ODR providers, and legal tech. We'll start with 3 short presentations and then move into panel discussion, and hopefully we'll have some time left for questions from the floor. So without further ado, let me introduce the first speaker. So we'll first hear from Professor Yoshihisa Hakayawa from Rikyo University, who will open by looking at how digital commerce is generating new kinds of cross-border disputes and what international frameworks are doing or not yet doing to address them. On that note, over to you.
Thank you very much. This is Krika, okay? So thank you very much. I now serving as a representative from Japan for the APEC, and which is now encouraging the use of ODR in the region of APEC. And I'm also leader of the new ISO project, which is in relation to the ODR related documents. And I used to serve as a delegate from Japan for UNCITRAL for the ODR working group. And today I'd like to let you know about what is the ODR and what is the benefit of the ODR, especially for the relatively small amount disputes for the cross-border cases. So let me introduce. Yes, so this is the expansion of the online transaction. It is obvious fact, but the disputes of online transactions are also increasing. But the problem is there are so many online transactions, and many of the nowadays are cross-border ones, but disputed amount are usually average $50. Who will bring a transnational litigation or big size international arbitration for such a small dispute amount? But at present, without technology, we have to give up to get the money back for the such kind of the disputes. And on the other hand, eBay has already established very successful online dispute resolution system. Every year, it manages almost 60 million cases per year. The number is larger than total number of the US litigation cases. And Alibaba is doing very well for this, the kind of the systems. So this is one of the examples of ODR system, which is now going on. And you can use your ID and password, which is also used in the e-commerce transactions. If you have a problem, you can enter ID and password. You can move to the online dispute resolution phase. And so you could do, according to the template, you could insert the information, what is needed, you are needed, and what is the disputed issue, and something like that. And you can communicate with the respondent. At the very beginning stage, it's usually negotiation. So on the platform, you can very easily contact your counterparty, and 90% cases can be resolved at the very first stage. And if this kind of the exchange, after the exchange, you could achieve the settlement. The settlement, the document will be automatically established. But if you fail to achieve settlement, such a bilateral negotiation, and the third party will appear. So it's mediation. And in the mediation stage, the third party mediator, neutral, will manage the case, and you can get the final settlement, or if fails, the many ODR system try to move to the arbitration phase, and you can get the final decisions. So this is one of the examples of the ODR systems. And additionally, the various international organizations is now doing so many activities for encouraging the use of ODR, and especially for the cross-border cases and the small amount cases. And it is an effective reaction to the cross-border low-value dispute in e-commerce, and it will contribute to harmonization for the ODR schemes in various regions, and a smooth introduction of ODR even in the emerging market countries. So the first trial challenges are made in UNCITRAL, and ODR working group started 2010. I served as a delegate from Japan for this project, and it continued until 2016. At the very beginning stage, United Nations ODR uniform rules for B2B and B2C were tried to establish first step negotiation, and the second step mediation, and the third step arbitration. All process will be basically conducted by online-based documents, and a simple and quick process for low-value disputes is tried to established. And under the systems, our image is a single arbitrator chosen by ODR arbitrator, and all awards shall or should be in public on website except private information. And hopefully we try to make a worldwide uniform rules for the merit, because governing law issue. I'm a professor of private international law, but the private international is one of the most disgusting issue in the complicated dispute. So if we could agree with the kind of the substantive rules which can be relied on, so that it must be very easy, and the substantial enforcement system by trust mark could be established. So that is the first concept. But unfortunately, a serious issue appeared in the United Nations. So it's a validity of the arbitration agreement between the consumer and the business corporation. US and other countries, of course, it should be valid. But EU, Japan, and other countries, consumer should have a cancel right for the arbitration in advance. And finally, the project established technical notes on ODR. But unfortunately, this does not have any legal effect. And the three-steps approach was proposed, but no explanation about the third step. Third step could be arbitration or any kind of the recommendation without binding effect. And finally, no reference to the idea of the ODR trust mark. If the award is relating to the very small amount, so judicial enforcement process is unrealistic. So we have to establish something, for the smooth operation or smooth implementation for the ODR systems. And the APEC project started from the 2017 after the termination of the UNCITRAL working group. EU established its own ODR platform at the time, but other states still need uniform rules and schemes for the global ODR platform with negotiation and third-party interventions. So APEC started its project to establish another global ODR platform, and UNCITRAL fortunately assisted the APEC project on ODR. And the B2C issues at the time were carefully avoided strategically because we had a very bad time for the B2C arbitration issues. And this is the kind of the brief history of the meetings and the rule-making activities like that. And finally, we established APEC collaborating framework on ODR, which was established and which aims to assist member states to encourage the use of ODR and to assist potential users in the APEC region to actively use ODR with APEC model procedure rules on ODR. APEC model procedure rule on ODR was created based on the draft of the UNCITRAL model procedure rules on ODR. In other words, UNCITRAL ODR project substantially continued in APEC, in other international fora. And the list of ODR providers which adopted the APEC model procedure rules is provided on the APEC website, including EBRAM. So today EBRAM's representative is come here, and the Ganzhou Arbitration Center or some other centers. So these centers can easily start its own business because we have already prepared the procedure rules which can rely on. And this is the kind of the list of the arbitrators, and two more are added at present. And these are the APEC project to encourage the use of ADR. Then now I'm turning to another project, which is led by ISO, International Organization for Standardization, headquarters located in Geneva. And there is a project of TC321. And TC321 is working for the transaction assurance in e-commerce related to upstream, downstream processes, including protection of online consumer rights, including both prevention of online disputes and the resolution process. So this must be ODR. And this is the kind of the brief history of the how we try to make ISO new standards on ODR. And now this ODR standard was published last year, March. And some ODR, the providers rely on these standards. At least APEC, the authorized ODR providers, including EBRAM, can easily say, we are ISO authorized ODR provider, which is a very good, the kind of the landmark for the consumers or the users. So the which ODR provider is a reliable and credible one. And we made basic principles and technical recommendations, operational manuals. But that we do not want to make additional new one. And if we have 2 or more uniform rules, so the industries or users have to be confused. So we try to use, for example, ICODA, which is a organization for ODR, and it made a kind of the name, the document, which is named is standards. And it was adapted as a basic principle of the ISO document. And CRT, which is a Canadian ODR organization, had a very good document about the technical recommendation, including the privacy issues, the information security. And we used this document as a technical recommendation of ISO document. And the operational manual is a carbon copy of the APEC model procedure rule on ODR, which was originally made by Untitled. So this is a list of the issue in basic principle. And this is a list of the technical recommendations. So that we are, providing some important issues for the record sealing, anonymization, or security and storage of records and access to records. And the final one is the contents of the operation manuals, and ODR providers can easily start its own business relying on these, the rules, and fair process can be easily operated. So the listed ODR providers, including EBRAM and Ganjo Arbitration Commission, can be regarded as the ODR provider adopting ISO 32122. And after the establishment of ISO 32122, as a next step, it is expected to start a project for ISO certification on ODR for e-commerce operators adapting the ISO standards or using an ODR provider adapting the ISO standards. So consumer, especially customers, especially consumers, can easily identify which ODR provider the trustworthy e-commerce operator, which is the ISO with ISO certification on ODR. The expected ISO certification ODR will work as a ODR trust mark. So this is we are now tackled. So thank you very much. This is the end of my explanation. Thank you.
Okay, thank you very much, Professor Hayakawa, for that very comprehensive presentation. Next, I would like to invite Professor No-Young Park, the chairperson of the Executive Office at the Korean International Mediation Center, who will speak about AI international commercial mediation, what it offers, but also the governance questions it raises. On that note, I'd like to invite Professor Park.
Okay. Good afternoon. Today, I'd like to make one central point. AI, or artificial intelligence, is not just improving mediation. It is changing how mediation works. Traditionally, mediation has been understood as a human-centered process. It depends on trust, party autonomy, and human judgment in the mediation process. No, different. The new one, please. I want the new one. That was made for the 12 minutes presentation, but I had to last night shorten into 7-minute presentation. So I have only one slide there. No. Yes, this one. But the first, okay, thank you. Sorry. So AI is increasingly moving into the core of the mediation process. AI is not limited to administrative tasks. It is increasingly used to analyze disputes, structure negotiation issues, and even propose settlement options. So the key question is not whether AI is useful. The real question is what happens when AI begins to shape how decisions are made. My answer is this: AI does not just assist mediation. It shapes how disputes are framed, what outcomes are considered reasonable, and how decisions are ultimately made. Let me explain this with a simple example. If an AI system identifies key issues from a complex contract or suggests a settlement range, parties do not simply consider that output. They begin to think within it. They negotiate within it. So the AI is not just helping, it is structuring the negotiation in mediation. This is what I call structural influence made by AI. The risk is not the wrong answers. The risk is that AI quietly shapes how decisions are formed. Over time, this affects human judgment. People begin to rely on AI outputs as a reference points, even when they do not fully trust them. So again, the issue is not error, it is influence. Yes. So this is only one slide I have today. So this becomes critical when we consider the legal dimension. Traditionally, mediated settlement agreements were private contracts, but under the Singapore Convention, they can now be enforced across jurisdictions. This means mediation outcomes can produce legal effect. And this changes everything. If AI influences mediation, it may also influence outcomes that may be later produce legal effect through enforcement. The European Union AI Act focuses on AI systems that contribute to outcomes with legal effect. In the context of mediation, AI systems may, in certain cases, fall within the category of high-risk systems, particularly where they influence the formation of outcomes that may produce legal effect. In such cases, their use may trigger specific obligations under the EU AI Act, including requirements on risk management, human oversight, and transparency. So AI becomes legally significant not because of what it does technically, but because of the consequences it produces. So the key issue is not simply whether AI is accurate, but how it influences the process, and this is why governance becomes essential. Governance here is not only about controlling the technology itself, it is also about controlling how the technology influences decision-making. This requires transparency, so parties should know when AI is used. It requires human oversight, so decisions remain human. And it requires documentation, so outcome can be explained and justified. So let me conclude with one central point. The challenge of AI in mediation is not technological, it is structural. The real risk is not that AI gives wrong answers, but that it shapes how parties think and decide. And once mediation outcomes become enforceable, this influence becomes legally significant, so governance is essential. AI must be controlled not only at the technical level, but also at the level of its influence on how decisions are made. Without this, trust in mediation cannot be sustained. So if you look at the slide, you know that under the Singapore Convention, mediated settlement agreement can ultimately be enforced. So that is in terms of EU AI Act legal effects. And if AI systems produce legal effects, especially in ADR process, that is classified as high-risk AI systems. And then under the EU AI Act, several requirements are imposed on the use of or the deployment of the AI in the process. Although we are mainly from Asia or the US, so EU AI Act does not itself apply to us. But I want to emphasize what we could learn from the application of the EU AI Act in the process of mediation. Thank you.
Thank you, Professor Park, for highlighting the question on AI, whether AI is, but how it shapes negotiation process itself. Let me now invite Michelle Sonnen from the head of APAC at Jus Mundi, who will give us a practical look at how legal tech platforms are already changing the way practitioners work. So on that note, let me hand over the floor to Michelle. So Michelle will do a live demonstration on Jus Mundi platform here.
I'm already connected, so it should be. Oh, no. Okay, everyone, give us a minute while I hook up to Zoom so I can share my screen. Okay, I'm hooked up, but I don't see it on the screen.
Derek.
Okay.
I think it's working now, right, Michelle?
Okay, perfect. There is an echo here. It must be okay. All right, I think we're ready to rock and roll.
Okay, the floor is yours.
Thanks everyone for your patience. Thank you so much to ADBI for inviting me here today. So I'm Michelle Sonnen. I am the head of Asia Pacific and MENA for Jus Mundi. We're a legal intelligence platform that specializes in international arbitration and investment disputes. We serve over 700 clients worldwide, including several governments, law firms, arbitral institutions, and companies. So Jus Mundi was created to address a fundamental challenge in international law. Legal information that matters for dispute resolution was scattered across jurisdictions, languages, arbitral institutions, national courts, and so forth. So you had treaties in one place while national court decisions were in another. Arbitral awards, if they're published at all, are quite difficult to find and harder to search. So to solve that, we built the world's most comprehensive database for international arbitration. So that includes, just to name some of the data, we have investment treaties, ISDS awards, commercial arbitration awards, enforcement decisions from national courts, institutional guidance, soft law guidelines, and so forth. And we've now developed an AI that's been trained specifically on this content, and that's called Use AI. So before I get into the demo, what I just want to highlight one thing, which is that what makes Use AI different from general AI tools like ChatGPT is that our system is purpose-built for international disputes. So it thinks like an arbitration lawyer. Every answer is grounded in citable sources, and it addresses the information gap that contributes to making international disputes so difficult and costly to manage, including for governments. So with that background, let me go ahead and show you how it works. And I'm going to show you two examples. So this is what the interface looks like when you log in. And I'm going to first do a prompt here. Got lots of things open on my screen. Okay. So while that's running, what this is to show you an example of how you might use AI to assist with early case assessment, to sort of help governments make, as you explore strategic decisions about whether you want to settle or whether you want to mediate or whether it makes sense to take this all the way to arbitration. These are the kinds of decisions that would require quite a bit of understanding of your legal position and the strengths and weaknesses of your case. I should note that the countries and the factual scenarios I'm going to show you in these examples are purely fictional. I mean, the countries are real countries, but the factual scenarios are fictional. They're for demonstration purposes. I just need to use real countries and real BITs in order to make sure that you get a sort of comprehensive answer.
Michelle, sorry to interrupt. Can you make the text a bit bigger so that people...
I can. Let's see. Oh, where'd it go? So let's see. I'm kind of blowing. Yeah, is that better? Okay, there we go. So what's happening now is that it's the AI is sort of searching through our database. So while it's doing that, let me give you a sense of the breadth of the database and what it's searching through. Can you see this window? No. Sorry, I got like many windows open. Okay, so this is what the database itself looks like, where all the materials are stored, and I just have the numbers up here to give you a sense of the scale. So we've got over 4,000 treaties. We've got over 1,400 different rules and laws. So this includes national arbitration laws as well as arbitral rules from institutions. Cases, this means documents that have come up in arbitration cases. And so that includes documents from the whole entire arbitration lifecycle, from the notice of arbitration in an arbitral proceeding, all the way to the enforcement decision in the national courts. And then we have about 20,000 publication documents as well. So it's still loading here, and it is almost done. It says that we've got about a minute left. So while that's loading, let me also tell you about what's happening behind the scenes. So the AI that we've built is trained on that vast database that I showed you of about 120,000 different documents. And then we built an agentic AI system. And so what that means is that basically there is a host of self-autonomous agents that are all running simultaneously in the background and working together. So one agent is a planning agent. That's the one that looks at your prompt, makes sure it understands what you're really asking, and then figures out its research plan. This is where it's very important to have an AI that truly understands arbitration. It's going to understand how all the different types of materials fit together. So it's going to know that you should look at national court decisions in areas in countries where you might enforce the award, as well as at the seat. It's going to understand which treaties are relevant here, which cases are relevant, and so forth. Once the planning agent has completed its plan for how it's going to conduct the research, several different agents then go and conduct the research. So you're going to have one that's going through the treaties. You're going to have another one that's looking through awards. You're going to have another one that's looking at court decisions. I mean, you might have another one that's looking at publications. Then there's another agent that puts all of that information together in a way that's very easy for you to digest and read. And then lastly, there is a self-reflection agent, and that allows the AI to self-critique its work and decide whether it needs to go and conduct further research or whether it's satisfied with the research it's done. Okay, I think it has not I'm not sure what's happening here. It may be my internet. So I had a feeling this could happen because of the internet. So I have one preloaded. I'll just show you this one. So this is the same prompt. Basically, it's about Spain facing a claim from a UK renewable energy company under the Energy Charter Treaty. And Spain has introduced regulations that have basically reduced the amount of power generation by 35%, as well as some fees that have increased the company's operating costs. So the question, the UK company is now going to assert a claim, and the question is, what are the strengths and weaknesses for Spain based on similar cases? So what you get here is a very digestible legal memo. It's not just a simple answer. And it goes through the potential defenses in quite some detail. So these are the different claims that could be brought. And then it gives an analysis of what the strengths are, as well as citations to case law. Here's more of the claims, as well as other defenses. And you can see that there are line-by-line citations here. I'll pull that up in a minute. And then what's also very nice is it created a chart where I went through each potential claim or defense and identified the strengths and weaknesses. And then it has citations to the authorities that support that assessment. So when I pull up the citations, it opens up on the right and it cites the case. And then it'll cite the precise paragraph of the document where that authority came from. And then it'll actually open up the document if I click on that paragraph, and it'll take me directly to the paragraph that's being referred to. And it will do this for all of the sources. Oops. And you can see here in this one, you have, oh, now I'm stuck. You have 57 sources being cited. And that includes primary sources, treaties, cases, publications, and so forth. So let me just show you one more that I've also preloaded as well in the interest of time. So this one is a slightly different angle. I wanted to show how you could use AI to prevent disputes altogether, dispute mitigation at the policy development stage. So this is an example where a government, in this case I chose Bulgaria, is considering a regulation that would require new environmental studies. And it's wondering what are the potential legal ramifications if it were to implement this regulation. So you can put that into the AI. And then it's going to, again, come up with a memo, and it's going to analyze different ISDS cases where this type of regulation was put in place and what the outcome was for the country. And then it'll also look at the investment treaty framework in that particular country. And then it'll sort of assess, what the potential vulnerabilities are. And then it'll also give practical recommendations. And then just as previously, you have all the citations that open up on the side with direct links to the document itself in the database. So, okay, there we go. Yeah. Okay. So these are just two examples I wanted to show you that could be quite practical, particularly for governments that are considering policy changes or that want to have a greater ability to do some early case assessment to help drive the strategic direction of the case. Analysis like this used to require quite extensive time and resources, weeks of research across scattered sources, especially where precedent was difficult to find or inaccessible. But now by harnessing the power of AI and our comprehensive database, you can run this kind of analysis very quickly. Just to flag that we do also work with quite a few government clients, including Japan's Ministry of Foreign Affairs, Singapore's Attorney General Chambers, the Philippines Office of the Solicitor General, who use AI to support their ISDS work and treaty negotiations as well. So happy to show anyone here more when we have more time, but thanks very much for watching. I hope it was helpful.
Thank you, Michelle. On that note, I'd like to call upon the rest of the panelists to the stage, please. Mr. Albert Long, Acting CEO and Chief Technology Officer at IBRAM International. Online Dispute Resolution Center. Ms. Donna Huang, Director, Arbitration and ADR North Asia ICC Dispute Resolution Services. Last but not least, Ms. Gloria Lim, CEO of Singapore International Arbitration Center. Please proceed to the stage. And the presenters as well, please, Professor Park and Professor Hayakawa. Anyway. Do we have enough seats? Okay. So now let me circle back to the first presentation of Professor Hayakawa. So this is the question for all the panelists and presenters. So let me start with a broad question. So as we know, the commerce transactions now become more digital. How is this changing the way disputes are being conducted? And what does that mean in terms of how ADR system that needs to evolve? So on that note, perhaps Albert, would you like to go first as the you're the ODR provider?
Yeah, thank you very much. First of all, thank you very much for ADBI's invitation to let EBRAM to join this panel. And as ODR provider, I would also like to thank Professor Yoshi Hayakawa because EBRAM initiated in 2020 and we launched APEC ODR framework in 2022. So we successfully using APEC ODR framework that is within 40 days. The parties can go through negotiation, mediation, and arbitration process within 40 days. So from the perspective of an ODR provider, the key point I would make is that ODR today is not about replacing traditional dispute resolution, but about designing processes that fit the nature of the dispute. In terms of what is most suitable for ODR today, we see strong section in low to medium value cross-border commercial disputes, particularly those linked to digital or platform-based commerce. This includes e-commerce transactions, online services, licensing, distribution agreement, and payment of fintech-related dispute, just like Professor Yoshi mentioned about eBay, Alipay, Taobao, etc. These disputes tend to share common features. The evidence is largely digital. The fact patterns are relatively standardized, and the parties are already operating cross borders online. In these cases, ODR offers a key advantage: speed, cost proportionally, and accessibility across time zone. Online mediation and arbitration, especially when used early, often helps party resolve dispute before position become entrenched. ODR also work best where dispute resolution is built into a commercial relationship itself. When contracts anticipate online process and provide procedural clarity, ODR becomes part of business continuity rather than a last resort escalation mechanism. At the same time, there are clear limits to wider adoption, and these limits are not primarily technological. From a practical standpoint, ODR is less suitable for highly complex or fact-intensive dispute, case requiring extensive witness testimonial or expert witnesses, or situation where urgent cohesive measures are needed. From a legal and institutional perspective. Enforceability and trust remain central challenges, where international instruments such as Singapore Convention or New York Convention are important steps forward. The recognition and enforcement of outcomes from online processes still varies across jurisdictions. Party want certainty that a resolution achieved online will carry real legal effect offline. There is also perception issue in some markets where ODR is still viewed as informal rather than institutional robust.
Okay, thank you very much, Albert, for that answers. Perhaps I'd like to turn to Donna or Gloria from the institutional point of view. What do you see in terms of changes and how ADR system needs to evolve?
Thank you, Ben. Well, Albert has kind of described the importance of technology and ODR in the area of particularly high volume but lower value disputes. And you see that ODR is very easily embraced in that kind of environment, and it gives users access, right, to a solution that is fast, quick, and efficient. I think for us in the arbitration space, and Donna may also share her experience, where we deal with slightly higher value disputes, I think there's a little bit less, and as you alluded to when we spoke, Ben, that there's a little bit less quick adoption of ODR as we have been discussing, but there's adoption of technology in different ways to achieve greater efficiencies, to ease the load of summarization, repetitive tasks, checks, compliance that we have to do in the arbitration process. So I think for us, in terms of trends for disputes, if we are asking about the types of disputes that you see, I would say we've not seen a strict change in terms of the types of disputes. We still see commercial, corporate, trade disputes being arbitrated. We do see IP and tech disputes. A lot of them tend to be contractual in nature and not so much, in terms of substance, requiring very specific technical related types of expertise. What we do see in terms of trends, though, is process-wise, procedure-wise, there's appetite for faster procedures in arbitration, the traditional arbitration that we've been talking about. As IAC has introduced in our 2025 rules, a 3-month streamlined procedure, documents-only procedure at 50% of the cost, that has been very well received. There's also a 6-month expedited procedure that we took on, that we actually expanded to increase the threshold, allowing for cases below 10 million Singapore dollars to qualify. And we've seen great take-up in those areas. So I think apart from technology, there's also an intersection with procedural reforms that need to take place. Yeah, over to you.
Thank you, Ben, and thank you for the ADBI's invitation that I have the pleasure to join my panelists. For addressing this question, I would like to address one point. So it's actually not just about the type of cases. I echo what Gloria just mentioned, that from the ICC statistics, we also not see a very significant trend for the type of cases being changed. So you already heard from Claudia that for the ICC case, construction and energy still remain the top 2 sectors, accounting for roughly like half of the ICC arbitration cases. Of course, we see and understand the strong need from the e-commerce platform, that they are looking for some like a super expedited dispute resolution mechanism, as well as some like a creative mechanism for their business model. But still, in our cases, those like complex disputes still play a very big role. But what we have really like see from that change is that the broader ecosystem around the disputes has been shifted. So what we're seeing now is that the underlying transaction, the way that businesses operate now is totally different with like a decades ago. For instance, that the evidence that's submitted to the tribunal and to the arbitration institution is now largely in digital form. And also the communication between the parties are mostly like electronic. So even if the type of disputes remains similar to us, but the way that those disputes are formed, presented are different. So to reflect that change, ICC just had a new rules be approved by the ICC, which will enter into force on the 1st of June. In that new rules, and I'm sure you will hear more about this, but one important change is on written communication. So under that rules, the electronic communication will become the default for communication between parties, among the tribunal, and also with the secretary. So with that, I think it sounds like a technical like adjustment, but it reflects a much deeper shift. It reflects a shift from like a digital combination to digital primacy. I hope that I addressed that question.
Michelle, would you like to add to that or?
No, I can save my time for it.
Okay, perhaps.
Thank you very much. And first of all, I'd like to divide two types of ODR or online dispute resolution. First one is mainly for the low value and high volume cases, and on which the EBRAM is focusing upon. And the second one is traditional international arbitration where I'm working, and so this one is the now the developing with such a new technology and AI. And for the first one, so the long time we had to give up to recover the money in the disputes, because the disputed amount is very small. If you would like to use a traditional litigation or arbitration cross-border ones, so you have to use, for example, $50,000 US for recovering the $50 US. So it's a nonsense. But now the ODR scheme which is provided by EBRAM is, for example, you can proceed with the dispute resolution with your smartphone, and you could enter something in the chat box, and such a settlement could be easily achieved. So that is excellent the development for this kind of the disputes. So the unexplored area, I mean. And additionally, the AI is working very well because under the, for example, eBay scheme, based on the big data, 60 million cases per year, so the AI could easily recommend 70% of these type of the cases can be resolved this amount, something like that. And this is a very good reference for the negotiations. So that is one thing. Of course, as Professor Park, mentioned, this kind of the AI has to be transparent, accountable, and the ISO scheme providing the guideline, the basic principle, and the technical recommendation for the which part human being, the oversight is needed, and which part can be, automatically operated by AI. So that kind of the guidance has already provided. And EBRAM, for example, try to obey this kind of the requirement. That is one thing. And secondly, for the much more larger cases, and the SHIAC and the ICC doing, and I'm doing, and this case, this new digital, technology is contributing, especially for example, hearing, so that we used to use a human being transcriber, but now AI transcribing system is well working, and the translation itself, now we have a very good translation system with AI, and we do not need any more human being translators, at least the FENA use international arbitration process in the hearings. And so the evidence document is displayed automatically. If we try to say the R33 or something like that, and R33 is automatically displayed. So the AI is now working for the smooth operation, the efficient, effective operation for the hearing system itself. So this is a very good contribution, I believe. So now I believe the AI and some technologies is contributing to the dispute resolution schemes. And I would like to add one more thing is Michelle mentioned about the AI could be used for the ISDS disputes, because ISDS disputes, one of the specific features of the ISDS especially the disputing legal points are very limited, so that we can easily find for example, which famous arbitrator have a which legal opinion in each topics, and so the topic itself is number of topics is limited. So the AI can easily find if you use this arbitrator, you can win or you will be lose or something like that. So this is a specific feature of the ISDS issue, and I think the Michel's system will work very well.
Thank you, Professor Hayakawa. Just to sort of comment on that, and it's true. I think that AI has that potential use case, not to predict with the kind of certainty that if you pick X arbitrator, you will win on Y issue. But because of the breadth of the data that we have in our database, particularly on ISDS, if you're talking ISDS specifically, and given the fact that there tend to be a limited universe of claims and they all arise out of treaties, you are able to get a very nuanced view of how tribunals have ruled on these particular issues in past cases, and then ask the AI how it would then a similar tribunal or a particular tribunal member might rule in your case with a very similar fact pattern, and that is a very powerful use case that you can do out of AI for sure. There are also, I think this is similar to the prompt I showed earlier with my fictitious Spain example. And I only gave it a very limited set of facts. But if you have a detailed set of a factual scenario that you can upload into the AI, it can then look at those facts, go through the entire database, find all the cases where they've had similar factual scenarios, and then give you quite a detailed analysis of how your claims might hold up based on previous cases.
So now we're on the subject of AI. If I could just go back to Professor Park's presentation, something that I find interesting is you made a point about not only whether AI is accurate, but it is how AI may actually shape the negotiation itself. So perhaps would you be able to elaborate a little bit more? What does it mean in terms of practical terms, especially for arbitration or mediation centers?
Thank you. Before I answer that question, I mean, although AI can do a lot of things, but AI cannot replace a human-driven process like mediation. That is one point. And I mean, the answer may cover many things, but I just like to emphasize the role, I mean, allocated between the mediation institutions and mediators while the AI is used in mediation. Mediation institutions as deployers, as found in the EU AI Act, the deployers are responsible for deciding whether and how AI is used in the mediation process and for establishing the governance framework. Mediators, on the other hand, are the ones who actually use AI in the process. So the structure is this: the institution governs and the mediator operates within the framework, AI does not eliminate responsibility, but it redistributes it between the mediation institution and the mediator. In this context, several practical implications follow. First, mediation institutions must establish clear rules on AI use, including transparency, scope of use, and data governance. Second, mediators must exercise active human oversight within a framework established by mediation institution. They need to understand the limits of AI and be able to interpret, question, and where necessary, disregard its output. Third, institutions must ensure proper documentation and traceability, particularly where AI contributes to the formation of a settlement. Fourth, there must be a clear allocation of responsibility so that it is understood how decisions are made and who is accountable. These are not only operational issues, they are also legally relevant. So I explained the implications of the application of the EU AI Act and the Singapore Convention. So the ultimate goal is to ensure that mediation remains a human-driven process while producing outcomes that are workable and justifiable. In this context, my center is currently developing guidelines on the use of AI in mediation aimed at operationalizing these governance principles in practice. Thank you.
Thank you, Professor Park. I'd like to turn to the practitioners, so Gloria and Donna as ICC and as ISC. What do you see as the biggest opportunities for AI and also, on the other hand, the biggest risks?
Of course, thank you. So I just want to share first at this stage. So ICC is taking a very cautious approach to the AI. At the case management team, we don't use any AI tools for case management. And second, arbitral tribunal is not permitted to use any AI tools to draft any documents, including like procedural or substantive. But we are not dinosaur living in the last age. So we fully recognize that AI is a growing trend, and imagine you are arbitrator. It's very difficult to not embrace this technology and thinking that there's a 24-hour free assistant working with you all the time. And if a party and the party find a arbitrator of course, party wanted the tribunal to do their own work, but if your arbitrator is not working as hard as others, and you might want a assistance to work for the arbitrator. So basically, we recognize that, and we also have a very internal, a formal serious internal evaluation, a project going on to assess the ethnic issues on the as well as the technical issues to help the tribunal, to help the secretary to manage arbitral cases. So the last point that I would like to address is that we had an internal survey and also a task force focusing on AI. So we figured out the most immediate need for arbitration is for the AI in arbitration is in case management. So not in decision making, not in legal analysis, but in case management. So in particular, we figure out the areas like a procedure arrangement and also document or organization and timeline tracking is the most needed areas for case management that people are looking for AI to assist.
Thank you. I think Professor Park has a quick comment.
May I interrupt? So if your institution does not use AI, but how do you control the individual arbitrators? For example, if they use Mundi at home or in his office?
I think basically it's an integrity issue. And for the case management team, we like remind seriously to the arbitrator. And it's just like the tribunal secretary. We don't allow like a shadow tribunal secretary to work. But it's, I mean, the institutional like a requirement.
To respond to Professor Park's comment, I think at the end of the day, the question is, where does the responsibility for the decision lie? Does it lie in the arbitrator who has been appointed? And I think as long as that is the principle, then whether AI technology or any other innovation is used to aid the arbitrator has to check and has to be responsible for the output. And it cannot be devolved to the AI. And maybe to just respond to some of what's been discussed, Prof. Hayakawa, you talked about standards, ISO standards, the need for standards. Prof. Park, you talked about the need to see the limitations of AI and ensure that there are safeguards and ensure that you do not devolve important functions that users of ADR expect from the ADR providers. And then, Michelle, you demonstrated how AI can be harnessed, right? So I just thought to leave with this room, three important areas that I think we can look at AI in a positive way. One is I think AI can, and we are looking at it at SIC as well, to help increase the efficiency, the accuracy of our internal processes, and also external service delivery. The second, and this can be in automation of some of the routine tasks that we don't need humans to do. The second is that AI can really support and enhance human decision making. I mean, in the area of perhaps summarization, that also has been carefully thought through, but in situations where it's humanly impossible to go through so many documents, the AI could well help, a human to digest the information better, make better decisions. We also see that in the area of legal research, as was demonstrated by Michelle. I think the third thing that is very interesting, which is also possibly undergirding our dialogue, is this need for building trust. And the question is, can AI help us build trust? And it is in this context that maybe, ISO standards, like, Professor, Hayakawa has mentioned, Yoshi, yes, has mentioned, are very useful. Even in setting up our own computer system, we did do an ISO exercise, and we have found that very useful to ensure that there's resilience in the system. So I thought we just have, just to summarize, I think from an institutional point of view, we see AI here to stay. And but at the same time, we do need a lot of guidelines and guardrails to ensure that it is well implemented.
Thanks, Gloria. I'm very conscious of time. I'd like to open the floor for a quick question if someone has one before we wrap up. It's more than one. Please, Jason, and then Professor Jensen.
So I just wanted to draw the attention of the speakers as well as I did mention that UNCITRAL's Working Group 2 finished its work on awards in electronic form. Now it's done, and now it's looking for a new project. And as you know, UNCITRAL as an international legal standard setter, it's going to embark on one of the three areas. It's going to be use of AI in dispute resolution, remote hearings or remote arbitrations, or platform-based dispute resolutions. So I think this is the three topics on the area, and the Commission is going to take a decision on which legal standards to develop in June. And all the inputs that you have provided is important, but I think we also need the inputs from the states on what kind of standards they want to develop for the Commission, which will become a UNCITRAL standards for you to use.
Thank you, Professor Jensen.
Yeah, I guess I wanted to make one comment on the databases that, or at least the database that was shown. It strikes me that one of the significant limitations of these databases is that all of the relevant information with respect to an investor state arbitration is just not publicly available. So you have the final award of the tribunal in which it identifies issues that it believed were relevant, or at least that it wanted to highlight in the award. But you never see you don't have access to the argumentation. So you don't have access, generally speaking, to the memorials and the pleadings that the parties submitted. So you don't necessarily have access to how was that argument presented? Was counsel, were they terrible? Did they make a bad argument, or did they not even make the argument? So this is an area where I think there's not much you can do about it, but there is a limitation to ultimately the outputs because the inputs are not complete.
Okay. Michelle, would you like to respond to that question? Then.
Yeah, no, I completely agree. And I think that gets to the more sort of core of the issue, especially with AI, is your output, regardless of the AI, is only going to be as good as the data behind it. And if you don't have strong data, your AI output won't be strong either. As you said, there's nothing Jusmundi can do to get states to put their pleadings in the record, but it is something that we at a policy level, we really advocate for accessibility. We have partnership with ICC. Accessibility is sort of at the core of that partnership as well, and really trying to get as much information as possible into the public realm. And on that note, aside from our AI, our entire database is actually open source. So you don't need the AI subscription to access the documents in our database. The AI bit of it and the technology that we sort of put on top of it, that comes at a cost. But it's part of our sort of mission as a company to make the data that we gather from institutions like ICC. We recently added SIC's challenge decisions to our database, and that's all publicly available without a subscription as well. But very much an issue that we'd like to encourage more accessibility both in the investment and commercial realm.
Can I? Okay.
Yeah, if I may to add just one point. I mean, AI is a data hungry, like a mechanism tools. So when like a digitalized document become like a data, and which create the ground of like a data, like a ecosystem, and the data will bring another concern about like data protection, like in the EU, the GDPR. And I believe in a lot of jurisdictions, data security is a national security issue. So we bring to another like a level of concerns when people using data, especially in arbitration context. People choose arbitration over litigation is because of the confidentiality. So and if the confidentiality is not being respected, I think people will turn around to litigation, and which concerns the institution a lot. I just want to address this.
So, and I have a slightly different view, especially in relation to the ISDS matter and the database, which is complete or not. And relatively speaking, compared with the commercial arbitration, international commercial arbitration, the many of the arbitral award was disclosed, and including each of the briefing argument or some other document, and so the big data has not have to be 100% perfect, so that we could use this kind of the big data for the analysis of the AI. And of course, the consequence could not be 100% reliable, but final decision should be, made by human being. So that it's a very useful tool, only just. And I think, I'm not hesitating to use AI because it's only just, from the viewpoint of the arbitrator, it's a tribunal secretary. And some tribunal secretary is a good one, and some are stupid, and it's on but anyway, selection of the tribunal secretary is the responsibility of me, arbitrator, and the top of the counsel team. So some associates are very good, but some are not. But the selection of these and try to encourage their diligent work, that is my responsibility at the top of the council team. So the AI is only just such kind of one. And of course, some people pointed out AI could be biased. but human beings also may be biased. And I cannot, to find your brain bias or not, but AI, we could at least, check the algorithm and which is a bias or not. So the compare with the human being and the AI, so I could not find any big serious difference. But I strongly recommend human being has to be a final decision maker because such arbitrator or some kind of the decision maker or mediator should be neutral and not biased and under the sanction. Unfortunately, AI cannot be sanctioned. So human being is the only one entity which has to be afraid of such kind of sanction. That's the reason why we need a human being.
Thank you. Very last question from Justice Knowles, please.
Just very briefly, so we grasp the scale of what we've got to address. If we say to ourselves there must be transparency and disclosure about the use of AI, would we really understand the answer if somebody says, yes, I've been using AI? Would we really understand what that meant? And our compass, yes, we must look at what the institutions are doing. Yes, we must look at what the mediators and arbitrators are doing, but we must understand what the parties are doing and the amount of use of AI already underway in preparing cross-examination, analyzing documentation is very substantial. It's a big compass, this.
Thank you. On that note, unfortunately, we have to wrap up. We're running very behind the schedule. I know that everyone has a lot of things to say, but as I suppose we can say that Jung next year policy dialogue will be on ODR and AI. So to be continued. So on that note, please join me in thank you, panelists and presenters. Thank you.
So thank you very much to all the panelists and presenters.
Thank you, Albert. Thank you. Thank you. Thank you.
Yeah, see you next year. See you next year.
Thank you very much. Thank you. It was very, very interesting to hear about AI and how it can be integrated into ADR. So let's now move to the last session for today, the closing session, titled From Dialogue to Action, Advancing Alternative Dispute Resolution Through Cooperation. During this session, we will share some practical insights on how to strengthen the use of ADR in cross-border trade. It is my pleasure to introduce the moderator for this session, Mr. Clark, General Counsel at the Asian Development Bank. In his role, Mr. Clark is responsible for driving legal strategy and engagement on regulatory and policy reforms to support ADB's mission of achieving a sustainable, prosperous, inclusive, and resilient Asia-Pacific region.
Thank you very much for that kind introduction. Now, I have a very difficult job here. I've got to make up a little bit of time, and I know we're at the end of day 2, but I've been very impressed that despite the intense schedule, despite the huge amount of energy that I've seen over the last 2 days, you still have it. And I don't see people, in any way sort of slacking off. But let's go the distance now. We're getting close to the final goal. So let me please invite up to the stage all of the members of this last closing session panel. It's really, I think, in a way, summing up a lot of what has been said to date and how we're actually going to move from dialogue, which has been critical to get us here, to action. And that's a lot of what our joint network is about. So could I please invite all of the panelists, I think you know who you are, to please come up to the stage. Thank you. Okay. Okay, sure. You're going to move me to the edge. Okay. Hopefully not over the edge, but okay. Right. I guess our 2 presenters will stay there and then present from there. Okay, fine. Okay. As you can see, we have a very prestigious panel here, and we're going to jump right into this once people are seated. Okay, excellent. Well, good afternoon, colleagues. Again, thank you very much, audience, for keeping your energy up. Now, I think we can say that over the last 2 days, we've had a really rich and practical discussion on some of the alternative dispute resolution methods that can support cross-border trade and investment across the region. Now, we've examined mediation, we've examined arbitration, we've even looked at some of the emerging hybrid models. And I think most importantly, we've made it really a focus to do it not as abstract concepts, but really as tools that when used efficiently, really have the ability to reduce friction, to preserve relationships, and to support the confidence that we all know is the secret sauce. That confidence is really what is going to boost regional economic integration and of course, the use of some of these tools. And I think, I don't know about you, but a central message that I think has emerged from a lot of these discussions is that, you know, ADR really doesn't get traction and advance through just isolated efforts. It's really, you know, it's these fragmented initiatives, the uneven institutional capacity, the lack of coordination that's the problem and continues to limit the full potential. And really, for cross-border disputes involving multiple legal systems, institutions, and public and private actors, there needs to be a holistic, you know, approach to this. And I think that's been coming out in some of the discussions. And it's really why I think this closing session today on cooperation and on moving from dialogue to action, that's really what the joint network that we'll talk about is all about, is so incredibly critical. So effective ADR ecosystems really require that states that are willing to enable its use and the institutions that are trusted and all of the international organizations that function really as enablers come together and help to align standards, to share best practices and experience, and really support the capacity building that we're doing. So against this whole backdrop, this clear need for coordination, I'm very, very proud to say that in partnership with ADBI and our ADB LPR program, we've been introducing the Asia Pacific ADR Joint Network. And it's really, you know, it's a name, it's a mouthful maybe, but it's a practical platform designed to respond to exactly these challenges. The network is really, it's not about bureaucracy. It's not about creating another layer of dialogue for dialogue's sake. Rather, it's about fostering coordination and really reducing duplication, whether it's through peer learning, whether it's through joint initiatives, whether it's through targeted support to real stakeholders on the ground that need it. So in this session, I really want to reflect on what cooperation should look like in practice, the institutional and operational constraints that may affect the good use of ADR, and how collective action through the joint network can help move the region forward. So we have a great panel here, but really to set us up, I think, and sort of cover the lay of the land and then launch into the discussions with the panelists, I want to ask and invite Dr. Byungsik Jung, our Deputy Dean of ADBI, and Christina Pak, my colleague in the Law and Policy Reform Program at the Office of General Counsel, to deliver a joint presentation that can set the stage for us. So let's start with you, Deputy Dean Byungsik. The floor is yours.
Thank you, Thomas. Okay, it's almost done. Be patient for a couple of minutes. Okay, actually, last year in February, we had the first policy dialogue on the ADR. After the meeting, OGC of ADB and ADBI, we got together and discussed about how to promote ADR in more systematic manner. At the time, we thought that this idea, ADR joint network framework, yeah, I can explain the detail why it is important to promote ADR more systematic in more systematic manner. Before that, we already, even though we discussed it in depth about the ADR atmosphere, let me respond to the first question. Some countries are curious why ADB and the ADBI, even though it's not an UNSTRA or ICSID, not judicial entity, why the Multilateral Development Bank or Multilateral Development Think Tank initiating this ADR joint network framework or promoting ADR? The answer is we are pursuing regional cooperation integration. Why regional cooperation integration is necessary? Because it's helpful for developing country to attract foreign direct investment and facilitate trade. That's the key reason why ADBI and ADB together are working together for these issues. For developing countries, they need foreign direct investment, trade, and ADR also necessary. But we understand developing country is not can afford to deal with the arbitration because it's so costly. It's almost equivalent to litigation. So for developing country, I think mediation is quite essential. But you know what? Mediation cannot stand alone. We already recognize that through the discussion. Even Judge Robin mentioned that without credible adjudicatory backstop like litigation or arbitration, I think very few disputing party have interest in mediation. So mediation should go together arbitration. As many panelists or participants mentioned that they are not rival. Indeed, they are partners. So today, you can recognize that we put some arbitration element in our 2 days dialogue because it's necessary. You have to know how arbitration is working. We have to figure out how to mediation, arbitration coexist together in an amicable way. So we recognize that the two dispute resolution systems coexist together. Then how to promote? That's our homework really. So we will display our strategy how to promote this ADR in Asia and the Pacific and beyond across the world. Okay. Probably some country already reached out bilaterally, ADB, ADBI, to ask them to join the ADR Joint Network Framework. Let me explain the structure of the ADR Joint Network Framework. The first executive committee, there is an executive committee, consists of selective countries. Just to understand, we select those countries candidate based on their economic size or geographical location and also potential of ADR market. So we approached a certain country, number of countries, and then some country already give some tentative approval, but some countries still under consideration. But I believe that soon they will join because as time passes, more and more countries are recognize the value of mediation and the ADR. So I think it's a time issue. And then we realize that actually in case of ASEAN, as I mentioned earlier, regional cooperation integration is quite important element from our perspective. The Secretariat of Regional Cooperation, Regional Economic Framework, Secretary is really play a critical role. So we are going to consider including the Secretariat, like ASEAN Secretariat, as a member of the Executive Committee. Another one, the Advisory Committee. Actually, ADBI is indeed, we are not a judicial entity. ICSID or USTRA is really, the bank of knowledge about ADR. So they should be stand by close to us. Otherwise, where can we get the expert? So we closely worked together. In fact, from the beginning, USTRA and ICSID. So naturally, we rely on their expert of the international standarding sector, like USTRA. So USTRA or ICSID could be our close partner as advisory members, advisory council. So we are thinking about establishing advisory council. And then still the developing members need as a capacity building or assistance. So of course, if they are developed, then they are capable to contribute financially, but still they need more assistance. Considering the element, we ADBI decided to remain as a secretariat. We will facilitate, we will support financially. So there is a very limited burden for executive committee. Why then executive committee is necessary? It's the government. It's not our international organization or advisory committee like UNSTRAL or ICSID. It's a government. It's a country which designed their policy, implemented the rules in their country. So country has a stakeholder. Like ADB, there's a board members. The country is really owner. So they idea, their consensus on the direction is quite important. So it's kind of executive committee is a head of our ADR joint network framework. Country is quite precious. And then under this, the management, there is a members. You might tell we selectively, we really selected very in a cautious manner, the representative of kind of ADR center for each countries. You know, there are many ADR organizations, institutions, centers in country. It's not easy to select a specific one, the organization. But since we started, we already cooperated with some the ADR center. Like we expected that one ADR center for one country. For one is for mediation, one is for arbitration. So in case of Singapore, it's quite easy. There's only two organizations, SIMC, SIAC. So no doubt about it. But in case of China, there are many organizations, many centers. In India, countless. And so in case of Korea, there is a KCF and then KIMC. It's a bit easy, but Japan, JIMC here, and then Japan, another arbitration center, so a bit easier compared to other countries. Malaysia, we invited there as AIIC. Yeah, they are representative. It means that partner, as a partner, we are going to work with the ADR centers. And then academia. Academia, even though there is some university, there are many universities, but some university has some capacity regarding the ADR. So we work together with the academia. And then business association. Why do we invite ICC? International Chamber, Commerce of Chamber is a client. They need to use this mediation, otherwise arbitration. Otherwise, there is no client. What's the matter, right? So we should work together. It means that they are stakeholders. They should go together, work together. Okay, now I'm going to show you what we have done so far and what we are going to do. The policy dialogue, you know what? We are human beings. All things comes from the ideas. The policymakers should get together and think about how we should go. That the idea comes from policy dialogue. Therefore, we host the first policy dialogue. It was quite successful. Building on that success, feedback, actually we developed that this, you can tell that if you look at the agenda, it's different from the previous agenda. This is the second time, the second policy dialogue, we incorporate the Singapore Convention, mediation in state-to-state disputes, and dispute prevention, and ISDS mediations, arbitration, and digital AI, using AI for the ADR. All things comes from the feedback, the first policy dialogue. Therefore, policy dialogue is quite important. You know what? Today, I got some idea. Next, for the policy dialogue, third policy dialogue, definitely we'll touch upon the digital. You know, digital, the using AI more and more. We will expand the discussion session regarding that issue because it's coming. And now we used that one. And then capacity building. Actually, we developed the e-learning course. You might have the experience of taking the course. We learned the cohort. It was so successful. You know what? 6 to 8 people registered that course. And then until last time, all 6 to 8 people remain. We had several follow-up sessions on live. The instructors really legendary people were instructors. All people attend, and they didn't leave until the finishing. It was so touching. I was about to cry at the time. And then we developed another second cohort. This time we added the arbitration element too. And Christina introduced a very famous lawyer, Gary. He's so busy, but he joined as an instructor for the arbitrations. This time we run the 6 the follow-up session. You know what? We didn't think about giving the certificate, but later on I decided. Actually, I took the mediation course in the very famous university, but I compared the contents. I can say our course seems to be better. So I decided, okay, they deserve to get the certificate. So we are going to give the certificate, but there is a condition. They should complete 8 modules and also should take 6 follow-up sessions out of 7. It's quite tough. But you know what? Around 70 people still remain. They are about to get the certificate. I'm very proud of them. And then we did, after this, the e-learning course, we did in-person education. It was so successful that we targeted government officer. Now we are going to expand to judge. Many panelists said that judges shouldn't aware. Yeah, we do. And also trainer, because we are limited. So we have to train the trainers, and that trainer will disseminate our knowledge to their country, for their countries. And then the legal reform. That's the really beauty of this ADR joint network framework and our the program. You know what? We love tangible thing. We don't like only discussion. If there's no result, I'm not going to touch it. There should be result. Let me explain one example. Introduce one example. ASEAN now they are trying to resolve their dispute by using the ADR. You know, we composed four distinguished experts, and then now we are providing technical assistance for ASEAN to develop operationalization of ADR guideline. It's really tangible. They are changing. And then another one. This example would be replicable to Central Asia. The Central Asia, they are starting the CATIF, correct trade investment facilitation framework. It's similar to the ASEAN. So ASEAN developed compared to Central Asia. So we'll reflect our TA to the Central Asia. And then last one, there is still some discussions. We talked about the mediation ISDS. There's a dormant some conciliation in ACIA, Asia Comprehensive Investment Agreement. The conciliation has been dormant. I'm going to wake up the conciliation by introducing the operationalization guideline on the conciliation in the ACIA. That's our world project. By the way, without OGC's technical assistance, we cannot move along. So now, from now on, I'm going to invite Christina. Christina will introduce really tangible TA for your benefit.
Many thanks, DD Jung. If that wasn't tangible enough, I don't know what more we can do. But I think the theme is really, greater impact through partnerships. So this is what, we're here the last 2 days, and also the joint network is about. So I think the next few slides, it's really about, like what's ahead. For the ADB, our Law and Policy Reform Program, we're basically here also to do consultations and for our next phase of our technical assistance. So from the beginning, dispute resolution really goes to the heart of, better investment climate and contract enforceability. So there's great demand from our client countries. So in the beginning, our Law and Policy Reform Program, we've been really focusing on, getting the last remaining specific states to sign on to the New York Convention, and then putting in place the implementing law. We're still doing a lot of it. A lot of the arbitration work is really modernizing the outdated arbitration law in line with the New York Convention. And then we moved on actually to FDI governance, really, the entire legal framework, including the international investment contracts. And then, so now we're in the process of developing a new technical assistance program. And we're basically in the formulation of our next phase, which has to be approved by the second quarter. It's really taking into consideration everything we've heard, and we've also been doing bilateral consultations with you. So this has been extremely helpful. I'll just go through, really, international mediation is an opportunity, and we've heard that from our client countries. So this could be, this will definitely be part of the next phase of the technical assistance. We'll continue to modernize the international commercial arbitration regime. And this is basically the conversation of today. We launched this FDI governance program because it's basically an ecosystem approach. that looks at the entire legal framework, including international investment contracts to investment treaties. And also we've been advising on national investment law, and they all actually, have parallels. There's sustainability elements, there's also carve outs, but also we're trying to foster, horizontal coherence, really the policy coherence, as well as the vertical institutional coherence. So we've been working with the government of Uzbekistan for the last 3 years on this, building off of our assisting them with the International Commercial Arbitration Act. And it was really the whole of government approach. I'm not going to repeat what we discussed, but it actually brought together 10 line ministries, including SOEs, to really talk about all the issues that we talked about. So this is an evolving program, and I from what I heard from today, it's definitely much needed. So maybe more of this. And then, of course, online dispute resolution. Actually, we have Claudia here. The backbone of the most Asia Pacific economies is the MSMEs, and they're riddled with small value disputes that impair their growth. So we've actually entered into a partnership with the ICC. They did a fantastic study on the economic value of low value disputes. And it's literally $1 trillion annually. So we're working with them to looking at sort of online dispute resolution for MSMEs for those low value disputes. So we're looking forward to that, but really focus on the MSMEs, the backbone of the economy. And then we've had this judicial capacity building program for over 10 years. And we have a partnership with Justice Knowles with SIFA. So this, obviously, judges are an important part. So this could be part of the technical assistance. So it's really, it's the entire ecosystem that we're working with that could be, that will be part of the technical assistance. What it looks like so we do the regional convening, and of course, the new technical assistance will support the Asia Pacific Joint Network. But what ADB does a lot of is work in country. So we'll work with selected countries along with all our partners on the legal reform part as well. So really all this requires collaboration. So we're really looking forward to hearing from the panel on really what the ADR framework and what ADB and ADBI's ADR program can do. So many thanks.
Thank you very much, Deputy Dean Byungsik and Christina, for that. I think what we just heard really underscores that the joint network is designed as a practical response to shared challenges, all the things we were talking about, fragmentation, uneven institutional capacity. But it also, I think, points to a shift in focus, and that's what I want to get into now. It's no longer about why does ADR matter? I mean, we all know why it matters. It's really about how do we actually move to operationalizing it and being very practical. So we need to look closely at how the cooperation is structured and operationalized, and how institutions move out of silos. I mean, I think some of the things I've been hearing the last couple of days indicate that there are a lot of silos, and everyone knows we have our solution. It's like a little bit of institutional rivalry can creep in, which is not good. So what we really need to do, I think, and what's critical, I hope, at today's panel is let's be candid, let's be practical. What do we need? With that, let me just move, and I am going to try to keep this snappy since we're a little bit behind. But the question really for the first round that I want to pose is how do you see the role and the added value of the ADR joint network in advancing the promotion and the effective use of ADR, particularly mediation, where we think there's a lot of, that's where a lot of the developing countries probably really need a lot of help, because this can be a lower cost, faster, more efficient, more in line with local norms and so forth. How do we get that effective use of ADR, particularly mediation, in cross-border commercial and investment disputes? And let me just go around. Maybe I'm not going to put you on the spot, Jose, but why don't we start with you?
Well, I think for our observation would be that while there are certainly efforts and the ADR joint network would be a big help, it still remains to be relatively fragmented among member states. And it would benefit from even greater cooperation. That would probably include a more structured and sustained cooperation approach among the member states and governments and other stakeholders, as well as supporting the gradual alignment of practices, promote the sharing of expertise, and encouraging more coherent regional approaches.
Thank you. Very important. Maybe let's go to Spark. Thanks.
Just briefly, I mean, although I'm representing a Korean institution, but this policy dialogue was a very good, I mean, great chance for me to see all the important figures and experts in ADR all over the world for 2 days. So I think this kind of dialogue, this kind of network are very much practically important. So I like the ADB and ADBI to hold this kind of gathering forever. Thank you.
Thank you. Right. Forever. Okay. We're going to have to really, like break for dinner or something. But okay. No, thank you very much. Situation Mongolia. What's your views? Thanks very much, Dashnam.
Thank you very much. We understand the importance of cooperation. From Mongolia's perspective, the ADR joint network plays a big role in strengthening the credibility, accessibility, and effectiveness of alternative dispute resolution, particularly mediation. I think that it serves as a platform for harmonization of legal frameworks and practices. Mongolia is in the process of aligning its mediation system with international instruments, such as the Singapore Convention on Mediation. The joint network can support this by facilitating the exchange of model laws, best practices, and implementation of experiences from more advanced jurisdictions. And also, the network adds value by building institutional and human capacity. Mediation is still developing compared to litigation and arbitration in Mongolia. Through joint training programs and knowledge sharing, we expect that the joint network will enhance the skills of mediators, judges, and legal practitioners, thereby increasing trust in mediation as a viable alternative dispute resolution. Thank you so much.
Thank you very much. Peter, why don't we jump over to you from sort of SCMC's perspective?
SCMC has had some experience trying to forge international cooperation in order to get onto a different level. So I don't think they were particularly successful. So I have an insight into why they weren't successful. So I don't want to name any names about.
Oh, come on.
But I want to share, the key things that came out of that experience and what we're looking the framework to do. First of all, it's to provide strong leadership, to have firstly a platform that integrates a whole range of committed mediation institutions together with a shared vision. And in that, to build trust in the entire commercial community and the investment community, we need to have uniform integrated standards, not just processes, but also for the mediators themselves. So that means to get away from, some institutions, they don't have a particularly developed mediation community. So to help pull them up and get them to the standard where they can participate in this framework. So the trust is very, very important. Secondly, the visibility, okay? It needs to be very visible. We've found that although we've collaborated with what seemed like high-profile institutions, the actual platform that we created wasn't visible enough. So that means, the communications and the marketing function has to be up there as well. So everybody knows about it. Okay. Thirdly, I think that there needs to be motivation, okay? Motivation of the mediators to participate, motivation of the institutions to participate. And that also means quite a bit of push from governments as well, not just pull, but push as well. So, you know, governments getting involved to be committed and integrated into the system as well. So they're pushing their institutions to participate. So to get over their own self-interests, because the self-interests get in the way. So there are three aspects that I think would really make a difference.
That's really helpful. Thank you. Anvar, over to you.
I think that the uniqueness of this platform, I mean network, is reducing fragmentation without creating a new layer of bureaucracy. And three functions stand out for me. First, a practice observatory. I mean, a standing place where we can see in something close to real time what is working, where, and why. Second, a capacity pipeline, a coordinated channel for DMC legal talent to train inside leading institutions, instead of every country negotiating the same bilateral arrangements in parallel. And third, convening neutrality, a venue where states, international organizations, and ADR institutions can sit at one table and just talk on practical questions without political overhang. And for mediation specifically, the network can be the place where questions of mediator qualification, Singapore Convention, enforceability model clauses and just all the structures are translated into shareable guidance.
No, thank you. I mean, from Uzbekistan's perspective, and of course, you know, we're looking forward to being there for our annual meeting in a couple of weeks. So you've really laid out three strong, I think, roles that can be played by the network, and that's something we're definitely going to want to internalize. So thank you very much, Chong-Wei, from the perspective of you know, your organization, which obviously has been at the center of this for a long while. Curious to get your thoughts.
Yeah, so I want to applaud ADB and ADBI for setting up this network. I've been doing mediation for a couple of years now, and I think this is the first time I see this synergy that has been put in place. We believe that in order for mediation to succeed, you need the judiciary, you need the government, you need the legal community, you need the business community, you need the centers. So it's really this five ecosystem working together that you can have a strong and sustainable development of mediation. And I think, in a sense, when you look at all the introduction by you know, Byungsik, you can see that it's all inclusive. And we have 16 countries, I believe, that's represented here, or at least. And we've been doing some work. We've done some work in Uzbekistan. We've done some work in Pakistan. But certainly, in many of these countries here, if we can work together in one place, I think that's going to be good. I mean, programs are great, but it's really the people that makes it work. Right. That's why network works. So I really want to endorse this and thank you for this.
Well, thank you, Jung, and that's a really good reminder of you know, the importance of, you know, people being, you know, the center of this as well as institutions. Terrific, Tezuka-sensei. I'd be curious to get, you know, your thoughts, obviously, from JMIC's perspective, and Japan having, you know, more of a obviously developed, you know, system, but you know, where you see some of the values of the network.
Thank you. JMC Kyoto is a small organization created around 7-8 years ago. But we pushed very hard the Japanese government to accede to the Singapore Convention earlier than later. And I'm very proud that Japan is now the first G7 country to ratify or accede to the convention. And during the legislative process, which I was involved as a member of the subcommittee member discussing the arbitration law reform as well as the Singapore Convention accession issue. There was a strange argument that Japan should intentionally try not to become a member state because the Japanese companies would be better off since there is no reciprocity reservation like new convention. So what would happen is that the Japanese companies may enforce the mediated settlement against Singaporean companies' Singapore assets as a member state, but the Japanese companies should not be need not be worried about enforcement against their assets in Japan. That is the very opportunistic free rider argument. I strongly oppose to that because the other party is clever enough to understand that if that is the case, there is no merit for the other party to agree to mediation if the other party is such an opportunistic country's party. So now they fully understand that the accession to the Singapore Convention is not for the benefit of the Japanese users, but the purpose is to promote the mediation globally. That is very important. So we have long time of deliberations on that issue, maybe more than 3 years. So I want to be able to share this kind of experiences through this newly established network so that the other states which have not yet ratified the convention would not spend time on such kind of opportunistic people, but rather I think we can share our experience. And one of the difficult issue is that the domestic mediation community strongly opposed to the idea of a default rule of enforceability. And we wanted to introduce the enforceability both to international and domestic cases. That is why we have selected to make the opt-in reservation, which was at the time a very minority position, maybe 2 other countries. Now I'm glad that we are 6. So I think we can share this kind of experience with the other countries where the domestic mediation community is not very supportive as to the convention. Thank you.
I mean, a couple of your comments are really fascinating. I mean, first of all, there's always the sort of opposition from. I mean, sometimes it's actually from courts or lawyers, because they think there's going to be a displacement of, their traditional function. But I'm really fascinated by your point about, what you call the opportunistic approach, or you could call it a transactional approach, because I mean, if at the end of the day people don't see the value of, promoting, arbitration and mediation, ADR generally, as for the system, that the systemic values, if it's always like, sort of game playing theory, like, is this going to benefit me or them? And so, yeah, I'll support it as long as it benefits me. But, if the balance goes the other way, then, I don't support it. I mean, that's sort of a self-contradiction. I mean, you have to be doing it because it's actually, good for the system. I mean, yes, we make the argument ourselves that it promotes FDI, it promotes foreign investment because, you think rules will be enforced. But it's not just for this group, right? It's for, the system, and that we believe that all boats will, sort of rise, so to speak, if there's a system in place that, allows faster, easier, cheaper. But when you get into is it going to benefit this group or that group? I mean, that's just a very difficult situation. So thank you for that perspective. Gloria, curious to get SIAC's view on all this.
Yeah. So I mean, I agree with a lot of what has already been said, so I will not repeat some of these points. But since I come from SIAC and we talk about arbitration, I think the interesting thing about having this network will be to see how the different ADR processes intersect to create more value for the users of the systems and the ADR systems that we have in all the countries. And I think it's about creating value. I do think that we will have to find some common vision. I'm very altruistic, so I do believe that we can find a value proposition that will work for everyone so that we can create a better environment for trade, a better environment, better procedures for the users. We have, by virtue of practice, divided arbitration as arbitration, mediation as mediation, litigation as litigation, and all. From, coming from Singapore, we have this notion of a suite of services. And actually for users, it's about what services would work and how they are strung together. And I think collaboration could help yield new solutions for people. So I think just something to open up our minds about the way we are also looking at ADR and dispute resolution processes as well.
Very helpful. Thank you. Thank you very, very much. So let me go to a second round of questions, a little bit more focused, and I'm going to, I think, direct this mainly to our government, panelists here, our government officials. What are the key expectations of your governments with respect to the joint network? And I guess if you could identify, what is the benefit? And there's been some allusions to this about, the certainty, I think about capacity building, but, identify what your key expectations are. And to what extent do you think your government would be willing to actively contribute to the network's development and activity? I'll let you define contribute the way you want, whether it's financial or time or policy, whatever. But yeah, so let's again start with you, Jose. Oh, I'm sorry. Yes. You know what? I'm sorry. Why don't could you hold just 1 second? That's my bad. I absolutely am amiss here for missing one of our very important Pui Ki Ta, Secretary General, KCAB. You're online. Can you hear us and see us all right?
Thank you. I'm actually not Ms. Ta. My name is Jung. I'm Senior Counsel of KCAB International.
Okay.
We had an unexpected commitment that arose that Ms. Ta had to excuse herself from this panel, but I am speaking on behalf of KCAB International. Thank you very much for reminding me. And thank you again, ADBI, for inviting KCAB International to this important discussion. So on to the moderator's first question. We believe that the ADR joint network would serve as an important platform for bridging fragmentation across jurisdictions and advancing a more cohesive ADR ecosystem in the Asia Pacific. As cross-border trade and investment continue to grow across the region, there is an increasing need for not only ADR mechanisms, but also a consistent and predictable dispute resolution ecosystem that can effectively support commercial activity over the long term. It is equally important to build user trust in ADR as a reliable and accessible tool across jurisdictions. This requires close collaboration, continuous communication, and sustained efforts to reduce complexity and lower barriers to entry, particularly for emerging industries and new users. And in this regard, we believe the ADR joint network would play a central role in advancing these efforts. This vision aligns with regional initiatives already underway, most notably the Asia Civil Law Summit launched by KCAB International in 2025. The ACLS brought together leading civil law-based institutions and arbitration practitioners from across Asia, the Middle East, and Europe. The Asia Civil Law Summit is a collaborative platform created to bring together civil law-based arbitration institutions to strengthen cooperation, share best practices, and promote the civil law tradition in international arbitration. Its purpose is to build a long-term framework for joint development, including harmonizing procedures, enhancing institutional capacity. The Asia Civil Law Summit was a success, bringing together over 250 participants and showing strong global interest in civil law's role in international arbitration. With distinguished speakers, representatives from 10 arbitral institutions, and support from 17 institutions worldwide, the summit highlighted a growing spirit of collaboration and community. I think this could be a good example of how we should proceed in our work forward together. Thank you very much.
Thank you very much, and it's a great reminder about that, very successful summit, and I think the joint network definitely can look to best practices like that, and use that in its activities. But thank you very much for that comment. Now let me go back to the government question and back to you. Thank you.
Yes, for goals, probably we can always say that broader objectives of enhancing trust, predictability, and efficiency in cross-border economic relations is still the primary goal for almost all of us. And how to achieve that? Activities like this, which promote great networking and capacity building activities, would something that would always come in mind. We can always share best practices. And it's nice to know that the Philippines, along with other countries, have started towards that goal. And it's also nice to share our best practices and get the best practices from the more advanced, those in the more advanced stages. So I guess that's it for the Philippines.
So from the Philippines perspective, would you be confident that there'd be willingness to contribute, again, like time and sort of bandwidth of people?
We can always support knowledge sharing activities,
right?
Fostering our network and promoting it as well.
That's terrific. Yeah.
And even other capacity building initiatives would come into mind. We can always share our own network with the rest of the team,
right,
to achieve that common goal.
No, that's how. And of course, the reason it's a network, is that we're really there to provide, sort of a convening function and a bridging. A lot of the substance, a lot of the ideas are going to be coming from you. So that's very encouraging to hear that you think there's a willingness to do that. Maybe just jumping to Mongolia, if you could. Maybe Dashma, give us a sense of where you think the level of support would be from your government.
Mongolia is, as I mentioned before, we are expecting technical support and guidance, also knowledge sharing, best practices. However, yesterday's policy dialogue, I explained it Mongolia's mediation challenges. We have still facing domestic legislation challenges. We have to aligning it with in order to sending Singapore Convention. So for the contribution part, I feel like we can only contribute by sharing our ongoing reforms and participating projects and initiatives. But maybe in after 10 years, we can contribute more like a policy part, or we can share our best practices. For the time being, we have to focus on our Mongolian legislation and learn from other countries, other best practices. Thank you.
Thanks. I guess my only comment would be that that's really helpful, but I wouldn't undersell the value to others, even of your challenges. It's not only the best practices, but it's what are the challenges? Because I would bet that a lot of other countries, a lot of other developed countries, are going to have those same challenges. So I would define contribution broadly to include your experience of dealing with those challenges and just making the time available to discuss them. Sort of what worked for you and in overcoming some of those, because even if not the exact same thing, analogous challenges may exist with local laws and obstacles in other countries. So it's something where I think sharing challenges as well as best practices can be helpful. But thank you very much for that. Something definitely want to stay in dialogue on. And then I guess, Anvar, going over to, Uzbekistan, maybe you could give us a sense of your expectations and likelihood of support.
Yeah, of course. From Uzbekistan perspective, I want to mention several expectations. First of all, is standing thematic working groups on DMC ICDS management capacity. I think this is the area where the gap between the regional frontier and the regional floor is widest. So second one is a dedicated work stream on Singapore Convention implementation in Asia, including a regional readiness diagnostic. Next is practice library of working model clauses, institutional rules, and pre-arbitration protocols that members can adapt. And I can mention about annual policy dialogue, which will be held in Uzbekistan on May. So Uzbekistan willing to contribute to hosting, being executive committee membership, and also second Uzbek legal specialist into network activities and commit staff time to any working group on ICDS and management or Singapore Convention readiness. So I can say that Uzbekistan not want to just want to be a beneficiary, but we are want to be a contribute and work in a partnership.
Thank you very much. And again, we're looking forward to, I think those activities coming up in May, and certainly, serving on the executive committee would be, something that really will, cement involvement. We need to have leadership by, the countries, sort of on the ground with very practical, hands-on, just commitment of time. And again, this is a lot of time and experience sharing. And I think you've given us some really good practical ideas, obviously around things like, the library and things like, putting together, materials that will be, helpful and be able to be leveraged. So those are great ideas. Thank you. Thank you very much. Let me jump.
Moderate.
Yes,
may I
please.
interrupt?
Of course. You're not from a government, but that's okay.
No.
Yeah.
No. I'm a private person. Could you allow me to ask a question to the president of the ICC, International Court of Arbitration? Because
Absolutely. Yes.
There is one system where two functions, arbitration and mediation, under one roof. And there is another system. Each system has its own roof, mediation or arbitration. So I like to hear your, idea why in the ICC you have arbitration function and also the other, including mediation functions.
Thank you. I'm glad to share. In essence, the International Chamber of Commerce is focused on ensuring that parties, whether they are in the private sector, whether they are states or state entities, have all of the tools in the toolbox to resolve their disputes. So the International ADR Center provides a variety of tools for the parties to resolve their disputes amicably. And of course, if they're not able to do that, then it can be resolved through arbitration. So it is, I like how you've described it. It is all in one house, but very separate rooms with a very, very strict wall. Because the International Court of Arbitration does not have access to any information involving the cases that are administered by the ADR Center. And likewise, the ADR Center doesn't have access to any information of the cases administered at the ICC court. And the only information that would be shared would be in the context of fees, because if a party is in arbitration and then using mediation, then there's a way in which the fees are reduced for the overall resolution of the dispute. And so it really, the reason we have it that way is to fulfill our broader mission of trying to provide dispute resolution services more generally.
Thanks, Claudia. No, that's good. And it's actually your question. I mean, it was a good one. Your answer was a good one, and it's a good segue actually to what I was going to have as the third round, which is really focusing on the ADR institutions here. And I think thinking about it, I mean, the question comes up of we have a number of institutions. How can these ADR institutions, and I just ask you to jump in as well, Claudia, along with the others, but how can these institutions, from the region or globally, really collaborate through or alongside with the joint network? Because this has got to be a very cooperative effort to support more coordinated and practical implementation, of the ADR initiative, drawing on your own experience. So maybe let me just reverse the order, I guess, and go back. Maybe just start, Tezuka-san, your thoughts.
Thank you very much. I think we could contribute to sharing the success stories, and which includes some practical tips or creative thinking ideas, so as to cope with the possible negative attitudes towards agreeing to mediation, because it may end up with just a waste of time and cost. And for example, we have an SIMC JMC joint protocol, and which JMC nominates one mediator, possibly Japanese, where Japanese party is involved, and SMC will nominate another mediator, two mediators panel. And we had a very successful two mediator panel mediation. That was our case number one case. And so unlike arbitration, two-member panel may work, and the parties do not have to debate on who is the best sole mediator, but they feel more comfortable to have two people. And also in one case where there are very complicated factual issues, and the counsels from both sides agreed to introduce some kind of mini discovery, not a US style discovery, but just up to two witnesses from each for just 1 day deposition on a very specified issue, and also a very narrow document production, so that both parties as well as the mediators will have a better idea of that most important issues, which made the mediation easier.
Right.
And also the final one is what I did in a very complicated mediation where I was an ad hoc sole mediator. I asked the parties agree to have two experts, maybe one each have some closer relationship with one of the parties. So I didn't try to select only one, but the two made experts on a particular issue. And then I had so-called not hot tubbing, but the warm tubbing. No cross-examination. Both of you are not the representative or party expert, but you are my expert, and try to find out why your views or calculations are different. And if there is any room to agree, then please let me know, which worked very well. So this kind of a creative solution should be shared. And I want to learn a lot from other institutions and other countries' success story.
No, that's exactly the kind of learning and sharing we need to be doing. Thanks. Let me just jump, Tron Wee, to you for a second.
Yeah, sure. So I think there are a couple of ways in which we'll be very happy to support and contribute and learn as well. One that comes straight to mind is capacity building. We've done that around the world. We've done it with 20 over countries over the last couple of years. It's always difficult to access the right people when it comes to capacity building. And we want the right people because they are the ones who can really further both the use of mediation and to be very good mediators down the road. And so we pre-select a lot of these experienced arbitrators, lawyers involved in international trade, practitioners, they could be engineers, etc. So we have those programs, and I think this is one where if we can have a combination, and we've done it before with judges, with MNC, general counsel, leading lawyers in the same room, you actually create a very good ecosystem to then promote mediation from there. So this would be one where I think together with the rest of us here, we can pull together the right group of people from government, from judiciary, so that we all can learn from each other. And then from there, you build more sustainable growth of mediation. The capacity building comes to mind straight away. The second one is, to me, is the signing of the convention. We've been talking to different governments about signing of the convention. That's one way in which I think we can collaborate. We had the honor of meeting the Minister of Justice from Uzbekistan in my last visit a month ago. He's very supportive, and I think that's what we can try to collaborate with for the signing of the convention, and any follow-up action after that that was mentioned. And the third, I think, is really about how thinking about policy and what the next step is. So I know we're all very excited about AI. That's one area in which we've been developing for a number of years. We call it Maya, Mediation AI Assistant, as a way to support mediation. We think that there is a lot of opportunity there because unlike arbitration and litigation, the AI actually doesn't decide, but it can provide a range of options and possibilities to help the mediator to find a solution. And this is, I think, important for disputes involving ISDS, state-owned enterprise, where they need something to hang on to say, yeah, this is kind of where the range is going to be. And of course, AI today may not be able to achieve that, but I think in the next couple of years, as AI improve, I think we want to be ready for it.
We need to be thinking about it.
We need to be thinking and ready for it when it comes. That's what I think we can do, be very progressive, be cutting edge to see what AI can do to help even before it hits us.
Thanks a lot, Sean. I appreciate it. We're going to just really go lightning now. Let me come back to you, Gloria, and get your comments. Thanks.
Yeah, so I mean, just to add to what Wee-Ming said, I think it's going to be useful to have this platform for sharing, and just like the question Professor Park posed just now, it's useful to have a place where we can have comparative models, where we can see how different ways of organizing ADR work in different systems, such as, in Singapore, we have separate, mediation, arbitration, litigation, and it allows for a different kind of cross-pollination of processes. So SIMC has a joint protocol, with JIMC, SIAC and SIMC have an ARP-MED-ARP protocol. There are different ways in which we can organize ourselves, and I think this group will really enrich that discourse on how more we can do, can design ADR to kind of mix and match the different elements in each of the systems we're working in.
Terrific, terrific. Peter.
Thanks. We want it to be dynamic, and that captures everything that's said. But what I mean by dynamism is, firstly, to have at least monthly interaction, highly structured interaction online through all the different points of contact, but getting the mediators online so they're interacting on a monthly basis, 6 monthly basis, having some sort of in-person event, okay? And thirdly, because we'll be seeing each other more often, there'll be a whole lot more ideas generated. So to have a sort of a clearinghouse through which we can funnel the ideas, they'll be processed and then shared so that we could actually build that into the capacity building, processes building, and to that whole agenda, so they won't be lost, and it will be actually integrated into the very intertwined platform that we want to set up, that we want you to set up for us. Thank you.
I think that's a good observation. I mean, we certainly hope that this, convening power is going to be used to get more ideas, more volume, but along with that is the need to capture that and make sure that, we're getting that feedback, internalizing. Let me just jump over to KCAB for a minute. Just your thoughts on how you can contribute to this or what you're looking for in the joint network.
Thank you very much. I think I echo all the comments made by my co-panelists and the previous remarks, and all the points that I wanted to make were already mentioned, so I'll be very brief. So I think what is the most important is to deliver tangible outcomes beyond any of the dialogues or policy considerations. So for instance, and in particular, we would value the development of coordinated frameworks, best practice guidelines, and interoperable mechanisms that can facilitate the effective use of ADR in cross-border disputes. We may consider what would be the best way forward in the coming days. KCAB International would particularly welcome the opportunities to collaborate in capacity building initiatives. And given our experience in hosting training programs, we see strong potential for joint training initiatives for users and practitioners across the Asia Pacific region. For your information, we're hosting an arbitrator training program every August after the Singapore Convention Week. And it seems like it turned out to be a great success. So this can be a good example that we can consider. Also, I mentioned about the Asia Civil Law Summit, and we may also consider hosting joint panel sessions. And we think that it's very important, as my previous co-panelists have mentioned, it's really important to make the opportunity to meet together and share our thoughts and the way forward together. So there may be various ways forward, but what is more important is that we gather together and make the opportunities to gather and discuss on our way forward. Thank you very much.
No, thank you. And that's a comment that I'm hearing, again and again, the importance of, meeting and sustaining, not just the dialogue, but sustaining the action plans. I think I'm going to leave the last word to you, Claudia, after hearing all of this, but Professor Park, maybe just to come back and get your thoughts on expectations and what we can do.
I may be wrong, but institutionally, I think it might be, possible, the cooperation between the different institutions in different countries, because, for example, there is a case between Korean company and the Chinese company, then which mediation center will deal with the mediation service. But nevertheless, my center has partnerships with two mediation centers, like the Shanghai Commercial Mediation Center and the mediation team under the Vietnam International Arbitration Center. And then fortunately, for example, each side hold a seminar explaining what Singapore Convention meant for businesses. Then the other party was invited to explain about their service or their existence. And also, personally, I think there is more importance of the close cooperation between Korea, Japan, China. So we have been holding the so-called China, Japan, Korea, the international mediation experts meeting. So we are going to keep this cooperation.
Thank you. Thank you very much, Professor Park. And Claudia, I mean, you've got 100 years of history here, maybe additional perspectives, but over to you.
Let me offer you a few points. One is rising from my experience as a practitioner, which is in a context of a stage full of our mediation institutions. I will say this. For sophisticated parties, you do not actually need a mediation institution to mediate. And so I believe globally, we do not necessarily know how many mediations are taking place by virtue of adding up how many mediations are at institutions. Because in my practice, if the parties or the lawyers proposed arbitration, mediation, and you could reach an agreement on who the mediator would be, then the mediation can proceed and no institution is needed at all. You only need to go to a mediation institution in those instances when the parties can't agree on who the mediator should be, and then you need to go to the institution, or there's a requirement within the contract to go to mediation, and then you initiate the dispute resolution process through that filing. So from a government perspective and from those who are really advocating for ADR, I think you can also be thinking about the ways in which you can educate the parties themselves, the business community, those who are involved in disputes with education and commitment to mediate. One of the things that did take place in the US that really shifted the culture around the use of ADR was basically getting the major businesses in the country to pledge that they would at least consider mediation before arbitration or litigation. And so those pledges around the utilization and commitment to those internal policies become a great driver. Lastly, I would just say, I think what I hear around the world are the various hurdles to utilizing mediation. And I think what ADB could really do is focus on understanding what are the hurdles to parties utilizing mediation. Maybe it's a lack of knowledge. Maybe it's a lack of view, like a view that it is a waste of time and money. But one key piece that I have significantly heard is that the notion that a settlement discussion would be, quote, without prejudice is not actually recognized in many countries around the world. And so that may be legislation or other types of things that would be needed. Or the question is, can you just contract by a mediation agreement that it is without prejudice, and therefore people would be free and feel confident in exchanging these types of things, and it would not be used. To me, that's, from what I believe, is one of the key hurdles to the use. And so that's where I really think ADBI could be really instrumental in fostering the utilization of mediation. We know that you do not have to have a treaty to use mediation. You do not have to have law in your country to allow parties to reach a resolution of their dispute. You do not have to have an institution, but institutions can be fostering all the other things. And so I think that would really be kind of thinking about what are the hurdles and how can you actually foster the utilization of these of this mechanism.
Yeah, thank you, Claudia. Those are really important perspectives. And I think at the beginning, you make a very important point, which is we do have to distinguish between sophisticated parties and unsophisticated parties. And of course, in a lot of our developing member countries, the use of, mediation and its, sort of, global form is a little bit behind, but, the institution could certainly play a role there as kind of the default when they don't have the familiarity, or maybe they haven't even agreed because they don't know, like, what are the benefits, what are the disadvantages. But, over time, as their familiarity gets greater, maybe that need for institutions will recede, but there's certainly an educational role they need to play in, what we might call the transitional, period to get to that. And thank you for your comments about maybe where ADB can play a role. I think ADB and ADBI can certainly play a role that's, educational and, building the consensus. And maybe in the interim, there is a role for law to sort of facilitate, or at least take out some of the negative hurdles like, this, a sense that, oh, maybe it will be with prejudice, and, provide some safe harbors or sort of, statutory provisions like that are helpful. Very interesting. Okay, I've tried to make up some time. I think we've made up a little bit of time since we started 15 minutes late, and we're kind of at time now, but I would be remiss if I didn't at least give a brief chance to our very patient and very hardworking and well-listening audience out there. If there's maybe one or two burning questions for any of the panelists here, please raise your hand, please.
So I think this is something that UNCITRAL should have been doing because we're supposed to be providing the technical assistance and capacity building. But what we have not been able to do, and what I'm hoping that the joint network can do, is actually have some consolidated informations about tracking the reforms that are taking place. We know we've heard from Uzbekistan, we've heard from PNG what's going on. We meet every year to track them, but there is no tracker where that information is stored. As a UN body, it's difficult for actually us to manage that because it's sometimes government information, but it would be good if the joint network actually keeps track of that information of where you are with arbitrations, where you are with mediations, where you are with the institution building, how many cases you handle. If there is that consolidated information, I think it will be a good, I'm not dumping it on you, but it's probably something that UNCITRAL should have done, but it would be something that would be very useful.
That wasn't a question, that was a comment. But it was such a good comment that I think we're going to allow it and actually take it into account because you're absolutely right. It's I think it dovetails with what we've heard a lot about. One role here being the information gathering and sharing, convening. One last chance. Anyone with a question going once, going twice? Okay, we're at the end of a long day. I'm going to be super brief here, but I'm looking at. There's a lot of thoughts I've scribbled down. I guess. I think there's some consistent messages that are coming out. First of all, I think there is alignment around, the value. I mean, potential value. I'd go out on a limb and actually say I think the perceived value that the network can play as a regional platform to help connect what are currently fragmented efforts. And we've talked about how that connection can happen. It could be information connection. It could be capacity building. You talk about, libraries. I mean, the comment, just now on, when we get together, are we actually preserving that information? There's a lot that can be done. Claudia, I think your, comments about where, ADB, and its role in the network can really be to help, clear the path. Maybe there are some, legal issues that, we need to deal with. Sharing experience, improving coherence, supporting sort of more consistent use of ADR. All of those are things that I think there's a broad conception the network can play a role. Second, I think this goes to the comments from our government colleagues in particular. We heard there are clear expectations, and if those expectations can be met, and I think if we can convince our government, partners that yes, we can actually play a role in meeting those expectations, whether it's around capacity building, whether it's around information sharing, whether it's, support, including with, TAs from ADB or, other things, that then you actually will be willing to sort of like support yourself, whether it's financially in the long run or just in the short run with sharing your own experiences and sharing the challenges, like the example from Mongolia. I think those are important as well. And I think supporting capacity building, policy coherence, and especially in situations where cross-border disputes intersect with investment, trade, and public interest. Those are all things that you've discussed you would be looking for and would be willing to support. And then maybe third and last, I would say from the institutions, and we have so many of them here from around the region, that I think I heard a pretty strong call for collaboration over competition. No one, I think, said, "Oh, our approach is better, our institution is better." Maybe you wanted to say that, but you refrained, and that's good. But seriously, I mean, I think what I heard was the need for a lot of collaboration, because we can't go back to the fragmented, silo. Let's have, 10 different, inconsistent approaches. That's just not going to work. And I think most of you highlighted some practical areas for cooperation, things like joint training, things like sharing of best practices, maybe referral and cooperation agreements, libraries. And I think, again, particularly businesses and investors who don't yet fully understand or utilize ADR, they need to be brought up to speed, and we can play an educational role in all that. So let me just close by sincerely thanking all of our panelists here, and I include, of course, our presenters, Deputy Dean Byungsik and Assistant General Counsel Christina, you led us off at the beginning, and I think the panel responded, very well with some great ideas. And it's really set the stage for the discussion here in a way that it's helped us clearly and compellingly, I think, articulate a vision for the joint networks work to be done. We have a lot to do, but your contributions have been central to moving this really from just a conversation and dialogue, which were, of course, necessary but not sufficient, to action, which is really the next step. So thank you all for your engagement. You're going to be hearing more from us. There's going to be more to come. And just thank you all for helping us really lay the groundwork for stronger cooperation on ADR. I think this is going places fast, and I just want to thank all of you. Please, for the panel and for the presenters, and I include you, Claudia, thank you for jumping in at the end. And for all of you in the audience, let's give ourselves a big round of applause.
Thank you very much to all the presenters and panelists and moderator for this amazing closing session that is very promising and inspiring for the future. So with this, the second day of the Alternative Dispute Resolution Policy Dialogue has come to an end. So before leaving, I would like to invite Deputy Dean Byungsik Jung to deliver the closing remarks for today.
Are you tired? Thank you so much. Okay, give me 7 minutes, okay? Over the past 2 days, we have shared, indeed, very rich dialogue. I hope you share my sense of satisfactions, not only the depths of discussion, but also the sense of direction that has emerged. We did not exchange simply dialogue. We clarified what matters and what needs to be done to promote ADR. We reviewed the progress of the Singapore Convention, and we heard very encouraging news that countries like Korea and Malaysia are moving toward ratification. It's not just simply a legal step, but it's a signal of commitment to amicable dispute resolutions. But we asked ourselves the fundamental questions: how do we encourage practitioners and mediations? The incentives, as someone presented, incentive for lawyers and active participation of experienced mediators, and the mandatory mediation have all to play. But above all, the truly matter is mindset. Practitioners should recognize the value of negotiation and mediation as tools for creative dispute resolution and for preserving good relationships. We also explored the role of mediation beyond commercial disputes, including state disputes. The operationalization of ADR on the ASEAN agreement in goods has potential to become a historic example that bilateral and multilateral trade agreements around the world will look to and learn from. The ADB and ADBI will continue to support ASEAN as it works to resolve the pending 6 cases through credible and workable, very clear ADR guidelines. We agreed that dispute prevention is far better than dispute resolution. Effective communication with the foreign investors and all your attention to grievance is really powerful forms of mediation in themselves. Prevention is not passive. Prevention is proactive, it's strategic, and more humane. Thank you so much for your exchanging experience and best practice in this regard. Mediation also has a role to play, critical role to play, even in state investor disputes. The statistics of ICSID shows that roughly around 30% or 60% is arbitration cases are resolved through the means other than arbitral awards. That tells us something important. In the most complex and adversarial setting, still there is a room for dialogue and resolution. At the same time, we should not undermine arbitrations. In many cases, the very existence of arbitration creates the condition that make mediation possible. In this sense, mediation and arbitration are not rivals. They are partners. They formed a balanced and effective dispute resolution ecosystem. I believe that after 2 days dialogue, we can say with confidence, ADR matters. We have a greater certainty on what needs to be done to promote ADR. First, ratify Singapore Convention. As many countries join, the enforceability and credibility of a mediated settlement will grow. Second, embrace mediation before, during, even after arbitrations. Compromise when chosen freely often serves human disputes better than judicial decisions. Third, most important, we should work together across the borders and institutions and professions to achieve this very important goal to promote ADR. ADBI, ADB, ADB, and ADBI will remain firmly committed to supporting the promotion of ADR across Asia and the Pacific and beyond. The ADR Joint Network Framework is not just a simply institutional arrangement. It's a shared commitment to make the world a better place. Before closing, I would like to invite you to join me in expressing my sincere gratitude to those who make this event possible. Thomas, Christina, and even though unseen, the ADB team, and Derek, Ben, our task manager, Ben, the Songwa, the Derek, Rachizia, and Minako-san, Kochie-san, Rapi, and Yoko-san. Your dedication and hard work make our dialogue possible. Thank you so much. Already you gave the warm remarks, okay. Thank you once again to your insight and your openness and your commitment. I wish you have a safe trip home. And also I hope the spirit of collaboration we built here will travel with you. So long. Thank you so much.
So thank you everyone once again for your participation. May I ask you please a few minutes to complete our post-event survey. There is the QR code on the screen. Please, if you can fill it out, it helps us improve our capacity building activities. If you're joining tomorrow's session, you don't have to fill it out right now, so you can do it tomorrow. But for those that are leaving us, then please do so. Thank you.
Right.